house. 20. The corpus delicti. The trial began on Monday, July 20th, much like the jury selection process had ended, with more motions presented by the defense. Neil Fink moved that the testimony of Diana Joan Goshi and Patricia Spaulding be suppressed as tainted witnesses. They were shown photographs of Collins twice by police before the lineup where they identified Collins. Fink believed showing the wig shop ladies the photographs clearly violated his defendant's right to counsel. When Spaulding was asked if the defendant's attorney was present at the lineup, she said no. A defense motion attacking the legality of the lineup was denied by Judge Conlon, who said the lineup was conducted in accordance with the law. During the previous week's hearing, John Collins' first attorney, Robert Francis, no longer representing Collins, told the judge he was at the police station and saw the witnesses going to the lineup viewing window. He also saw the lineup forming outside the room. Francis said he was aware of the lineup, but never officially informed it was about to start. The judge overruled the defense objection. The third defense motion was to suppress scientific testimony concerning the identification of human hair found on Beineman's body that she may have obtained at the alleged murder site. Judge Conlon denied the motion. In a defense attempt to undermine the police early in the case, Neil Fink complained to Judge Conlon about 2 instances of police interference. Ann Arbor Police Sergeant William Canada was accused of pulling defense witness Donald Kaufman out of a bar, putting him in the back of a squad car, and threatening him with perjury if he falsely testified in this case. Then, Neil Fink told the judge that State Police Sergeant David Like, John Collins' uncle by marriage, has been an obstructionist in this case from the very beginning. Fink wanted to depict Sergeant Like as a hostile witness. He wanted it to appear in the court record that Like refused the defense access to the alleged scene of the crime, the Like basement, and he refused to tell the defense the blood type groupings of his family. What Fink did not mention in court was that Like did allow a defense investigator into the basement to collect forensic samples for their expert in Boston. Once Fink finished, the judge called for a mid-morning recess. When the trial resumed, the courtroom was crowded with news personnel from all over the country. Finally, the moment arrived when Prosecutor William Delhey would begin his opening statement and address the jury. In a strong baritone voice, Delhey told the jury the county would prove without a reasonable doubt that John Norman Collins is guilty of the murder of Karen Sue Beineman on July 23, 1969. After a description of the crime, he continued by saying the prosecution would show John Norman Collins was in the area at the same time Beineman disappeared. He was the driver of the motorcycle on which the Grand Rapids girl was last seen, and Karen Sue Beineman was slain in the house of State Policeman David Like, who gave access to his home to his nephew John Norman Collins while Officer Like and his family were on vacation. Neil Fink handled the opening remarks for the defense. Addressing the jury, he agreed with the prosecution that Beineman's body was degraded to a point almost beyond human comprehension. But the prosecution has forged a chain of circumstantial evidence, and as such, this case is no stronger than its weakest link. Fink told the jury 2 prosecution witnesses would testify they saw Beineman ride off with Collins, but both ladies wear corrective glasses, and neither was wearing them at the time. Neil Fink was attempting to impugn testimony not yet given, but he was permitted to press on. Fink added, "The defense will produce witnesses who will provide an alibi for Collins during the critical 3-hour window from Miss Beineman's disappearance until her digestive tract shut down. We will also present expert scientific witnesses to refute the hair fiber neutron analysis evidence we expect the prosecution to present. After listening to the testimony in this case, you will have serious doubt, and with the fidelity of your oaths, you will return a verdict of not guilty." Delhi called the first witness for the prosecution, Washtenaw County Deputy Chief Medical Examiner Dr. Craig R. Barlow. Dr. Barlow began by showing and describing color photographs of Beineman's battered body, including close-up photos of her face, her broken tooth, strangulation marks around her neck, chemical burns on her chest area, and abrasion marks on her wrists and ankles. These exhibits made for grim viewing for the jury, especially the women. The photo exhibits were entered into evidence. Dr. Barlow testified he arrived at the body drop location on Riverside Drive in Ann Arbor Township at 6:30 p.m. on Saturday, July 26th. He said it was obvious the body had been there for some time due to the decomposition that had already begun. There are definite ligature marks on her wrists, ankles, and neck, plus blows to the head and chest with marks on her breasts and arms. On cross-examination, the medical examiner told Joseph Louisel he found no fibers on the neck, wrists, or ankles to indicate what was used to beat the young woman. But in his medical opinion, the body could have been in another location prior to being found on Riverside Drive at least 24 hours, maybe longer. The rest of the session was taken up by court business and settling the jury into their hotel accommodations at the Campus Inn, which was only several short blocks from the Washtenaw County Courthouse. An entire upper floor was dedicated to their sequestration until the end of the trial. 3 county deputies were stationed as around-the-clock security, one at the elevator door and the others at each end of the floor guarding the stairwells. The jurors were provided with room service privileges and a fully stocked bar with hotel staff on call, all courtesy of the taxpayers of Washtenaw County. On Tuesday, August 21st, Judge Conlon's ban on photographs taken on the second floor of the courthouse was broken by an Ypsilanti Press staff photographer. Sheriff Harvey was caught on camera wheeling himself into the courtroom with his left leg in a hip-to-toe plaster cast propped up on a wheelchair leg rest. Sheriff Harvey and his son were in a motorcycle accident on Interstate 94 the month before, when he ran his new Harley into the back wheels of a semi-truck. The second-floor courtroom photograph made it into the evening edition of the Ypsilanti Press, despite the judge's ban. On the second day of the trial, the prosecution called only 4 witnesses, and direct testimony lasted 3.5 hours. The first 2 witnesses were Beineman's Downing Hall roommates, Sherry Green and Kay-Ann Knowles. They were separately called to testify. They shared room 302 with Karen Sue for the summer session at Eastern Michigan. Both girls gave an account of the last time they saw Karen that was virtually identical. The young co-eds told how they went to lunch at the dining commons at about noon on July 23, 1969. Green said she had swapped her lunch of a hot dog and watermelon with Beineman, who had ordered a salad. Karen also ate a few corn chips and an ice cream bar, and drank an orange drink. This testimony laid the groundwork for the medical examiner to determine the time of Beineman's death from the contents of Karen's stomach. Knowles testified the 3 roommates returned to room 302 when Karen said she had plans to go downtown to pick up a wiglet she had ordered the day before. Karen asked if I would walk with her, but I had an afternoon class and had to study for a test, so Karen left Downing on foot at about 12:30. Delhi asked each girl individually, "When did you see her again?" Both young women gave the identical response. "I didn't." Upon cross-examination, Joseph Louisel asked each of the co-eds if they were shown underclothing of the victim by investigating police officers. They both answered no. Louisel asked where Beineman washed her undergarments. They responded that she washed them by hand in the bathroom sink and hung them on a drying rack in their room. The crafty lawyer asked if Beineman used an electric shaver on her legs in their room. Neither co-ed knew if Karen owned an electric shaver or used it to shave her legs. Knowles did say she knew Karen trimmed her bangs in their room. Not wanting to appear unsympathetic to the uncomfortable witness, Louisel thanked Knowles and told the judge, "No further questions, Your Honor." The next prosecution witness called was Dr. Conrad Mason, a University of Michigan physicist in aerospace engineering. He told Prosecutor Delhi, under direct examination, that he and his wife were walking along Riverside Drive in Ann Arbor Township to retrieve their mail. He glanced down a shallow wooded ravine and saw the naked body of a female lying face down. That was about 4 p.m. on Saturday, July 26th. The body had only a pair of sandals on her feet, Dr. Mason testified. I said to my wife, "Oh my God, look!" Then they ran up the street to their home at 3640 East Huron River Drive and called the county sheriff's office. The first officer on the scene was Sheriff Douglas Harvey. Soon, the Mason home became a beehive of law enforcement activity. In addition to county police, also arriving on the scene were the Ann Arbor Police, the state police, and the prosecutor with his chief assistant prosecutor. Under cross-examination by Joseph Louisel, Dr. Mason said he was asked by police not to disclose to anyone the finding of the unidentified body. Dr. Mason told of the plan to replace the body with a mannequin that prosecutors Delhi and Williams borrowed from JCPenney at the Arborland Mall. Dr. Mason testified he was told officers would be hidden strategically around the area during the night. And, of course, it rained terribly that evening. Dr. Mason told the court the police used his screened-in porch as a field headquarters. At about 2 a.m., 2 sheriff's deputies knocked on the door and asked to use the phone. One of the officers told Dr. Mason their walkie-talkies were not working. The other officer called the task force at the Holy Ghost Father Seminary barely a mile away. "We've had a contact," Dr. Mason heard the officer say. The fourth and final witness scheduled for the day was Washtenaw County Sheriff Douglas J. Harvey. He had signed the original criminal complaint against John Collins. Wheelchair-bound, Sheriff Harvey was helped to the stand by one of Collins' guards, Sheriff's Deputy Roy Couch. Sheriff Harvey told the court that after the call came in from Dr. Mason, he rushed out to Riverside Drive and was the first person on the scene. He viewed the body from the road above the gully and asked to use Dr. Mason's home phone. The sheriff did not want a report of this to go out on police band radio that some snot-nosed reporter could pick up. John Cobb of the Ypsilanti Press had a police band radio in his car and often showed up at the crime scenes ahead of the police. Harvey's first call was to the Michigan State Police Crime Lab in Plymouth. Next, he notified prosecutors Delhi and Williams. Finally, he called the deputy medical examiner, Dr. Craig Barlow. By then, sheriff's deputies had secured the secluded area. After the crime laboratory team made their preliminary inspection of the body, Sheriff Harvey explained to the court how he and the prosecutors walked down the steep incline to the body just as it was being turned over. He said Beineman's head was beaten in. The next time he saw the body was during the autopsy the following day, performed by medical examiner Dr. Robert Hendricks at University of Michigan's Medical Center morgue. Dr. Hendricks was vacationing on Beaver Island in northern Lake Michigan when Karen Sue Beineman's body was found. He was summoned back to Ann Arbor in a chartered plane to perform the autopsy. He had performed the autopsies on all the young women in the unsolved Washtenaw County murders of the last 2 years. Judge Conlin adjourned the day's proceedings until 9 a.m. Tuesday. Police witnesses were scheduled to testify for Tuesday's court session. The cross-examination of Sheriff Harvey began the morning's testimony. Because of Sheriff's hip-to-toe plaster cast, the defense did not want to keep him on the stand any longer than possible, afraid the sheriff might evoke sympathy from members of the jury. On cross-examination, Louisel asked the sheriff if anyone had ever located the murder weapon. Harvey answered, "We never found the blunt instrument, and no footprints were found because of the heavy rain." Louisel continued, "Whose decision was it to replace Miss Beineman's body with the mannequin?" This was a sore point for the sheriff because of the Detroit Free Press article a year earlier, when reporter Walter Lundy used the label Keystone Cops to describe the seemingly random and chaotic stakeout. The defense wanted to exploit this incident by embarrassing the county sheriff and undermining the investigation. After 15 minutes of cross-examination, Harvey said he did conceive the original plan, but had no part in placing the dummy there. The sheriff told the court he heard the prosecutor's staff discussing it, but he did not know who ordered it. After the stakeout debacle, Harvey said he received several verbal reports, but claimed he never received a written report. At this point, Louisel went to his briefcase files and pulled a copy of the report the sheriff claimed he had never seen. Louisel decided to leave the jury with the impression Sheriff Harvey was being dishonest with them. The sheriff was dismissed as a witness and returned to the gallery. Next, Eastern Michigan University campus patrolman Larry Joseph Mathewson was called to the stand. He was the first witness to testify that he saw John Norman Collins around the campus that day. Mathewson said Collins was astride a very shiny motorcycle at about 12:30 p.m. on July 23, 1969. The patrolman saw Collins stop and wait for EMU student Lorraine Kellogg to cross the street bordering Eastern's campus. In cross-examination, Joseph Louisel brought out that Mathewson testified at the preliminary hearing that he passed Collins sometime after noon, but he did not specify an exact time. The defense made what they could of the ambiguity of Mathewson's report. They considered it a minor victory. Judge Conlon called for a mid-morning recess. When the trial resumed, forensic pathologist Dr. Robert M. Hendricks was called to the stand. The silver-haired doctor had worked at the University of Michigan for 22 years. He conducted the autopsy on Karen Sue Beineman's body and concluded she had been beaten savagely on the head, which caused extensive brain damage, but strangulation caused her death. When Delhi asked Dr. Hendricks what could have been used to strike her, he answered, "A club, a blackjack, a bottle, a fist, a boot. Just about anything hard can be a blunt instrument." The doctor continued his description of her body. Stuffed deep in her throat was a coarse yellow cloth. Her wrists and ankles had been bound, and small bits of skin were removed from her body. There was discoloration on her neck, shoulders, and breasts that looked like a track made by some sort of fluid flowing over them, some corrosive or tissue-destroying chemical. He suggested a household cleaner or ammonia might have caused the discoloration. Hendricks surmised the killer may have tried to revive her with it. The victim's underwear was found stuffed into her vagina. The pathologist implied she had been raped, but did not conduct blood type testing because he did not think he would get any results. Dr. Hendricks testified that Beineman died between 1 p.m. and 3 p.m. on the day of her disappearance. Her digestive process stopped between 1/2 hour and 3 hours from her last meal, which was at 12:15 p.m. On cross-examination, Louisel asked about the blow to the right side of Karen's head. Hendricks said it probably rendered her unconscious. He added, "Medical authorities have estimated in strangulation cases that death occurs from 7 to 15 minutes after air is cut off from the throat." Then the defense counsel asked if there were any cuts on the body. The doctor reported, "While the body had numerous abrasions, there were no cuts found during the autopsy." When Louisel pressed the prosecution's witness on the exact time of death and the day of her death, Hendricks admitted he was unable to fix an exact time. "Could it have been the 24th?" Louisel asked in an exaggerated manner. "Yes, sir," Dr. Hendricks answered. "Or the 25th?" "Yes, sir." But before the defense attorney could continue, Dr. Hendricks added, "However, the extent of putrefaction, the extent of insect activity on her body, and the warm and rainy weather at the time make me think she died about 3 days before I performed the autopsy." Joseph Louisel could not shake the experienced pathologist from his position. "Were there any fibers around the wrists or ankles of the victim?" The physician answered, "No." "No further questions, Your Honor." After a lunch recess, the prosecution called Eugene Wheeler, a Michigan State police detective, to the stand. He lifted Beineman's fingerprints from 2 of her notebooks and matched them to the body. Next to testify was forensic dentist Dr. J. Philip Sapp from the University Hospital. He told the court the young woman had a front tooth broken above the gum line. It takes a pretty severe blow to fracture a tooth. If the victim had been alive when it occurred, he said, it would have caused great pain. Last to testify was Dr. Robert E. Heyer, Karen's family dentist from Grand Rapids. He matched Beineman's dental records with her remains at the morgue. With their testimony, the second day of the trial ended. In the evening edition of the Ann Arbor News, William Tremmell wrote about the day's session. Karen Sue Beineman met a cruel and lingering death at the hands of a sadistic killer. Tremmell reported the first phase of the prosecution's case was over, the positive identification of Miss Beineman. Tomorrow, the prosecution would move into the second phase of their case, placing John Norman Collins in the area at the time of Karen Sue Beineman's disappearance. 21. Pinning down the suspect. 7 young Ypsilanti women, most of them EMU co-eds, were scheduled to appear as prosecution witnesses Wednesday, the third day of the trial. They all told police separately that John Collins had approached them on his motorcycle between 11:30 a.m. and 12:30 p.m. in the vicinity where Karen Sue Beineman was last seen getting on the back of his motorcycle. Before the day's proceedings began, one of the bailiffs politely offered the defendant's mother 2 soft green pillows to sit on. Loretta Collins joked with reporters that she had some with spikes for them to sit on. She used one of the pillows to soften the pew-like oak gallery bench she was sitting on. She lent the other pillow to her friend. The Collins entourage included his mother, his sister Gail and her new husband, and another unidentified young woman who predictably smiled at Collins throughout the proceeding. The first co-ed to be called to the stand was mentioned in the previous day's testimony by EMU patrolman Larry Mathewson. Linda Campbell was an EMU graduate who worked part-time as a waitress at the Inn America on Washtenaw Avenue. She told Prosecutor Delhi that she dated Collins in late 1968 and early 1969. Campbell testified that, on the time and date in question, I talked with John for about 20 minutes on Lowell Street between Jarvis and Forest Avenues. John had just returned from California, and we talked about it, Campbell said. Any mention of Collins' trip to California was not good for their client. Neil Fink objected immediately and wanted the reference to California struck from the record, and the jury instructed to disregard it. The judge sustained the objection and purged the remark from the record, but not from the minds of the jury. Linda Campbell described how Collins was dressed: blue jeans and a blue and yellow striped t-shirt. She added, the motorcycle he was riding had a lot of chrome. Prosecutor Delhi asked Campbell to walk over to a floor stand holding a map exhibit of the area under discussion. Please place a red pin on the exact location where you encountered Mr. Collins. Each of the girls to testify the rest of the day would be asked to mark a location. The map made a compelling courtroom exhibit that was used 7 times to drive home the prosecution's point that Collins was cruising the area. The next witness was Judy Lonizak, a 17-year-old Ypsilanti High School student. She testified she dated John about 10 times in the fall of 1968. She saw Collins riding a motorcycle on West Cross Street near Perrin Street. He was wearing a green and yellow striped t-shirt. Judy also placed a pin on the prosecution's map exhibit. One of the girls thought the shirt had green stripes, and the others said they were blue. It is likely the true color was in between, most likely teal, which was a popular color in the late 60s. The shirt was never produced in evidence. This was a minor discrepancy in their testimony that the defense left unexplored. The third young woman to testify she saw Collins that afternoon was Lorraine Kellogg. She spoke with Collins for about 20 minutes outside her apartment at Forest and Ballard Streets. She placed the time at just after noon because she was returning from a class dismissed at 11:50 a.m. Prosecutor Delhi had now established a firm time and definite place for Lorraine's encounter with Collins. Ms. Kellogg, do you remember what Mr. Collins was driving that day? Yes, a flashy blue motorcycle. Could you by any chance describe what the defendant was wearing that day? He was wearing Levi's and a green and yellow striped shirt. What else can you tell me about your encounter that afternoon? We talked for about 20 minutes or so. Was there anyone else present? Prosecutor Delhi asked. Yes, Joe Westmore, a resident of my apartment building. He had just driven up in his car, and John moved his bike over so Joe could park. How long was Joe there with you and John Collins? For about 10 minutes. Then he went inside and made us lunch. What did you talk about with the defendant? We made some small talk. I never formally met him, but I knew who he was. How did you know Mr. Collins? My roommate dated him. Fair enough. Do you remember what you and John Collins talked about? Lorraine Kellogg thought for a brief moment. We talked about motorcycles and mutual friends. He asked me if I would like to take a motorcycle ride with him sometime. How did you react? I said, sorry, I'm going steady with someone. How did he react? He said, maybe some other time. I want you to remember carefully, Delhi said. Did you observe a young woman matching the description of Karen Sue Beineman pass by you that afternoon a year ago? A young woman passed by us and walked on. Did you take a look at her? No. Why do you think a woman passed by you when you didn't see her? My back was to the sidewalk, but John was on his motorcycle facing the sidewalk. I noticed him glance at someone who walked past, and he said hello, smiling. I didn't want to turn around and take a look because I didn't care who it was. What happened next? Not long after, Joe came out and said lunch was ready. I excused myself and went inside. What did John Collins do? Said goodbye and drove up Ballard Street. What do you mean by up Ballard Street, Miss Kellogg? Toward downtown, away from campus. The prosecution wanted to leave the jury with the impression that it was Beineman who passed by that afternoon, while Kellogg was talking with Collins. Under cross-examination by Neil Fink, Kellogg did not remember telling prosecutors she could not remember the color of the shirt in her original statement to police. She also made a statement that Joe Westmore joined the conversation for 20 minutes or so, but Fink pointed out again that her pretrial statement indicated Westmore talked with her and his client for only 10 minutes. I don't remember saying that, she said. Your memory is very selective, Miss Kellogg, Fink said. Objection, Your Honor. Sustained. Without missing a beat, Fink continued. What else do you not remember from that day? That's about it. When my client asked you out, how did he make you feel? What do you mean? Did he make you feel uncomfortable or threatened? No. Would you have accepted his invitation if you weren't going steady with someone? Probably not. Why not? Because he asked my roommate on a date to his room to watch color TV one night. He spent the entire evening trying to get her into bed. That was not the answer Fink hoped for. No further questions, Your Honor. Judge Conlon called a recess to allow the defense team to listen to a tape recording of Kellogg's police statement the previous October. While on recess, some of the jury complained to the bailiff they were having trouble hearing because some of the spectators were talking while testimony was being given. When court resumed, Judge Conlon admonished the gallery and warned that any spectators who talked during the testimony or disrupted the court while in session would be removed and banned from the courtroom for the remainder of the case. Next up to testify was 22-year-old Susan Bonner. Miss Bonner, on Wednesday, July 23rd, did you see John Collins? Yes. Would you tell the court where and when, please? On Ballard Street, at about 12:30 or 1 o'clock in the afternoon. That broad time frame was not good for the prosecution's case. How certain are you of the time? Asked Delhi. Pretty close. I left my class at noon and went to Ned's bookstore for about a half an hour. Then walking home, I saw John Collins. A moment before you continue, Miss Bonner. Don't 10 a.m. classes typically end at 11:50 and not 12? Yes, I guess they do. Did you stay longer after class for some reason? No, I just rounded the time off. Could you have been less than 30 minutes at the bookstore? Maybe. I was in no rush to be anywhere, so I took my time. But 30 minutes is only a rough estimate. Yes. Ms. Bonner, is it possible you passed by Mr. Collins earlier than 12:30 p.m.? It was closer to 12:30 p.m. What did you see? John sitting on his motorcycle, talking to a young woman. So you recognized John Collins? Yes, we knew each other on a social basis. He was in a fraternity, and some of my sorority sisters dated him. The girl standing on the sidewalk had her back to me, but John and I smiled at one another. Did you know the young woman he was talking with? No, she didn't turn around, but I could tell I didn't know her. Is this the person John Collins was speaking to? Prosecutor Delhi asked, handing her a photograph of Karen Sue Beineman. No, the girl he was talking to had long brown hair. The prosecution hoped Bonner could identify the woman talking to Collins as Karen Sue Beineman. Now it was certain she saw Lorraine Kellogg talking with Collins. Still, they were able to have Bonner verify the time she saw Collins and place another stick pin on the prosecution's map exhibit showing where she encountered Collins. When it was the defense's turn to cross-examine Susan Bonner, she was asked what her opinion of John Collins was. He is a very nice guy. What did your sorority sisters say about Mr. Collins? Objection, Your Honor. Defense counsel is asking for hearsay testimony. Sustained. No further questions for this witness, Your Honor. Louiselle was pleased with her testimony. Next up to testify was Sarah Herrera, a teenage bride who said Collins tried to pick her up while she was waiting for her mother outside Ypsilanti High School on Adams and West Cross Streets. Like the other girls who testified they saw Collins, she rose from the stand and placed a red pin on the map exhibit. Returning to the stand, she said a man in a striped blue-green shirt rode up to her on a motorcycle at around 11:30 a.m. Louiselle asked the high school girl how she could be certain of the date. She explained, Well, I ordinarily wouldn't remember when someone tried to pick me up, common occurrence in a college town, but there was something in the paper, Herrera said. Louiselle wanted to crush that line of testimony and did not follow up on the point. The observant young woman also added she noticed the motorcycle had a square-shaped rearview mirror on the left side of the handlebars. This was testimony that did not please the defense. They dismissed Sarah Herrera as quickly as possible. Another EMU co-ed, Eileen Gale, testified that at about 11:25 a.m. on the date in question, a motorcyclist stopped her as she was walking alone on Perrin near Forest Street. Another red pin went on the map. She remembered the motorcycle had a blue tank and the driver was neatly dressed. He had on a knit shirt with a large amount of green and yellow in it, Eileen Gale said. I only spoke with him for a minute or two. Then I ran down the street to my girlfriend's apartment. Why did you run down the street? The prosecutor asked. Something didn't feel right. With all the murders, I felt a little paranoid. The defense declined to cross-examine Eileen Gale, and the judge dismissed her. The final witness to testify she saw John Collins in the area was 22-year-old Mary M. Thompson, an EMU senior. She said the defendant drove up to her sometime before noon on July 23rd as she was walking up College Place between Forest and Cross Streets. She said Collins was wearing a green-striped shirt and driving a shiny motorcycle. Thompson explained she spoke to him for only 30 seconds to a minute. All 7 girls who testified placed pins on the map exhibit to show where they crossed paths with Collins. All contacts were within several blocks of each other near the EMU campus and within blocks of where John Collins lived. Wednesday's final witness was Michigan State Police Trooper Donald Collins, no relation to the accused. He had drawn a diagram of the street outside Wiggs by Joan on North Washington Street in downtown Ypsilanti. William Delhy wanted the scaled diagram entered as a courtroom exhibit and indicated another diagram would be entered into evidence later in the day, a diagram of the basement of Sergeant David A. Like, the alleged scene of the murder. With the judge's approval, both drawings were entered into evidence. On the one-year anniversary of Karen Sue Beineman's death, her sister Barbara attended the trial for the first time. She sat in the back row of the small courtroom, and on the opposite side of the aisle from Loretta Collins, who appeared every day at the trial, including the 5 weeks of jury selection. Karen Naylor, a young woman described in all the papers as John Collins' former girlfriend, began the day's testimony. William Tremmel reported in the Ann Arbor News that the tall, long-haired blonde wept quietly as she identified Collins in the courtroom. He smiled back at her. She composed herself and explained that a year ago she was a student at Washtenaw County Community College, just northwest of Eastern Michigan University, where she was currently enrolled. Naylor explained she met Collins while she was washing her car outside her apartment house named the Huron Hills on LaForge Road where she lived. This handsome, well-built guy was visiting some fraternity brothers who lived in the same building as me. After a couple of minutes, he discovered I was into motorcycles and had my own Yamaha. Then, several days later, when I was out riding my bike, he pulled up alongside me and asked if I wanted to go riding with him. Is that how he phrased it? The prosecutor asked. Yes. After I said it, I thought most people would ask, "Do you mind if I ride with you?" But he made it sound like it was a great privilege to ride with him. I was struck by his self-confidence. Is that all you were struck by? Well, no. What else? John had on a tight t-shirt and shorts. I remember thinking how well-toned his body was. Are you John Collins' girlfriend, as the newspapers describe you? Naylor answered. We dated through March, April, May, and July of last year. Not June? Why not June? Most of June, he... Objection, Louis L. bellowed. That question is not within the scope of this case and is inadmissible as part of your Honor's earlier ruling. Sustained, Collin ruled. Mr. Delhy, stay within the parameters of this case. My apologies to the court, Your Honor. It won't happen again. The prosecutor did some backpedaling. Miss Naylor, were you and Collins ever engaged? Objection! The prosecution is leading the witness. Overruled, Mr. Louis L. The court is interested in the witness's answer. No, sir, we weren't. We hung out and went off-roading quite a bit on one of several bikes he owned. He had 2 Bultaco dirt bikes we rode around the backcountry. We would go on romantic picnics along the Huron River, but never anything very serious. We always had a good time together. What other motorcycles did he have at his disposal? John had a green Triumph 450 with high handlebars and a big blue Triumph 650 with a square rearview mirror on the left handlebar. Naylor told the court that the Saturday before Beineman disappeared, Collins made a date to take her to the beach on Wednesday. It wasn't like him to not show up or not make a phone call. He stood me up. Would you explain what you just said in more detail? John never showed up. The next morning, I went to his apartment, and he wasn't there. Then I looked for him inside the garage. He wasn't there either, but both Triumphs were. But there was no sign of the square mirror. However, on the blue Triumph, there was a crushed and bent round mirror. How did Mr. Collins take care of his motorcycles? He was meticulous. He didn't like to go out in the rain and mud with them. Would John Collins ever put a defective part on one of his motorcycles? Objection, Your Honor. The answer calls for an opinion and assumes facts not in evidence. Sustained, Mr. Fink. At this juncture, Fink interrupted Naylor's testimony and requested the Triumph motorcycles be brought into the courtroom for examination before the jury. Prosecutor Delhy conferred briefly with Sheriff Harvey, who was in a wheelchair at the rear of the courtroom. Delhy approached the bench and told the judge the motorcycles were being stored at an undisclosed location. They would need to be trucked in, which could take some time. Perhaps Sheriff Harvey could ride them in? Judge Conlon smirked, in a rare light moment in the courtroom. The county sheriff had recently crashed his own motorcycle and smiled at the prospect of driving each of those bikes up the stairwells and roaring into the courtroom in front of John Collins. While the spectators enjoyed a bit of comic relief at the judge's remark, Conlon adjourned the proceedings for the lunch recess, while the motorcycle exhibits were retrieved. As her son was led back to his jail cell, Mrs. Collins waved and smiled at him, as bravely as she could. When court resumed, the two Triumph motorcycles were wheeled into the courtroom. John Norman Collins reached out in a rare show of emotion and touched the handle grip on one of the bikes and grinned as he made his way to the defense table. It was time for the rest of Karen Naylor's testimony. She identified the motorcycles as belonging to Collins. Then Delhi asked her to testify about the square mirror and which of the bikes she saw it on last. The blue one, she testified. John had a minor accident with the green bike and transferred the cycle's handlebars with the square mirror to the blue Triumph. When Joseph Louisel cross-examined Naylor, he asked her to point out the damage on the green cycle. She walked over to the exhibit and pointed to a small dent on the gas tank. She told the court Collins had a square mirror on the green cycle at the time of the accident. If I told you the handlebars on the blue bike were purchased in July, would you change your testimony? Said the wily attorney. No, because they weren't, answered Naylor. Naylor testified Collins had a square rearview mirror on his motorcycle like the one she had on her motorcycle. Didn't you pay $6 for yours? And didn't John tell you it was no good? Louisel probed. No, that's not true. We never talked about that, Naylor answered defensively. Joseph Louisel was going nowhere with his line of questioning and simply gave up. No further questions, Your Honor. The defense would vent their frustration on the next witness, Diana Joan Goshi, owner of Wigs by Joan. 22. The Wig Shop Ladies. All the newspapers described Diana Joan Goshi, the prosecution's key witness, as a tall, slender woman with silver blonde hair piled high on her head. Because of the gravity of Goshi's testimony at the pretrial hearing, the defense asked that the jury be excused while the wig shop owner was questioned by the prosecution about the conversation she had with Beineman. The judge complied with the defense request. 10 minutes later, Goshi testified Beineman told her, "I'm the bravest customer you've had today. I bought a hairpiece, which is something I've always wanted, and I accepted a ride from a stranger on a motorcycle." Judge Conlon ruled the testimony inadmissible about Beineman accepting the ride because it was a past action and hearsay. The statement Beineman made about purchasing the wig was irrelevant. Goshi would be allowed to testify the girl told her the motorcyclist said he would take her back to her dormitory. "After the conversation, what did you do?" Goshi said, "I went outside my shop to get a better look at him." "Did you see his face?" "I saw a three-quarter profile of him. I looked at him for more than a minute at a distance of 30 feet. "What was he doing?" "He was sitting on his motorcycle. The motorcycle came within 15 feet of me as they drove off." When asked to describe the clothing the young man was wearing, she answered, "A horizontally striped yellow and green t-shirt." The description matched descriptions given from the previous day's testimony. Goshi was asked if she could point out the person in the courtroom. She pointed to John Collins as the person she saw on a motorcycle with Karen Sue Beineman that afternoon. "What happened after that?" Delhi asked. "They drove off and turned right onto Michigan Avenue." When Judge Conlon called the jury back to the courtroom, Goshi repeated the same testimony in their presence, without the prejudicial remarks the judge ruled inadmissible. Thursday's afternoon proceedings were adjourned until Monday morning at 9 o'clock, when cross-examination of Goshi would begin. The rest of the afternoon, Judge Conlon researched opinions and ruled on a variety of issues brought by the defense. He told the jury and the attorneys he fully intended to conduct a Monday through Friday court schedule, but he had other court business to take care of this Friday. When court reconvened on Monday, July 27th, Neil Fink moved to strike the testimony given the previous Thursday by Karen Naylor, John Collins' former girlfriend. Miss Naylor contradicted herself about the testimony concerning the square mirror. Her testimony is highly prejudicial and not based on fact. Judge Collins said dryly, "I will review the woman's testimony before making a decision." Today's cross-examination of Ghoshi was also going to be handled by Neil Fink. This would be a punishing 2 hours on the stand, as the defense attorney attempted to attack her character and truthfulness. So far, the women who testified were handled with care, but Fink changed tactics now. "Mrs. Ghoshi, you told this court Miss Beineman came into your shop between noon and 12:30 p.m., did you not?" "Yes." "But didn't you first tell police it was at 12:15 p.m.? "I'm not certain." "Not to worry. It's written down right here on the police statement you made and signed." He held a clipboard with the report and showed it to her. "Then, during the pretrial hearing, you testified under oath that Miss Beineman arrived at your store between 12:30 and 1. So when was it? 12, 12:15, 12:30, 1 p.m.? "I don't have a definite time period when Miss Beineman arrived. It was sometime after noon and before 1 p.m. "Are you sure?" "Objection," Delhi interjected. "Defense counsel is badgering the witness." Mrs. Ghoshi answered his question. "Sustained," Neil Fink continued. "Mrs. Ghoshi, you originally described in your police report that the motorcyclist had dark curly hair and medium sideburns, correct?" "Yes, sir." "But Mr. Collins has straight hair and short sideburns. Were you shown any photographs of Mr. Collins prior to giving the police your description of the person on the motorcycle?" "No, sir. I gave the description to the police. Officer Mathewson showed me a grainy photo of John Collins standing by a Christmas tree. I told the officer I wasn't certain and didn't want to make any identification from a photograph." "Were you shown any other photographs of the defendant?" "Yes." "And what was the result of that?" "I was unable to identify Collins from 3 photographs I was shown by Sheriff Harvey. One of the photos looked like him, but I also told the sheriff I wasn't comfortable making a positive identification from a photograph." "What was Sheriff Harvey's reaction?" "Disappointment." "What did he say?" "Thank you," and he left." "Do you wear corrective lenses, Mrs. Ghoshi?" "I wear glasses when it is bright and for long distance." "Were you wearing them on the day you allegedly saw John Collins in front of your shop?" "No. He was not that far away or difficult to see." "Does your employee, Mrs. Spaulding, wear glasses?" "Sometimes." "Was she wearing them the day she claimed she saw John Collins on the motorcycle parked outside your shop?" "I don't remember." "I'd say there's a lot you don't remember. Do you remember ever marrying your husband?" "What?" Ghoshi said. "Objection," interjected Delhi. "This line of inquiry is irrelevant and immaterial to the facts of this case. Your Honor, this speaks to the integrity and truthfulness of this witness." "Objection overruled. Continue, Mr. Fink." "Come on now, Mrs. Ghoshi," Fink probed. "It's an easy question. Do you remember marrying your husband?" When pressed further, Ghoshi admitted she lied twice under oath when she said she was married to a man named Whitting, with whom she was living. "That was a lie, wasn't it?" "Yes," she said. Fink asked Ghoshi to walk over to the motorcycles and examine them. When she returned to the stand, she said she could not connect either motorcycle to the man seated before her. "I'm not that familiar with motorcycles." Fink continued to undermine Ghoshi's judgment. He asked her about a former male companion who he claimed was a convicted rapist. "Aren't you afraid for your son's safety? Or to be seen in public with this man?" "No." I don't turn my back on my friends." Fink suddenly took another tack. "What about the reward?" "What reward?" "The $74,000 you were bickering over with your employee Patricia Spaulding about who should claim the reward." Prosecutor Delhy objected strongly, saying the defense was muckraking. "No further questions at this time, Your Honor," Fink said. "The jury will disregard the remarks about the reward money, and the court recorder will strike them from the record," Conlon instructed. On redirect, Prosecutor Delhy made an attempt to reestablish the credibility of his star witness. "Mrs. Ghoshi, would you explain to this court the circumstances behind your first marriage?" "When I was 15 years old, I ran away from home with my boyfriend to St. Louis, Missouri, in an attempt to get married. When I returned home with my male companion sometime later, we claimed we were married and lived together for 8 years as husband and wife, and purchased a home. I lied under oath because I wanted to protect my 11-year-old son who has to grow up in this town. I made the mistake. He shouldn't have to suffer for it." After 2 hours of interrogation, Ghoshi never wavered in her testimony that it was John Norman Collins who drove Karen Sue Beineman away from her wig shop 1 year before. The second prosecution witness of the day was Carol Viacheja, an EMU co-ed and an employee of Jacobson's women's clothing store in Arborland. The previous year, she worked at the chocolate shop next door to Wigs by Joan. The 21-year-old clerk testified the shop was empty of customers, so she was gazing out the front window. "I saw a young man and a woman pull up on a flashy motorcycle and park in front of the shop. It was around 12:30 or so when they rode up." "What happened next?" "The girl got off and walked down the street toward the wig shop. About 15 minutes later, the girl came back and got on the motorcycle. She got off again, talked with the man, and got back on. Then they rode off." "Can you identify that man?" "The man resembled John Collins, but I can't be sure." Unlike the ladies in the wig shop, Viacheja could not positively identify Collins as the motorcyclist that day, but she could identify what he was wearing: a green and yellow striped t-shirt and blue jeans. "Do you have any recollection of the motorcycle, Miss Viacheja?" The young clerk was a bike enthusiast and rider herself, and easily recognized the big blue bike with all the gingerbread chrome detail. "It was a blue Triumph 650. That one over there." The defense could not get Carol Viacheja off the stand quickly enough. Now it was Patricia Spaulding's turn. She would be the second witness to place Collins and Beineman together on the motorcycle that fateful afternoon. Spaulding had shown Beineman how to wear her new wiglet in her hair. After Spaulding identified who she was and where she worked, Prosecutor Delhy began his questioning. "Mrs. Spaulding, would you tell the court what you witnessed on Wednesday afternoon, July 23, 1969? "Miss Beineman came into the shop at about 12:30 p.m. to pick up a hairpiece called a fall. She ordered it the day before." "How long was she in the wig shop?" he asked. "For only 15 minutes, maybe." "Did you have any direct contact with her?" "Yes." "Would you describe your interaction with Miss Beineman?" "I showed her how to store the hairpiece and how to style her hair using the hairpiece." "Tell the court what happened next, please." "Well, I went outside the shop with Mrs. Ghoshi and looked toward the chocolate shop and saw a man waiting on a motorcycle for the young woman. I took a look at him and went back into the shop and watched them out the window as they headed toward Michigan Avenue. Miss Beineman was wearing her hairpiece when she left." "Is the driver of that motorcycle in this courtroom today?" Patricia Spaulding pointed at Collins. "Have the record show Mrs. Spaulding pointed at the defendant," said the judge. "Can you describe the motorcycle he was riding?" "It was dark blue, shiny, and well kept, with a square rearview mirror on the left side of the handlebars." "Is that motorcycle in this courtroom?" "I couldn't say for sure. My husband rides a motorcycle, but I couldn't identify a particular bike. I was focused on the driver, not the motorcycle." "Thank you, Mrs. Spaulding. No further questions, Your Honor," Delhy said, walking to the prosecution table, satisfied he had made his case. Diana Joan Goshi and Patricia Spaulding placed Collins and Beineman together on the motorcycle, and another credible witness, Carol Viecheja, was able to identify the motorcycle and the make, a Triumph 650. This witness was not sure about the rider, since it was the motorcycle that caught her eye. Just before the lunch recess, Judge Conlin interrupted Spaulding's testimony to rule on a defense motion made the previous Thursday. The judge said he would strike evidence given by Karen Naylor regarding her conflicting testimony about Collins switching the square mirror on his motorcycles. Later in her testimony, Naylor said she saw only a picture of the square mirror on the blue bike, but no such photograph was in evidence. The jury was instructed to disregard that portion of her testimony. This was by no means a victory for the defense. Several other witnesses testified about the square mirror, so the prosecution won their point. Returning from the lunch recess, Spaulding came under intense cross-examination from Joseph Louisel about her lunch break with Goshi. "Did you or Mrs. Goshi discuss your testimony at lunch?" "We didn't," she answered. "What did you discuss? The reward money and who would claim it?" "Objection. Defense counsel is putting words in the mouth of the witness." "Sustained, Mr. Delhi." "Allow me to rephrase that. Did you talk about the reward money at lunch?" "Mrs. Goshi said she was thinking about claiming the reward if Collins was convicted, but we didn't discuss that at lunch today." When Louisel pressed Spaulding about her original police statement, she said she never gave the type of motorcycle, and she did not identify Collins from the 3 photographs Sheriff Harvey showed her. She did say, however, that the motorcycle had a square mirror on the left side. The wig stylist also admitted she made no attempt to get the license plate number of the motorcycle as it passed in front of the wig shop. Spaulding added she was not satisfied with the composite drawing made by Ypsilanti Police Sergeant William Stenning. The sideburns on the drawing were longer than on the man she witnessed that day. His sideburns came more to the middle of the ear. Patricia Spaulding added little to the testimony already given by her employer. In the end, both women stood their ground. 23. The worm turns. Arnold Davis, self-described best of friends with John Norman Collins, roomed in the same boarding house across the second-floor landing from Collins. A year had passed since Davis graduated from Eastern Michigan. He was currently working as an operations supervisor at LaGuardia Airport in New York City. When Davis arrived in court, Collins stared intently into the witness's eyes for at least 5 minutes, John Cobb of the Ypsilanti Press reported. Both Davis and Collins bear a remarkable resemblance. Both are of the same build and have square jaws with sharp features. Their hair is worn in the same style, with a wave over the right side of the forehead. Davis differs from Collins by having longer sideburns. Arnie Davis began his testimony Tuesday morning without the jury present. Judge Conlin ruled that to protect the record, it would be best to take the testimony first in their absence. The judge and the prosecution feared mistrial could be called if information related to any of the other murders connected with Collins came out during Davis's testimony. Arnie Davis was dressed in a pink shirt, a red and gray tie, and a gray suit. He began his testimony in a relaxed and thoughtful manner. Prosecutor Delhi questioned him about Sunday evening, July 27, 1969. 2 police detectives came to our house at around 11 at night. John went out on the porch and talked with them for about 15 minutes before agreeing to leave with them. He returned home between 1 and 1:30 Monday morning, Davis told Delhi. "Did he talk to you about the incident with the police?" "Yes, he said the cops suspected him of the Beineman murder and asked him to return later that day for more questioning. I laughed and said, 'They're suspecting a lot of people.'" "What happened next, Mr. Davis?" "John called home and told his mother he was in trouble." "Can you tell the court what happened the next evening at about 11 p.m.? "John and I returned home after feeding a dog belonging to his uncle. The family was away on vacation. When we returned home, John took a knife wrapped in a shop rag from under the seat of one of his motorcycles. What did he do with the knife? He took it upstairs. A short time later, I carried a dark green or blue blanket from the trunk of John's car, while he carried a cardboard box to his room, Davis testified. Did you notice anything in the box? I glanced and saw a pair of women's shoes, some rags or clothing, and a burlap handbag. Do you know what he did with those items? 15 minutes later, John left the rooming house with the blanket and the box. Within half an hour, he returned home empty-handed. Did you ask him about the items? I asked him about the blanket. And what was his answer? He got rid of it? Did Mr. Collins give you anything that night? Yes, he did. Would you tell the court what he gave you? John brought a hunting knife to my room and asked me to keep it for him. Did you? Sort of. What do you mean, sort of? I told him to put it someplace, and he placed it in my dresser drawer. The defense team objected strenuously to Davis's testimony regarding the contents of the box and the hunting knife. Ruling on the admissibility of the testimony, Judge Conlon said, "It has not been shown Miss Beineman was wearing a pair of dress shoes. Her corpse was wearing sandals, and there isn't sufficient identification of the handbag to indicate it was similar to hers, or that either are connected to Miss Beineman in any way. As regards the testimony about the knife, there has been no claim by the prosecution of any knife wounds on Miss Beineman's body, and only her underpants were cut with a sharp instrument." The judge ruled certain parts of Davis's testimony were ruled inadmissible and could not be brought before the jury. The knife did not enter into the cause of death, and the contents of the box are irrelevant to the disposition of this case. The defense won a major victory against the aggressive prosecution. The jury was brought into the courtroom at 10:10 a.m. to hear the admissible parts of Arnie Davis's testimony. William Delhey carefully led Davis through his 20 minutes on the stand. How long have you known the defendant, Mr. Davis? Just over 2 years. We pledged the same fraternity in the spring of 1967, and common association led to friendship. And which fraternity was that? Theta Chi on West Cross Street. What kind of car did Mr. Collins drive when you met him? A blue and gray 1958 DeSoto. After that, he drove a silver 1968 Olds Cutlass. Davis testified he and Collins lived in a rooming house on Emmett Street from the summer of 1968 until August of 1969. Arnie Davis said of his relationship with Collins, "We were good friends. Best of friends." Prosecutor Delhey asked Arnie Davis to carefully trace his contacts with Collins from Tuesday, the day before Beineman disappeared, to the following Sunday, July 27th. On Tuesday night, we ate dinner at the Ponderosa Steakhouse in Ann Arbor. Then we went to the home of Collins's uncle to feed his German Shepherd while the family was away. I stayed in the car while John went through the garage door to feed the dog. What about July 23rd, the day Karen Sue Beineman went missing? I went to work at J.C. Penney in Arborland from 9 a.m. until 12:45 p.m. When I arrived home afterward, Collins wasn't there, so I started working on a project for the store. After about 30 minutes, Andy Manuel and I went to Grant's in the Galt Village Shopping Center. We stayed there between 3:45 p.m. and 4:15 p.m. when we went home. 15 minutes later, John walked into the house. He said he was at Joe's motorcycle shop getting parts for his bike. Would you identify who Andrew Manuel is for the court? Andy was a work friend of John's who recently moved into our house. After John Collins got home that evening, what did the three of you do, Mr. Davis? We watched television in John's room. John went out to work on his bike. He stayed in the garage for a couple of hours. When he returned, we watched TV until 11:30 p.m. Then he remembered he had to feed his uncle's dog. John went to his uncle's house and was gone for over an hour. When he returned, the James Cagney movie Andy and I were watching was nearly over. After the movie finished at 1, Manuel left to get some pop, and Collins went to wash his car at the Quarter Car Wash. What did you do, Mr. Davis? I went to sleep. When did you next see John Collins? Delhi prodded. On Thursday afternoon, I saw John in the garage working on his motorcycle and talking to an EMU campus policeman. I just returned from the Secretary of State's office with a license plate for one of... Louisel interrupted Davis. Objection, Your Honor. This line of inquiry is irrelevant and immaterial. Sustained, Mr. Louisel. Arnie Davis testified the next time he saw Collins was on Sunday, July 27th, just before 11 p.m. Davis asked Collins if he had a good time on his date. Just then, the doorbell rang, and Arnie asked Collins to answer the door. It was the police again. They asked John to go to the crime center for some questioning. He returned home after 1 a.m. The next day, Collins was arrested. At the finish of Arnie Davis's testimony for the prosecution, the defense team objected strongly to his testimony, saying it was tainted by illegal police misconduct during questioning. This made an issue of the voluntary nature of Davis's testimony. All his testimony comes from mental torture, and we object to everything he testifies to. It's all tainted. We want that on the record, said Joseph Louisel. At 4:15 p.m., Judge Conlon ruled, It's almost quitting time. We'll adjourn now and give the defense time to interview the witness, Davis. We don't want to get into grounds for a mistrial. The defense got their chance to cross-examine Arnie Davis on Tuesday morning. During Monday's session, Davis gave key prosecution testimony about their client's movements at the time of the Beineman murder. The defense chose to ignore Davis's testimony, awaiting a ruling by Judge Conlon to strike it from the record. Joseph Louisel chose to focus on Davis's treatment by police, which virtually overshadowed the testimony of his friends' comings and goings. When Louisel should have pressed this witness, he decided to go easy on him instead. Would you tell the court, Mr. Davis, about your trip to Kentucky with Mr. Collins in 1968? The seasoned attorney began. Davis described how Collins swerved his car to avoid hitting a cat in the road, but the vehicle struck and killed it. And didn't John stop the car and go over to the animal? Yes, sir, he did. The vignette the defense attorney painted for the jury did not touch on the question of why he stopped or what he thought he could have done about it. Did Collins pray over the animal? Did he bury it? Did he place it on the shoulder of the road? Did he grieve over the cat's carcass? Or did he have a morbid curiosity and watch this mangled and torn creature twitch in its death throes? The prosecution was puzzled where the defense was going with this line of questioning, but for the present, they let it continue. Was your friend working his way through college? Louisel asked. Yes, he was. Where did he work? John worked part-time at Motor Wheel Corporation on Norris Street in Ypsilanti, Davis said. Is it true you and Mr. Collins often talked about Vietnam and the draft? Objection, said Delhi. This line of testimony is irrelevant and immaterial to the matter before this court. Louisel appealed to Judge Conlon. My question is meant to bring out Collins's peaceful and law-abiding self. Objection sustained. Mr. Davis, would you tell the court about the arrest of your friend? Yes, sir. The police came to the home looking for John on Saturday morning, July 26th. Where was he? He was in Centerline at his mother's house. Did you tell the police officers that? I did, but they still staked out the house. At one point, I went up to their unmarked police car and invited them in for a cup of coffee. Did the police avail themselves of your hospitality? They said, no thanks, and left. When did John get home? About 11 p.m. Sunday night. Anything out of the ordinary happen? The doorbell rang, and I asked John to answer it. Did you know who was at the door? I had a pretty good idea. I mentioned to John the police were at the house looking for him over the weekend. Who was at the door? 2 police detectives. Then what happened? John went out to the porch and talked with them for about 10 minutes and left with them. Where did they take him? When John returned home at 2 o'clock Monday morning, he said the police took him to the crime center on Washtenaw Avenue. Using a police report as a hand prop, Joseph Louisel led the witness. Didn't John describe his interview with police that night as horrible? Yes. And didn't he tell you, Louisel said, reading from the police report, I want to help them. I want to. I want to help them solve this crime, but gosh, it was horrible. They let the real killer get away, and now they are harassing me. Arnie Davis agreed those were the words Collins used. In a roundabout way, the defense was able to get some hearsay testimony of their client into the record, despite muzzling Collins from testifying in his own defense. The "they let the real killer get away" remark was engineered to enter into testimony the abortive mannequin fiasco at the Beineman stakeout. Arnie Davis said he was at McKinney Union on the EMU campus when he heard his friend had been arrested. I hurried home, and there were police and newsmen at the house. A crowd had formed outside. The police wouldn't allow me into the house and took me to the crime center for questioning. You mean the Holy Ghost Fathers Seminary, where the task force was headquartered? Yes, sir. I was questioned there until 3 or 4 in the morning. Mr. Davis, do you remember the names of any of the officers who questioned you? Morrison, Little, Canada, and sometimes a prosecutor. Did they all question you at the same time? No, in relay teams. Did they threaten you at all, Mr. Davis? I was told I could be arrested for suspicion of the Beineman murder if I didn't cooperate. Did they accuse you of lying? Yes. Did they use loud voices? Yes. What happened next? The questioning finally ended at 3 or 4 Saturday morning. The police took me to the In America with a detective who told me I could get up and leave if I wanted. But were you left with the impression if you chose to leave, you would be arrested? Objection, Your Honor, Prosecutor Delhi interrupted. Defense counsel has been leading the witness all afternoon. Whatever Mr. Davis's impression may be is not a fact in this case or subject to the rules of evidence. Objection sustained. Louisel made no mention to the jury that the boarding house on Emmett Street was a secured crime scene, and nobody could go inside the house without police authorization. Apparently, Arnie had no place to go, so he was taken to one of the nicest hotels in the greater Ann Arbor area, the In America, for free lodgings with room service, all paid for by the county. As his testimony stretched on, Davis continued to cast aspersions on the police at Louisel's promptings. The police picked me up later the next day on Saturday and interviewed me most of the day until about 1 o'clock Sunday morning. Did they ask you the same questions? Over and over again. But this time they threatened to implicate my twin brother in the murder case. I was questioned by police for 4 or 5 hours almost every day at the crime center. At one point, didn't you tell the police they could write down whatever they wanted and you would sign it? Something like that. They kept asking me about a square rearview mirror. I told them I don't recall such a mirror. They seemed mad. Objection. The question doesn't require the witness to draw a conclusion based on his answer. Sustained, Mr. Delhi. Once you graduated from Eastern Michigan and moved to New York, did police interest in you continue? State Police Detective Max Little kept calling me at my place of employment in New York City. I finally told him I wouldn't cooperate with him anymore if he continued to harass me. Were you ever offered counsel during these interview sessions? I was never represented by counsel during numerous police interviews and was not always told my statements were being recorded. State Police Lieutenant Morrison told me it was to my advantage not to have a lawyer present during questioning. Were you told by your interrogators, if you were innocent, you won't need a lawyer? Yes. Morrison told me he could get a warrant for my arrest, but he was holding back. So Lieutenant Morrison gave you legal advice? Yes, I suppose so. Before the prosecution could lodge an objection, Louisel said, I'd like to withdraw that question, Your Honor. Did Morrison speak with you about the reward money? He told me he couldn't offer me any inducement or reward, but it was his understanding that rewards were available in the Beineman case. No further questions for this witness, Your Honor. On redirect, Prosecutor Delhi did not respond to Davis's charges against the police. Do you remember, Mr. Davis, what you told investigators John Collins said to you on the night of Sunday, July 27th, after the discovery of Miss Beineman's body was reported? I'm not sure. The police questioned me about many things, he hedged. Yes, we just heard your sworn testimony, Mr. Davis. An uncomfortable silence ensued while Delhi carefully scanned a police report. Mr. Davis, let me read to you from the police report taken that day. Collins asked you, if anybody asks, remember what time we went riding on Wednesday. It was early afternoon, right? Does that ring a bell with you, Mr. Davis? Vaguely. What time did you tell the police investigators you had your motorcycle driving lesson with Collins on Wednesday? Around 4 p.m. until 7 p.m. Was the lesson 3 hours long? More like 2 hours. We took the long way through the back country to our house, about 2 or 3 hours altogether. You testified he drove you to the parking lot on Eastern's North Campus. Yes. Who drove back? He did. I was on the back of John's motorcycle. Do you remember the route you took? The scenic route. Huron River Drive to Superior Road, Superior to Geddes Road, Geddes to Prospect Street, and Prospect to West Cross Street. Then we turned left on College Place and went up a block to our house on the corner of Emmett Street. You remember the directions home pretty well, Delhi remarked. Do you remember now what John told you the day Karen Sue Beineman disappeared? Delhi asked, putting on his glasses and bringing the police report within reading distance. Reluctantly, Arnie said, John told me he wanted me to say the lesson was earlier in the afternoon. Is that all he told you, Mr. Davis? Squirming a bit, Arnie said, and not to fuck him up. No further questions, Your Honor. Assistant Prosecutor Booker T. Williams was back on active duty after his family leave. His wife passed away after a long illness. The next witness was Collins's other rooming house friend, Andrew Manuel, who was brought over to the courthouse from the county jail across the street. He was serving a 60-day sentence for a parole violation from 2 other 14th Circuit Court cases, which, not coincidentally, involved his motor wheel work buddy, John Collins. Any mention of these cases could result in a mistrial, so Williams was cautious with his questioning. A mistrial in the Collins case would mean that the entire process would have to begin anew. At this point, the prosecution did not want this case to slip away and cost the taxpayers an endless amount of money. The defense did not want a mistrial because if Michigan Governor William Milliken decided to honor California Governor Ronald Reagan's extradition request, Collins could be tried in California. Further upping the stakes was the death penalty. California had capital punishment on the books, and Michigan did not. Andrew Manuel's testimony roughly followed what Davis said earlier. Manuel agreed Collins returned to the rooming house between 4 p.m. and 4:30 p.m. on Wednesday, June 23rd. Manuel testified Collins and Davis left to get something to eat. Here was where his testimony varied from Davis's account. Davis claimed Collins was giving him motorcycle driving lessons during the same time frame. When Arnie and John returned, Andrew Manuel testified they ate their evening meal at the W.T. Grant store in the Galt Village Shopping Center, off of South Grove Road in Ypsilanti Township. Mr. Manuel, didn't you just testify Mr. Collins and Mr. Davis left earlier to get something to eat? That's what I thought, but I don't know what they were doing. I wasn't there, he wisely answered. What did you do after your evening meal together? Chief Assistant Prosecutor Williams asked. We went to the Emmett Street house at about 9 or 10 p.m. and watched television. Do you remember what you watched? Arnie and I watched a James Cagney movie, but Collins left for a time. I think he was in the garage working on his bike. What did you do when the movie ended, Mr. Manuel? Following the movie, I went to a gas station to wash my car. Collins arrived there a while afterward. Isn't that kind of late to be washing your car? Not when you're used to working midnights. While John was waxing his car, I left. The next time I saw him was in his room Tuesday. The three of us went out for supper and stopped at John's uncle's house to feed the dog, Manuel said. Arnie and I stayed in the car while John went inside for 15 or 20 minutes. Inside where? The house or the garage? Maybe both. I wasn't paying attention. Did you see Collins over the weekend? No, John was at his mother's house. Do you know who fed the dog while John was out of town? No, sir, I don't. No further questions, Your Honor, said Assistant Prosecutor Williams. When Judge Conlon asked Neil Fink how long he expected his cross-examination of Andrew Manuel to last, Fink said about an hour. The judge announced the afternoon recess. However, when court reconvened, Fink stood up and simply said, "We have no questions for Mr. Manuel." The defense felt there was little to be gained by placing Andrew Manuel back on the stand, and lots to lose, if he messed up in redirect examination by the prosecution. To the informed eyes in the courtroom, it was difficult to discern who wanted Andrew Manuel off the stand more, the prosecution or the defense. 24. Family. Ties that bind sometimes strangle. Michigan State Police Sergeant David A. Like was called to the stand to testify for the prosecution against his nephew on Tuesday, July 28th. 1 year earlier, suspected blood spots shrouded by blotches of black spray paint on his basement floor led the then Corporal Like to report his nephew's suspected activity. Testifying for the prosecution, Sergeant Like explained how he and his family had just returned home from an 11-day vacation to visit his brother in Madison, Wisconsin, with a side trip to Beaver Island in Lake Michigan. "Can you give the court a time and date when you arrived home?" Prosecutor Delhey asked. "Tuesday, July 29th at 11:30 p.m. "Did you notice anything unusual when you got home?" "My wife noticed scuff marks on her clean kitchen floor, apparently made by rubber heels." "Can you describe the scuff marks in more detail?" "They were of varying lengths and looked like skid marks. Sandra mopped the floor before we went to bed." "Would you tell the court, Sergeant Like, what you discovered the next morning?" "At 8:30, my wife called me down to the basement. I could tell by her tone something wasn't right. She wanted to know if I had spray painted anything on the basement floor." "Had you?" "No. That's when I first saw 6 or 7 spots of black spray paint on the laundry room floor. The spots started at a door opening in the middle of the basement leading to the laundry room. They trailed to the dryer in the southwest corner of the basement. There was some black paint near the ladder, too." "What ladder?" "The night before leaving on vacation, I painted the hall ceiling, and afterward placed a homemade ladder on its side in the basement laundry room next to the oil storage tank. I finished around 10 p.m. Then my wife washed clothes and cut the boy's hair." "Did she cut your hair that evening?" "No, sir." "Where does your wife normally cut hair?" "In the basement, under the staircase landing across from the clothes dryer." "Tell us more about the spots of black spray paint. What size were they?" "They varied in shape and size. I didn't measure them." "Was there a black aerosol spray paint can in your basement before you left on vacation?" Prosecutor Delhey asked. "Yes, sir, there was." "Where did you keep it?" "In a storage cabinet on the east wall of the laundry room." "Did you find the spray can there when you returned from vacation?" "I looked, but couldn't find it." "Anything else out of the ordinary happened that day, Sergeant Like?" "Yes. I was due back at the state police post on Thursday, but I got a call from Corporal Brown telling me I should come down there, the Ypsilanti State Police Post. I was briefed by Captain Walter Stevens in his office and told my nephew was the prime suspect in the Beineman murder case. Afterward, I mentioned the black paint on my basement floor." With the Collins family glaring at David Like from the first row of the gallery, He continued his testimony. When I got home, I didn't know how to tell my wife her nephew was a suspect in the Beineman case. We tried to call John all day with no success to hear if he had a reasonable explanation for the paint. Sandra called her sister Loretta to see if John might be at his mother's house. What time was that? About 8:30 at night, Officer Like testified. Loretta told us John was out, but she would have him call when he got in. John called an hour later. After some small talk, I asked him about the scuff marks on the kitchen floor. He said he knew nothing about them. Then I asked John if he spray painted anything in the basement while we were gone. What was his reaction in response? After a brief hesitation, John said, "What paint, Uncle Dave?" I told him a can of black spray paint was missing. What was his answer? He said, "I didn't enter the house, Uncle Dave. I had no reason to." I asked John if someone could have gotten into the house while we were gone on vacation. John said he didn't notice anything unusual. He only watered and fed our dog in the garage. I told him I would have to report a suspected breaking and entering and the spray paint blotches to my post commander. John replied, "Let me know what they find out." After his nephew's denial, Sergeant Like said he and a detective friend scraped under the paint and placed samples in evidence envelopes to have them tested. Like did not reveal the results of the tests and was not asked to do so. Please describe for the court what happened the following day. I made my report to Sergeant Christian Walker, Assistant Commander of the State Police Post, and returned to my home with Staff Sergeant Carl Friedborn, Post Commander, to wait for the crime lab to arrive. When asked if the defendant had a key to his home, Officer Like testified that John had a key to the front door since 1967, but Collins told him he did not know where it was. I placed a key to the side door under the doormat, so John could feed our family dog while we were away. Did Mr. Collins ever return the key? Yes. No further questions at this time, Your Honor. Judge Conlon dismissed Sergeant Like, but asked that he return the next morning to begin his cross-examination by the defense. The last witness of the day was State Trooper Donald L. Collins, no relation to the defendant. He entered into evidence a scale drawing of the Like basement. The state trooper said he made the drawing on September 25, 1969. He presented the prosecution exhibit with a plastic overlay showing black spots representing the blotches of spray paint. There was no defense objection or motion to suppress the exhibit. Judge Conlon adjourned court until 8:30 the next morning. When court resumed, Sergeant Like's cross-examination was delayed to allow the prosecution to enter more exhibits into evidence. 10 color slides and 8 photographs of the Like house on Roosevelt Street were introduced into evidence by Michigan State Police Detective Thomas J. Nasser. The jury was not present, to give the defense a chance to view the items first. When the jury was settled in, Sergeant Like was recalled to validate the new photographic evidence entered into court. Like said all of the exhibits were true representations of his house and basement when he returned home from vacation, except for one slide showing an area where he had scraped some paint. All but that exhibit were entered into evidence. Now it was Joseph Louissel's turn to cross-examine Officer Like. The defense attorney asked the state trooper if his nephew John ever showed any interest in joining the Michigan State Police. We discussed things like salary, benefits, and retirement pay. What did you tell him? I told him to contact a district recruiter, but advised him to stay in school and complete his education. On the day the crime lab investigators were gathering evidence in your basement, what were you doing? I was upstairs trying to console my wife. What was your involvement on the day your nephew was arrested? As if matters were not already bad enough between the Like and the Collins families, this testimony spelled out the critical moment of family betrayal and John's last day of freedom. On the 31st of July, I went with Captain Walker Stevens to John's rooming house in Ypsilanti. We took John to the State Police Crime Lab in Plymouth. Captain Stevens contacted Robert Francis, an Ann Arbor attorney who was John's lawyer at the time. What happened next, Sergeant Like? At the crime lab, John was questioned by Captain Stevens. When Robert Francis got there, he denied police permission to fingerprint or photograph his client. Was John fingerprinted? Louisel asked. Captain Stevens and Mr. Francis got into a heated argument and voices were raised. Then John and his lawyers stepped outside to confer. What were you and Captain Stevens doing in the meantime? Captain Stevens called Prosecutor Williams. Afterward, Stevens asked John to re-enter the crime lab where County Sheriff Captain Mulholland arrested him for the murder of Miss Beineman. Then you were instrumental in the arrest of your nephew, were you not? I was present and a witness to it. Joseph Louisel made a dramatic pause. The courtroom was bereft of sound as the portly defense attorney lumbered to his next point. When your nephew was arrested in the middle of the night on July 31st, you were a corporal then? Objection, Your Honor. David Lyke's promotion is irrelevant to these proceedings and is calculated to discredit the witness. Would both attorneys approach the bench? The judge directed. Mr. Louisel, what are you driving at? I want to establish a quid pro quo relationship that speaks to the fitness of this witness's testimony. Judge Conlon, Sergeant Lyke is already in a difficult position, having to testify against his nephew with his in-laws glaring at him from the gallery. This line of questioning is irrelevant and misleading and should be struck from the record. That's all well and good, Mr. Delhy, but the issue is floating out there. If it isn't handled in court, the press will run with it. It may be best to get it out in the open and be done with it. The prosecutor reluctantly agreed and returned to his table. Proceed with your line of questioning, Mr. Louisel. Officer Lyke, I will ask you again. Was your promotion in any way connected with your testimony here today? Absolutely not. Then how do you explain the timing? I was up for promotion before this situation with my nephew developed. One thing has nothing to do with the other. Lyke was able to squelch Louisel's leading question and contain any collateral damage. Fair enough, Sergeant Lyke. You have testified a can of black spray paint was missing from your storage cabinet, did you not? Yes. Do you remember where you purchased the paint? Yes, I do. Do you remember when? Yes. Would you enlighten the court, please? I bought the spray paint at a hardware store in Flushing, Michigan when I was stationed at the Flint Post in 1967. Had you ever used it? Yes. After using it, couldn't you have thrown it away? Most of the paint was still in the can. I remember holding it upside down and clearing the nozzle, then placing it on a shelf in the storage cabinet. Doesn't your garage have an electronically operated garage door, Officer Lyke? Yes. Is it not true that when a button is pushed, the door opens and the light automatically goes on? Yes, but much of the time I unscrew the light so it doesn't go on. Was the door left ajar over your trip? The door was up about 18 inches from the driveway to give the dog some ventilation. Where was the dog food kept? In the garage. So there was no reason for your nephew to enter the house to feed the dog? None. Wasn't there a note on the fuse box left undisturbed when you returned from your vacation? Yes. You have previously testified your wife cuts your son's hair in the laundry room. Does she cut your hair as well? Usually. In the same place? Yes. At the same time? Not this time. My wife cut my hair a couple of days before. Does she ever cut more than 3/8 of an inch when cutting your hair or the children's? She may have. I don't know. This was an important point for the defense. Joseph Louisel was expected to claim the hairs found in Karen Sue Beineman's underpants could not have come from the Lyke basement, as some were longer than 3/8 of an inch. At this point, Louisel asked Judge Conlon if he and Neil Fink could view the Lyke basement and kitchen areas under discussion. Conlon asked Officer Lyke if he would agree. He nodded yes. The judge called for an early noon recess, so Prosecutor Booker T. Williams could personally escort both defense attorneys on a tour of the Lyke basement and kitchen area. Upon resumption of the trial, Louisel attacked Officer Like's refusal to allow the defense access to his home earlier in the investigation as obstructionist. Isn't it true, Officer Like, that you have been hostile to the defense in this case from the beginning? No, sir. Didn't you refuse defense attorney's admittance to your home previously? No. I wouldn't let you both come in at the same time with all of your investigators. Today wasn't your first opportunity to see the basement. Sergeant Like denied categorically he had refused the defense entrance to his home. In point of fact, Officer Like, didn't you, in the presence of another officer, tell my investigators to go to hell? No, sir. There was no profanity used. No further questions at this time, Your Honor. The oppressive atmosphere in the courtroom was aggravated by a July heat wave escalating the tension. Sandra Like was up next on the prosecution's list of witnesses. On her way to the stand, she looked at neither her sister nor her nephew. She was a woman torn between her sense of duty and justice toward her community and her conflicted blood ties to her relatives. It was evident the prolonged stress had taken its toll. Mrs. Like was a tortured witness on the stand. Sandra Like began testifying about when her family got home from vacation. She immediately noticed some fresh heel scuff marks on her kitchen floor, some as long as 6 inches, in front of the refrigerator near the stairwell leading to the basement. Are you certain they were not there before you went on vacation? Yes. Are you positive? Yes, I mopped the floor just before we left. I don't like coming home to a messy house after a vacation. The floor was clean. What happened to the scuff marks? I mopped the floor clean before I went to bed. Did you notice anything else unusual after you arrived home? The following morning, I went to the basement to wash the children's clothing and noticed their toys were moved and there was black spray paint on the laundry room floor. Then I did a load of laundry and reached for the ammonia container, and it was gone. Also missing were an empty Bold detergent box and an empty bleach bottle I placed on the washing machine before we left on vacation. David was supposed to throw them out, but he didn't. Anything else? There was a wet rag hanging on the edge of the laundry tub that was dirty and had hair on it. Was the wet rag there when you left? We were gone 2 weeks. It would have been dry by then. A slight chuckle went through the tense courtroom to the mild embarrassment of the prosecutor. Of course, Mrs. Like. What was I thinking? Let me rephrase the question. Was the soiled rag hanging on the laundry tub before the family left on vacation? No. It was clean and folded in the laundry room cupboard. What happened to the rag? It was soiled, so I threw it away. Mrs. Like admitted she unknowingly destroyed some evidence in this case. To contain the damage, Prosecutor Delhi asked Mrs. Like if she threw the rag out before or after she discovered her nephew was under suspicion for murder. Before, she said. Let's move on. Your basement is divided into a family room and a utility room, separated by a thin wall, the prosecutor said, pointing to the diagram exhibit. Is it not? Yes, a family room and a laundry room. Where do you cut your son's hair? In the laundry room, across from the clothes dryer. When was the last time you cut your children's hair? The day before we left on vacation. When I finished, I swept up the floor quickly because I needed to make some final preparations for the trip. Did your husband have any explanation for the paint marks? I asked David if he remembered painting anything before we left on vacation. Had he? He said no. What happened next? After trying all day to reach John in Ypsilanti, we called my sister in Central Line about 8:30 to see if he was home visiting his mother. Was he? Delhi asked. Yes, but he was out, and my sister said she would have John call me when he returned. It was painfully uncomfortable for Sandra Like to speak about her sister in the third person, with Loretta sitting in the front row, riveted to her every word. Did he ever call back? About an hour later, my husband and I talked to John and his mother in a four-way conversation. What did you talk about? I asked John how everything had gone while we were away. He said, just fine. I asked him what he had been up to in our basement. He said, what do you mean? Then we asked if he had painted anything in the basement. He answered, no, I didn't. No further questions, Your Honor. Under cross-examination, Joseph Louisel asked Mrs. Like, when did you first begin to suspect your nephew? The next day, when David came home early from work and told me John was a suspect, and the crime lab was on the way over to our house. How did you react to the news? With shock? Were you at home when the crime lab team arrived? I was weeping in bed much of the day. Where were your children? David sent them out to play baseball with the neighbor kids. When did you tell your husband about the missing items? The next day? Mrs. Like, this is what you wrote in October, to review and summarize the items missing or found different in your laundry room. This is your handwriting, is it not? Louisel handed the court document to Sandra Like. Yes, my husband asked me to write a summary of everything I remembered different from how we left it. I didn't write it with suspicion of him, Collins, being involved, but it was an essay of what I noticed missing in my house. Did you write it in October because you were more composed by then? I haven't been composed for a year, she snapped back. Of course not. Would you take a moment to read this copy of your October 12th essay? A brief moment passed before she looked up from her summary. Is there a word in that report about a missing ammonia bottle? No. Is there a word in there about a missing soap box? No. Is there a word in there about a missing bleach bottle? No. Is there a word in that report about a wet rag? No. Mrs. Like, before you left on vacation, did you leave a note for your nephew on the kitchen table telling him there was a watermelon in the basement refrigerator? Yes. Had the note been moved from where you placed it? No. The note was still on the kitchen table. Was the watermelon ever eaten? No. The watermelon was untouched when we returned home. No further question for this witness, Your Honor, Louisel said, sounding disappointed in the witness. Court was adjourned for the day. Mrs. Like, escorted by State Police Sergeant Earl James, walked briskly past Loretta Collins, who stared forward in benumbed silence. On Sandra Like's way out of the courthouse with her husband by her side, she collapsed from the ordeal and the withering heat. David Like carried his wife to their car and drove her to nearby St. Joseph's Hospital. Tensions were running high all day. It was grueling on the stand for the Likes, and a devastating day for the Collins family. 25. Science enters the scene of the crime. On Thursday morning, Dr. Marjorie Barnes was given her moment on the stand. She was a surprise witness for the prosecution. Would you identify yourself to the court and give your address, please? Prosecutor Delhy asked. I'm Dr. Marjorie R. Barnes, a science education consultant. I live at 615 Cornell Drive in Ypsilanti. Dr. Barnes, would you please describe your day on Wednesday, July 23, 1969, for the court? I was out of town between 11:30 a.m. and 3 p.m., but returned home to finish cleaning my house in preparation for a dinner party. Can you see the Like house from your house? Yes, I have a clear view of the west side of the Like house. Have you observed any unusual activity around the Like house? I knew the Likes were on vacation because once a day I noticed somebody coming by to take care of their dog. After July 23rd, I noticed the same person was at the house several times. Did you see him each time? No, usually I just saw his motorcycle parked on Cornell. Did you notice anything else? On the 24th or 25th, I saw this same person leave on his motorcycle with a large Bolt detergent box. Where did he go? He drove north on Cornell. Can you identify the person you saw on the motorcycle that day? He was not as tall as you, but approximately the same build. Maybe not as tall, but as big. Delhy was over 6 feet tall. Collins was 5'11". Do you see that person in the courtroom today, Dr. Barnes? She looked directly at the defendant and said, I can't be certain. Thank you, Dr. Barnes. No further questions. In his cross-examination of Barnes, Joseph Louisel asked if she told the police or the prosecution she could identify the person she saw going in and out of the Like House. I said I could not recognize the person as an individual, just his general stature and coloring. Where is your house in relation to the Like House, Dr. Barnes? Across the street. But not facing each other? That is correct. My house. Louisel cut her answer short. That's good, Dr. Barnes. You answered my question. What the defense attorney did not want Barnes to say was she literally had a picture window view of the side door of the Like House directly across the street. When did you give your statement to State Police Detective Gordon Hurley? On August 1st. All the neighbors were being questioned door to door. The detective asked if I had seen anything unusual within the last week or so. That's when he took the report. Did you discuss the incident with anyone else? No. What about the likes? Never. Wasn't there some confusion in your original statement to the police about the date you saw someone leave the Like House with the detergent box? Yes, I had to reconstruct my week, but I was able to narrow it down to 2 days, either that Thursday or Friday. Barnes produced several pages of notes on a small yellow pad and handed them to Louisel. He read them before handing her notes back. Louisel tried, but could not shake her from her testimony. How can you be certain the box you saw was a Bold detergent box? I had just received a free sample in the mail, so I recognized the packaging. Were you wearing your glasses at the time of this sighting, Dr. Barnes? Of course. I always wear my glasses. Dr. Barnes, isn't it true you refused to speak with defense investigators about this case? People other than police tried to question me, but I declined to discuss the matter with them. Why didn't you tell them what you knew? I decided not to talk to reporters or anyone. That's my right. Dr. Barnes, were you instructed by the prosecution not to cooperate with the defense in this case? No. The decision was mine and mine alone. I wasn't instructed by anyone to remain silent. Forget the reporters. These persons identified themselves as working on behalf of John Norman Collins. Why did you refuse to talk to them? I just didn't want to talk about it. I have no further questions, Your Honor, Louisel said. During redirect examination by Delhi, Barnes insisted there was no doubt in her mind she saw a man leaving the Like House carrying a Bold detergent box on either Thursday or Friday, a day or two after Karen Sue Beineman went missing. Assistant Prosecutor Booker T. Williams was slated to handle the scientific portion of the testimony. The prosecution strategy now shifted into the third stage of the people's case, the critical hair and blood evidence that marked the beginning of the scientific testimony. The prosecution needed to establish Karen Sue Beineman was in the Like family basement the day she was raped and murdered. First up to testify on the physical evidence was the commanding officer of the State Police Crime Lab, Staff Sergeant Kennard Christensen. He told the court, "There were fingerprints found in the Like basement which contained too few points of identification and could have belonged to either Mr. Collins or Miss Beineman. They were unidentifiable." Did you find any identifiable fingerprints? Of the 100 or so prints we lifted, all belong to the Like family as far as I know. I didn't personally lift the prints. Other detectives did. What part did you play early on in the investigation of the Like basement? Officer Like and I did an initial investigation. I got down on the concrete floor and used a spotlight to inspect the laundry room floor for evidence. Did you discover anything? Yes, I saw hair clippings and what looked like blood near the clothes dryer. At that point, I called for additional expert help. Did you test the possible blood spots covered by the black paint? Yes, I did. And what did you discover? Only one showed evidence of blood being present. Another detective tested another area on the floor and the wall. What were the results of those tests? I don't know, the Michigan State Police Crime Lab commander said. The autopsy reports a blow was struck to the face of Miss Beineman with a blunt instrument with enough force to break one of her front teeth above the gum line. Did you ever locate the weapon? I examined tools in a cabinet and a length of 2x4. Neither showed traces of blood or hair. Officer Christensen, we have a photo of a baseball bat leaning against the basement wall. Could that have been the murder weapon? No. Why not? Because it was a wiffle ball bat made of a light plastic that couldn't cause the injuries Miss Beineman sustained. Was any other evidence removed from the basement and brought to the crime lab for further analysis? Williams asked. Yes, there was. We took the bottom front of the clothes dryer, a children's shirt hanging in the laundry room, several pillowcases, samples from the floor, sweepings from a vacuum cleaner bag, and many fingerprints. Was the garage checked for fingerprints? Williams asked as an afterthought. Yes. What did you find? We didn't find any of Colin's fingerprints in there either. Not even in the dog's food or water bowl? None. Your Honor, the prosecution would like to enter into evidence 5 jars given to Detective Sergeant Christensen immediately after Karen Sue Beineman's autopsy was performed. Judge Conlon looked over at the defense bench, but no objection was forthcoming. The exhibits were entered into evidence. Prosecutor Williams questioned the state police detective about the contents of each. The first jar contains a yellow cloth taken from the throat of Karen Sue Beineman. There were no chemical tests performed, but the cloth was examined under a microscope by me and then given to another detective to examine, Christensen said. The second jar contains blood drawn from Miss Beineman's body. The third and the fourth jars contain hair samples pulled, and not clipped, from Miss Beineman's head by Dr. Robert Hendricks when he performed the autopsy. The final jar contains Miss Beineman's underpants, which were lodged in her vagina. What was the chain of custody for this evidence? The jars were taken by me immediately to the Plymouth Crime Lab, cataloged, and placed in a refrigerated vault. They were later taken to Lansing for further study. You saw the body in the location where it was discovered, did you not? Yes, we saw it together. For the record, would you tell this court what you saw that morning? Miss Beineman's body was found lying on its stomach in a wooded gully. Her right arm was extended over her head, and her left arm was tucked under her body. Her feet were crossed. The only clothing she had were her leather sandals. Was there the presence of hair or blood evidence on the sandals? No. We examined them carefully. The only piece of physical evidence found was the body. Were there any footprints found? Some at the edge of the road, but we determined they were made by our initial investigators. Were plaster casts made? No, sir. It was raining. Sergeant Christensen's lengthy report to the Washtenaw County Prosecutor's Office was handed over to Louis L., who asked for some time to read it before cross-examining Christensen. Judge Conlon complied and called an early lunch recess with the cross-examination to begin at 2 p.m. When the court was called back to order, it became apparent Christensen and Louis L. had known one another for a long time. Louis L.'s folksy interrogation of the state police commander was more like a conversation between neighbors across a fence than adversaries in a notorious murder case. How would you characterize the investigation of the Like basement? It was a slow, methodical, meticulous search for evidence. Did any fingerprint man find prints of the defendant or the deceased in the upstairs section of the house? Not to my knowledge, Christensen replied. And no fingerprint man has ever indicated to you that the fingerprints of the defendant or the deceased were found in that basement? That's right. My men did find prints in the house, but they contained too few common points for a positive identification of either party. Officer Christensen, were you involved in the mannequin incident? We discussed the possibility of substituting a mannequin for Miss Beineman's body and staking out the area in an attempt to catch the killer. We? Who exactly? The prosecutors seemed to be taking the lead. Wasn't County Sheriff Doug Harvey a party to this plan? Not to my knowledge, sir. Joseph Louisel was clearly disappointed. Earlier in the trial, he hammered away on the county sheriff, hoping Harvey perjured himself on the stand by denying direct involvement in the plan. But Christensen closed ranks and backed up Sheriff Harvey's testimony. Did you help implement the plan, Officer Christensen? No, but I heard about it later. Then your testimony is hearsay, isn't it? Objection. The defense is asking the witness to draw a conclusion about his testimony. Sustained, Mr. Williams. Much of the afternoon testimony focused on hair and blood evidence. Officer Christensen told Louisel, I don't feel legally qualified to be an expert witness on hair. Still, he testified that several hundred hairs were taken from Beineman's head and many things can be determined from a strain of hair. Did you examine the hair fibers yourself? No. Dr. Walter Holtz from the Michigan Department of Health Crime Laboratory took the samples and ran tests. Why was the yellow cloth found in Miss Beineman's throat only examined under the microscope for stains and not given any other treatments? Christensen replied, You will have to ask Dr. Holtz that question, Counselor. Were you able to determine the origin of the cloth? I had no way of determining where the cloth was made. It did have a seam in it, similar to a manufactured garment. It may have been a shop rag. But you don't know for sure, do you? No, sir. Before Christensen completed his testimony, the detective was instructed to walk to the scale drawing of the like basement and mark where he made his tests for the presence of blood evidence. The defense had no further questions for Commander Christensen. Sergeant Like, who had spent 2 hours on the witness stand the previous day, was recalled by Prosecutor Delhi to testify about the clippings of his and his son's haircut by Mrs. Like. Samples from each of us were placed in separate evidence envelopes, sealed, labeled, and turned over to State Police Lieutenant Harold Morrison, Sergeant Like said. Did you volunteer these samples, or were they requested? Lieutenant Morrison requested the samples. Did you require him to have a court order? No, sir. No further questions, Your Honor. Late in the day, the prosecution called State Police Lieutenant Harold Morrison. He became the 33rd witness to take the stand. He testified he received 4 envelopes containing the Like family hair clippings and turned them over to Dr. Walter Holtz at the State Department of Health in Lansing. In his brief cross-examination of Lieutenant Morrison, Louisel asked about an incident at the Like House on June 10, 1970, when Louisel and Fink appeared to inspect the basement. Was I refused admittance to the house? No, sir. You were invited in twice. Lieutenant Morrison contradicted the defense attorney. Didn't Sergeant Like say I couldn't go in if Fink did? Yes, Morrison replied. Wasn't there considerable profanity by you and Like? No, sir. Is it not true you conducted the same tests Neil Fink and our aide ran in the basement when they appeared there on June 10th? Yes. I felt it would be a good idea to have the same type of samples you had, for whatever value they might prove. The defense has no further questions for this witness, Your Honor. Next up to testify for the state was a forensic investigator from the Michigan Health Department, Dr. Curtis Fluker, who did much of the forensic lab work. Under direct examination by Assistant Prosecutor Williams, Dr. Fluker testified the hair clippings found in Karen Sue Beineman's underwear ranged in color from brown to blonde, and all were under an inch in length. When Louisel cross-examined Dr. Fluker, he disputed the hair evidence. Isn't it true that brown to blonde hairs can be found on any head of hair, which is called brown? No, that's not true, the lab expert replied. Isn't mounting hair on a dry slide, as you have done, a disapproved method of analysis? I don't know of anyone who has disapproved it, Fluker said. Isn't it true there are not enough differences in hair to determine a source? No. If I were to tell you the statement came from the FBI, would you still disagree? I've disagreed with the FBI before, and I would disagree on this point. Louisel produced a copy of an FBI law enforcement bulletin, which he handed to Dr. Fluker to examine. He looked at it for a brief moment and replied, "Mr. Louisel, this bulletin is dated August 15th, 1952. That was 18 years ago. Forensic science has come a long way since then. Would you describe for the court how you made your comparison?" With a high-powered compound microscope, I examined hairs taken from the victim's underpants and determined they were all head hair, ranged in color from blonde to brown. The ends were cut and probably came from a person with short hair. I can't conclude the hair clippings all came from the same person, though. All of Officer Like's sons had hair color ranging from brown to almost blonde, and each wore his hair close to cropped, as did their father. Dr. Curtis Fluker's testimony strengthened the state's evidence and the prosecution's case. So ended Thursday's testimony. Friday, before the morning session, Judge Conlon granted 3 of 4 defense motions raised by Louisel. The defense wanted County Sheriff Captain William M. Mulholland to appear to answer questions about the photos he showed Patricia Spaulding, the wig stylist who pointed at Collins in the courtroom the previous week. The defense attorney also wanted any witnesses who were involved in the mannequin incident to be called to testify. Louisel was determined to get the embarrassing episode into the court record. The third motion Conlon granted called for the handing over of all blood typing documents from the murder victim not attached to the original autopsy report. Judge Conlon denied a motion to force the prosecution to call 4 alibi witnesses who were already scheduled to testify for the defense. The judge remarked, "This goes beyond that which is required of a prosecutor. The court does not think the prosecution should be required to provide a character witness for the defense." With the jury called and settled into the box, Dr. Walter L. Holtz became the 35th state witness. He identified himself and outlined his scientific training and background for the court. For the last 5 years, he has served as chief of the Michigan Department of Health Criminalistics Division in Lansing. He was called to investigate the Like basement, the alleged scene of the assault and murder. Williams handled the scientific portion of the people's case. Would you tell the court how you went about your investigation and what you discovered, Dr. Holtz? I got down to eye level on the basement floor with a special ultraviolet light. I discovered some rust-colored spots near the clothes dryer, which were proven in the lab to be human blood. Dr. Holtz, is there anything else you could tell from the spots on the floor? The drops were tear-shaped, which indicated they came from the direction to the left of the clothes dryer and perpendicular to the wall. Were these drops covered with black paint? No, but I also ran tests on those spots under the paint. And only one of those spots tested positive for blood. The rest were varnish stains. Were you able to test for blood type? Yes. It was type A. Did you find other blood evidence in the basement? I saw a red-brown stain on a boy's blue and white striped shirt, which was hanging over a barbering gown, Sandra Like's dental hygienist tunic, and 2 moist rags found in a potato sack between the clothes dryer and the west wall. Were these items tested in the lab? Yes. The shirt tested positive for blood. Dr. Holtz, did you transport any evidence to Dr. Samuel Golub in Dedham, Massachusetts? Yes, I did. I took underclothing removed from Miss Beineman's body at the autopsy and segments of clipped hair found on the clothing. Did you take any other evidence to an out-of-state agency for examination? Yes, I went to Gulf General Atomic Laboratories in San Diego, California. What was the nature of that trip? I brought hair clippings found in the Like basement and 4 envelopes with samples of clippings from the 3 Like boys and Sergeant Like for examination. How large was your sampling of hair clippings? Williams asked. More than 500 segments of hair were removed from Miss Beineman's undergarment, and a greater number were recovered by investigators from the floor of the like home. Over mild objections by the defense, Judge Conlon admitted into evidence Beineman's underclothing and 3 separate lots of hair evidence. The clippings taken from Karen's underwear, clippings recovered from the like basement floor, and clippings collected from the heads of 4 like males and placed in separate envelopes. Dr. Holtz testified he examined the hair found on the underwear and the hair taken from the like basement floor and found them to be similar in all respects. All the hairs were Caucasian, all were from the head, all ranged in color from blonde to dark brown, all were less than an inch in length, all matched according to the 3 hair segments, the 2 outer layers and the core, and all had been cut with electric clippers. Dr. Holtz, how did you reach the conclusion the hair was cut by electric clippers? I'm convinced for 3 reasons. Both ends of the hair were cleanly cut. The hair was cut very short, and there were partial cut marks on some hairs, as if the clippers brushed the hair but not cut it. Had scissors been used, there would be partial cutting marks on both sides of the hair. He produced an envelope containing material found in front of the clothes dryer, 3 slide mounts of hair found on the floor by the clothes dryer, and 4 mounts of hair taken from the underwear, which the prosecution entered into evidence. Under cross-examination, Joseph Louisel attempted to discredit the scientific testimony of the prosecution's criminology expert. Dr. Holtz, isn't it true that after your visit to our defense expert witness, Dr. Samuel Golub, in Dedham, Massachusetts last May, you discarded the comparison base of the hair? No. Didn't you advise the prosecution we'd better forget about the angle business after Dr. Golub showed you how to measure the angles of hair correctly? Absolutely not. In open court, the criminalistics chief restated his scientific conclusion. The hair segments found in the underclothing of the victim are the same as the hair clippings found on the basement floor of Sergeant Likes' house. After 3 days on the stand being pounded by Louisel, Dr. Walter L. Holtz was excused. His unyielding testimony considerably strengthened the prosecution's case. With a surprise defense motion toward the end of the day's session, Judge Conlon recessed court early so the jury of 7 women and 7 men could view the alleged scene of the crime firsthand. In addition to the 14 jurors, defense attorney Fink and 2 sheriff deputies arrived at Officer Likes' home just before 4 o'clock. They inspected the basement laundry room the prosecution contended was the murder site. What the defense hoped to accomplish was unclear. All of the evidence was removed almost a year earlier. With the exception of the close quarters and placement of the utility room fixtures, the only possible evidence to see was several black spots sprayed on the concrete basement floor. 26. The mannequin debacle. Tuesday's testimony centered on the failed mannequin stakeout. This was the first public account of the incident since it happened the night of July 26, 1969. An Ann Arbor News account of the Running Man the previous year claimed someone approached the mannequin, bent down, looked at it, and then fled through the woods. The newspaper report also said shots were fired at the fleeing man. Prosecutor Delhy denied the report at the time. But for over a year, the public wondered if the mysterious running man was Karen Sue Beineman's killer. Had he slipped through the police dragnet? Prosecutor Delhy did not list any of the stakeout duty officers as prosecution witnesses because he knew their testimony was irrelevant to their case. The defense would portray the debacle as evidence of police incompetence. The Detroit Free Press article at the time labeled the stakeout a Keystone Cops operation. The prosecution did not want the incident brought up in open court. It was embarrassing and could result in a mistrial if not handled properly. The defense believed the mannequin trap provided an alibi for their client. Based on the belief that only the killer would know where the body was dumped, this unknown runner must have been the guilty man. The defense contended their client was in Ortonville, Michigan, 60 miles away, riding dirt bikes with friends. They were prepared to call 6 witnesses to testify about John Collins' whereabouts the night of the stakeout. 4 of 9 officers on the stakeout reported seeing the runner. They each were called to testify. John E. Markwell, with EMU Campus Police; Washtenaw County Sheriff's Deputy Basil Basinger; EMU Campus Police Officer Paul Dufresne; and Sheriff's Deputy Eugene Alley. Delhi was irked the defense insisted on calling the stakeout team. Because Judge Conlon granted their motion, Delhi added them to his master list of witnesses. All he could do was point out to the jury that the police were being called only at the behest of the defense lawyers and under a court order by Judge Conlon. Each officer, in turn, told of being assigned to the stakeout in the area where the body was discovered. The stakeout team was aware a mannequin was substituted for Beineman's body in the gully. Assistant Prosecutor Williams instructed the men to apprehend and identify anyone who approached the body drop site. The officers were cautioned not to fire their service revolvers. The team was told to show up in SWAT uniforms and bring plenty of mosquito repellent. The officers were deployed around the site at 10 p.m. 3 of the men were positioned across Riverside Drive, the dirt road across from the gully. They were hidden behind trees and brush. All of the officers said it rained steadily most of the night. 2 unmarked police cars, each with 2 officers, were hidden strategically nearby, and 2 officers were stationed at Dr. Mason's house, which served as their impromptu command center. Sergeant Markwell stated in his testimony that he was briefed by Lieutenant Bourdin and Prosecutor Williams at the crime center on Washtenaw Avenue. What was the reasoning behind the stakeout? Louis L. probed. The decoy was planted, said Markwell, because in 2 previous area murders, we, police, had evidence indicating someone returned to either the murder scene or where the body was dumped. The man I saw appeared for a split second, but the road turns and he disappeared behind the hill where we were stationed. The testimony referring to previous area murders was allowed into the record. The defense could not object, because Louis L. opened the door with his inquiry. Where were you positioned, Officer Markwell? I was paired up with Sheriff's Deputy Basinger, hidden among the trees and rough brush on a rising across Riverside Drive, opposite the decoy. We were positioned about 75 feet away in a shallow gully. What time did you see this phantom runner? Sometime after midnight, I spotted a man running full out on Huron River Drive. Did you call out to him? No, it happened so fast. I held a slight conversation with Deputy Basinger, whether it was justifiable to take action. We tried to call our commander on the handheld radio, but it wasn't working. By the time the scout car was contacted, the running man was gone. Would you be able to identify this running man if you saw him again? No, sir. Did anything else noteworthy happen that evening, Sergeant Markwell? About 45 minutes after the sighting, a tracking dog was brought in, and he picked up a scent. It led the canine officer and a couple of deputies to a house party in full swing half a mile down the road. Is it possible the suspect slipped into the party? Possible, but unlikely. We didn't check because we didn't want to draw the attention of the partygoers to our investigation. Is there anything else you can tell the court about that night? As the night wore on, a car passed the area 4 times and was stopped by sheriff's deputies and released. While we repositioned ourselves, taking the natural cover on Huron River Drive, another car went past and stopped around the bend. It sounded its horn 3 times, then it took off again. When I tried to radio a police interceptor to chase down the vehicle, the radio failed to work. Didn't another car come by, which aroused suspicion that night? The defense attorney led the witness. Yes, a 3rd car came by with people screaming and yelling out the windows. Were they stopped and questioned? Yes. Who were they? People from the party. The gallery laughed. Sergeant Markwell was dismissed, and Sheriff's Deputy Basil Basinger uncomfortably approached the stand. Neil Fink took over for Louis L. and questioned Basinger. The sheriff's deputy told of seeing a running man after midnight going in a southerly direction. He appeared to be wearing light clothing. I saw him for a fraction of a second. No one shouted, and no shots were fired. Did you see his face, Deputy Basinger? No, sir. Was there any physical evidence this runner left? Fink asked. I found what appeared to be a footprint in the mud near a string of mailboxes on Huron River Drive. I carefully placed my coat over it. Did you tell your commanding officer? Yes. Was a plaster cast made of the print? No. Were any photographs taken of the footprint? No. Why not? Continued Fink. The officer in charge said it was an investigator's footprint and dismissed it. What happened next? We tried to make radio contact with a police car, but our radio phone wasn't working. We made contact about 4 minutes after we saw the runner, but he had disappeared by then. I went up to the house where our field headquarters was, on Dr. Mason's front porch. Did you hear any of the officers tell Dr. Mason we've made a contact? We had not made a contact. Why didn't you shout out to the running man, Deputy Basinger? I felt it might be someone running to get in from the rain, and if it wasn't the person we were looking for, I didn't want to give away our position. It was now EMU patrolman Paul Dufresne's turn to testify. He told Louis L. he had only been a policeman for 2 months, with no formal police training, when he was volunteered for the stakeout. It was pretty rough that night, wasn't it? The rain was bad enough, but the mosquitoes were worse. Where were you stationed? Closest to the mannequin, about 60 feet away. Did you see the running man? Yes, running southeast across Riverside Drive where it comes out at Huron River Drive. I only saw him for a second. Did he hesitate or look down toward the gully? No, he was jogging. Were there any shouts or shots fired? No, sir. Prosecutor Williams instructed us not to shoot our service revolvers. Did you make out a written report of the incident? No, but I made a verbal report to State Police Detective Max Little. How long did you remain on duty in the area? Throughout the night and until 1 p.m. the following day, the rookie officer said. No further questions for this witness, Your Honor. The fourth and last officer from the stakeout team was Sheriff's Deputy Eugene Alley. Prosecutor Delhy asked him to point out on a rough sketch made by Dr. Mason the first day of the trial where the various members of the police team were stationed. Much to the chagrin of Prosecutor Delhy, when it was the defense's turn to cross-examine Officer Alley, Louisel had no questions. After all, it was at Louisel's insistence that Alley and the other policemen were summoned into court. Delhy knew dredging up this incident was a defense diversion to distract the jury from the damning scientific evidence presented by the prosecution. Sheriff's Captain William M. Mulholland was called to the stand for the second time Tuesday, both times at the insistence of the defense. Showing his impatience with defense counsel, Prosecutor Delhy took less than 10 seconds for his direct examination. What is your name, rank, and length of service with the Sheriff's Department? Captain William M. Mulholland. I've been with the Sheriff's Department for 15 years. No further questions for this witness. Neil Fink handled Mulholland's cross-examination. You showed Mrs. Patricia Spaulding of Wigs by Joan some photographs on August 1st, 1969, did you not? I showed 8 photographs to Mrs. Spaulding. 3 were of Collins, and the others were of jail inmates with jail numbers across the bottom. What did Mrs. Spaulding say to you after viewing the pictures? She said she wouldn't identify the man on the motorcycle from a photograph. Let me ask you about Sue Bonner. She testified that on the afternoon of the murder, she walked past Collins on Ballard Street while he was talking to a girl she didn't know. Do you remember that testimony, Captain Mulholland? Yes, I do. Miss Bonner was walking on Ballard Street the same day Miss Beineman disappeared. Did you state at one time that Sue Bonner, if pressured, would say the girl Collins was talking to was Karen Sue Beineman? But she wouldn't make a good witness in court? I don't recall that wording, Officer Mulholland replied. Neil Fink demanded to see the report Mulholland filed after his interview with Bonner. The prosecution produced the report, and Fink read from it. Sue Bonner can't be sure, but if pressed, would identify the girl as Beineman, but it will do no good in court. Captain Mulholland, is this sentence in your report? Yes. No further questions, Your Honor. No redirect, Your Honor, Delhi said. 27. Radioactive evidence. The last of the prosecution's scientific evidence was ready to be presented in open court. Dr. Howard L. Schlesinger, a forensic chemist from the Gulf General Atomic Laboratory in San Diego, California, was flown to Michigan to testify. He outlined his experience and education. When asked to tell the jury what a forensic scientist does, he explained that he dealt with evidence in criminal and civil justice proceedings. Dr. Schlesinger, the current head of the Activation Analysis Group, explained to the court, in layman's terms, the process of neutron activation analysis, NAA, the most recently accepted method for comparing hair. This method of analysis uses the bombardment of atoms with neutrons, which converts some atoms into radioactive material and then later detects this material. The process identifies large numbers of chemical elements in a sample and tells how much is present. The forensic scientist testified he was given several vials of hair samples taken from Beineman's underpants, the basement floor of the Like home, and known samples from the heads of the 4 Like males barbered by Mrs. Like. After washing the hair to eliminate possible human contamination, Dr. Schlesinger exposed all of the hairs to radiation for 1 minute, and after initial analysis, exposed the hairs for an additional 60 minutes, and tested them again. The floor and panty samples were then exposed for another 50 hours of neutron radiation, and more tests. After each bombardment, he counted chemical elements found in the samples. Dr. Schlesinger said he found 12 elements that all the hairs had in common. Once chromium was eliminated for technical reasons, he found cobalt, manganese, gold, mercury, tin, zinc, selenium, antimony, chlorine, bromine, sodium, and potassium. The last 4 elements were eliminated for comparison purposes because they could have come from another source, such as the washing of the hair fibers before testing. The first 9 elements were part of the internal structure of the hair. When Assistant Prosecutor Williams asked about the accuracy of his data, Schlesinger declined to quote mathematical probabilities regarding how many other people might have hair with the same chemical composition. He testified, "It's difficult to come up with straightforward figures. It's difficult to say. The percentages could be 25 or 35% different either way." During cross-examination, Fink asked, "Dr. Schlesinger, are your forensic observations objective and scientifically certifiable?" The scientist answered, "In many cases, subjective evaluation is based on our own previous experience when making a conclusion. I know what the prosecution hoped would be the results, but there has been more than one occasion where I have testified opposite to what my client had hoped for." "So what is your conclusion on the hair evidence in this case?" "As a result of my analysis, my conclusion is that with a high level of probability, the hairs taken from the victim's panties came from the same source as the hair from the basement floor of the house where police believed Miss Beineman was killed." Maybe for spite, or because Neil Fink wanted to jab Prosecutor Williams, Fink ended his cross-examination with this question. "Did you know, Dr. Schlesinger, that the prosecution tried to get Dr. Jervis, our defense expert, to be a witness for them?" Prosecutor Williams rose from his chair and objected. "That's absolutely not true." Before the judge could rule on it, Fink said, "I withdraw the question, Your Honor. No further questions for this witness." The final prosecution witness was Dr. Schlesinger's former supervisor, Dr. Vincent P. Gwynn, currently a professor of radiochemistry at the University of California, who had been flown in at the people's expense. Dr. Gwynn testified, "The panty hair samples were remarkably similar to the other samples. It is definitely very feasible to state the panty hairs had the same origin as the hairs from the floor and the heads of the Like males. We used charts for each of the elements to calculate the probability of our conclusions with straightforward, simple arithmetic." He categorized 800 hair clippings into smaller groups until he reached 4 groups, the same number of male members in the like household. During his calculations, he came up with the following conclusion. A conservative conclusion, an unbiased calculation allowing for some possible correlation of accidental match. The chances of it happening again are 6 times 10 to the 7th power. In other words, if you took all 200 million people in the United States, there might be 30 groups of 4 people in the country with the same percentage of the same elements in their hair. Have you ever testified in a court of law before, using neutron activation analysis as evidence, Dr. Gwynn? Finn inquired. No. The Collins trial is the first I know of in North America to have NAA entered into testimony in such a crucial manner. Then Mr. Collins is being used as a guinea pig? Objection, Your Honor. Prosecution Williams jumped out from his seat. The use of the word guinea pig is prejudicial. Sustained. Strike the remark and the question from the record, Judge Conlon instructed the court reporter, while raising an eyebrow at the defense attorney. Neil Fink continued, undeterred. Dr. Gwynn, have you ever been asked to compare samples from 4 possible sources before? This is my first experience comparing samples from 4 unknown samples, but I believe my calculations are sound, and I'm willing to defend them. No further questions for this witness at this time, Your Honor. Williams asked that the hair evidence and lab report results be entered into the record. Over the vocal objections of the defense team, the prosecution rested its case with a flourish. Now it was up to Joseph Louisel and Neil Fink to make the best case they could to prove the innocence of their client. 28. The defense case. Shortly after 9:35 on Thursday morning, without the jury present, Neil Fink made the first of 5 motions before calling his first witness. Addressing the judge, Fink asked for a directed verdict of not guilty. I just can't believe it. It is inherently incredible. To permit this case to go on to the jury would be an injustice. I just do not believe if this were not the Collins case, it would ever go to the jury. The judge denied the motion, saying, the evidence, if believed, places the deceased in the basement through her blood type and hair samples. There is evidence, if believed, which could result in the jury's finding the defendants guilty, and I believe it's enough for this case to go to the jury. Neil Fink's rationale for a directed verdict lacked specificity, was factless, and sounded hollow to courtroom observers. It was an inauspicious beginning for the defense case. Undeterred, Fink called to strike the testimony of Dr. Walter L. Holtz, which drew the conclusion the hair clippings on the like laundry room floor matched the hair clippings found in the victim's underpants. I don't think saying the words makes it so, said Fink. It's making a guinea pig of Collins, which is grossly unfair. Objection. Sustained, Mr. Williams. Mr. Fink, refrain from referring to your client as a guinea pig. Judge Conlon denied this motion on the same grounds as the first. The scientist's conclusion is a question of fact for the jury to decide if acceptable, Counselor. Next, Fink asked for a motion to strike the testimony of the prosecution's expert scientific witnesses, Dr. Howard Schlesinger and Dr. Vincent P. Gwynn, as an attempt to validate their research findings using a technique never before used in a court of law. Their figures on neutron activation analysis and statistical probability will overload the jury. Once again, Judge Conlon denied the motion, saying both men were qualified as expert witnesses. It would be up to the jury to decide how much weight to give their testimony. Neil Fink's fourth motion was a request that all police statements taken from defense witnesses yet to be called be turned over to the defense immediately. This began an argument between the attorneys that Judge Conlon shouted over to be heard. Prosecutor Williams argued, "These are defense witnesses. There is no reason why we should provide the defense with our reports. There might be a time when we would ask for their reports." Neil Fink threatened, "If you ask that in front of the jury, we'll move for a mistrial." Judge Conlin assured the defense attorneys they would not be asked to provide reports on their witnesses. The law only applies to prosecution witnesses, so the defense cannot demand prosecution investigative reports on their own witnesses. Neil Fink was 0 for 4, but he presented one last motion. The fifth motion called for the prosecution to produce a receipt for a motorcycle chain ordered by Collins on July 22nd and paid for the next afternoon, when Karen Sue Beineman was believed murdered. The judge granted the request, and a police officer was sent to the crime center to obtain the receipt. In an offhand remark, Fink was heard to say, "Maybe we'd better have a perpetual motion in this case." "This perpetual case is a perpetual motion," commented the unamused judge. The first of the defense's 5 alibi witnesses was Joseph Dudley Patton, owner of J&J Cycle, located just east of Ypsilanti city limits. Joe Patton testified that John Collins came into the shop between 1 p.m. and 1:30 p.m. to pay a motorcycle repair bill. "I told him I would take his money when I was done eating my lunch." "Can you fix the time?" "Me and my crew usually take lunch at the same time every day." "How did Mr. Collins appear to you when he entered your shop?" "Nothing unusual, I'd say." "Would you come over to the Blue Triumph and examine the handlebars, Mr. Patton?" "Sure." The motorcycle shop owner approached the Triumph 650. "Do you see any marks from a mirror being attached to the handlebars?" "No, but sometimes people place tape on the chrome to prevent them from being scratched." "Did you ever see a square mirror on this motorcycle?" "No, sir." When William Delhey took over for cross-examination, he introduced a typewritten statement Joseph Patton admitted signing after he talked to Sergeant William Canada on September 17, 1969. "The statement you signed has 2 p.m. written on it, but it was crossed out and 1 p.m. was inserted as the time Collins was in your shop. Was it not?" "I recall telling him, Sergeant Canada, he was supposed to make corrections," Joe Patton told Delhey. Fink objected to admitting the statement into evidence because of stray marks on the document. The judge said he would not admit it into evidence, but it could be used by the prosecution to refresh the witness's memory. "Is it possible Mr. Collins could have come into the shop as late as 2 p.m.? Delhey asked. "I don't think so. It would take a real emergency for me to eat lunch that late." "No further questions at this time, Your Honor." Former J&J mechanic John Lado, who was now living in Toledo, Ohio, was the second alibi witness called by the defense. Lado said Collins came into the shop at about 1:15 p.m. and hung around for 45 minutes to an hour. "I signed the same statement as Joe, but changes were made after I signed it." Lado claimed Collins was in the shop at 2 p.m. and maybe as late as 3 p.m. During Prosecutor Delhey's cross-examination, Lado said there was a typographical error in the police report regarding when Collins was in the shop. "What time should it have been, Mr. Lado?" "I heard the approximate time he left from another person in the shop." "Oh, so you're basing Collins' appearance in the motorcycle shop on what someone told you? On hearsay and not first-hand knowledge?" "Well, yes." "I move to strike this witness's testimony from the record, Your Honor." "Sustained." No further questions. The third alibi witness was J&J motorcycle salesman Donald H. Kaufman. The jury was excused for the first part of his testimony to hear charges that he was harassed by Sergeant Canada during his questioning. Neil Fink began. "Would you explain to the court where and when this happened, Mr. Kaufman?" "A friend of mine who had just gotten a weekend pass from basic training woke me up at 7:30 a.m. to go drinking with him and some other friends. We went to the Union Bar. The only one we knew was open that early. Shortly afterward, Sergeant Canada came in and asked me to talk with him outside. I went out, and he told me to get in the squad car. I wasn't too pleased, but had cooperated in the past and saw no reason to stop now. I was interviewed numerous times at the shop already, but by that time, I would have gone along with anything they wanted me to say. They? Asked Fink. Who was the other person in the squad car? The other man wasn't introduced to me. What did they ask you, Mr. Kaufman? While in the police car, this other person asked if I remembered a person named Patrick Henry in the shop on July 23rd. I said I didn't. They told me I had to remember because I sold him a bike that day. Officer Canada told me I would be perjuring myself if I didn't remember. He threatened me with perjury. Fink made a show of directing the judge to protect Donald Kaufman with immunity. Judge Conlon preferred instead to counsel the witness to tell the truth. There can't be any perjury if you have no recollection. You have a right to say that. Don't worry about perjury unless you are perjuring yourself, Mr. Kaufman. An angry flurry broke out between Fink and Delhi over the interview taped in the back of the squad car. As far as this so-called harassment goes, Delhi said, we have a taped statement we'd like to play for the jury, recorded October 23, 1969. I'm going to move for a mistrial if the prosecutor in the presence of the jury again threatens to play a tape about something it is implied the defense doesn't want the jury to hear. Fink threatened. There are sinister connotations to the jury when Mr. Delhi threatens to play the tape. The court is not convinced such a mention has a sinister connotation, Conlon said. The jury has heard the tapes before. Bailiff, call the jury, please. Kaufman again went through his testimony about the Union Bar and the squad car interview. He fixed the time Collins was in the motorcycle shop at between 12:30 p.m. and 1:30 p.m. on July 23rd. The alibi witnesses did nothing to bolster the defense argument that Collins was at J&J Cycles when Karen Sue Beineman died, and therefore could not have killed her. So far, the defense was not connecting with its own witnesses, much less the jury. Fink decided to take a different approach, hoping to discredit the testimony of Dr. Marjorie Barnes, who said earlier she saw a man riding a motorcycle one-handed, leaving the like home holding a Bold detergent box. Fink asked the motorcycle salesman, "Is it possible to start up and drive away on a motorcycle one-handed?" "That would be impossible," Donald Kaufman said. "Your witness." Prosecutor Delhi inquired on cross-examination, "Couldn't an expert rider balance such a box sitting on the gas tank between his outstretched arms and still operate the hand controls of the motorcycle?" "It might be possible." "I can assure you it is possible, Mr. Kaufman." "Objection," Fink blurted out. "Prosecutor Delhi's statement assumes a fact not in evidence." "Sustained, Mr. Fink." "Were the police officers who questioned you in or out of uniform?" "Out of uniform." "Was the car marked or unmarked?" "Unmarked." "So it wasn't a squad car?" "It was an unmarked police car." "One more thing, Mr. Kaufman. What was Collins wearing the afternoon he was in the motorcycle shop?" "Blue Levi's and a yellow and green striped T-shirt, I think." "Were the stripes vertical or horizontal, Mr. Kaufman?" "Horizontal." "Are you certain?" "Positive." "No further questions, Your Honor." The fourth employee of the cycle shop to testify for the defense was John McDougal. He testified Collins was in the shop between 12 noon and 2 p.m. "There was nothing unusual about his behavior. I spoke with him for about a half an hour." McDougal also described the T-shirt Collins was wearing that afternoon in the shop. This witness had nothing new to add and was dismissed. The day's briefest testimony came from the fifth and last alibi witness, Michelle Flanders, a Michigan State University co-ed. She told the court she was in Ortonville, Michigan with Collins and several other persons throughout the day and evening of Saturday, July 26th, the night of the mannequin stakeout. Her testimony was calculated to refute the widely held belief that Collins was the running man seen by undercover policemen. If Collins was in Ortonville, the implication was that law enforcement allowed the real murderer to escape. Delhi wanted to ignore the incident completely and had no questions for Flanders. On Friday, August 7th, the defense brought in the first of their scientific hair experts to refute the testimony of the prosecution's experts. Dr. Auseklis K. Parkons from the University of Toronto in Ontario identified himself as a self-employed hair evidence expert. Parkons explained he held a doctorate degree in nuclear chemistry with a neutron activation analysis (NAA) specialty from the University of Toronto. His doctoral thesis was on the comparison of the individual characteristics of human hair using NAA. He wrote the element comparison tables used by prosecution experts in their testimony. Parkons described himself as a protege of Dr. Robert L. Jervis, a University of Toronto hair evidence expert who pioneered the NAA methodology of comparing objects using neutron bombardment. Jervis's method was used by the prosecution's experts. Both prosecution expert scientific witnesses testified hair clippings on the like basement floor, samples taken from each of the like males, and hair clippings found in the victim's underpants all came from the same source. Dr. Parkons testified that only 4 of the 8 essential elements for a valid comparison were found on the hair clippings of the underpants, when matched with the hair clippings found on the like basement floor from the heads of the like children. He said 2 other necessary elements did not match at all. Armed with Dr. Parkons' conflicting scientific testimony, Fink continued to undermine the testimony of the prosecution's expert witness, Dr. Holtz, chief of the Michigan Department of Public Health Criminalistics Division. Dr. Parkons, are you familiar with any authorities who maintain that the microscopic examination of hair is an unreliable method of hair comparison? Yes, sir, I am. The microscopic analysis of hair is subjective and could be classified as an art, depending to some extent on the experience of the examiner. Neutron activation analysis brings examinations up to the level of science. Microscopic examination of hair was the only method used until 10 or 15 years ago, but it is unreliable. Can you provide the court with a list of references supporting your opinion that microscopic analysis of hair is unreliable? Yes, he answered, submitting a prepared list of references cited in his doctoral thesis. Prosecutor Williams asked for a recess so he could study the reference material. Williams was given the difficult task of questioning the top experts in their field about this highly technical, state-of-the-art scientific process. Both prosecution expert witnesses from San Diego stayed on as scientific consultants to assist him. After an extended lunch recess consulting with his experts, Prosecutor Williams asked Dr. Parkons in cross-examination if it was true there exists a wide variation in trace analysis of different hair samples. Prosecution and defense experts agreed there was a 32% variation in the hair found in the like home. When asked to make a probability calculation in this case, Dr. Parkons refused, saying, "Because of the mixture of hair from 4 different people, the variables are too great to produce a credible figure." Next up for the defense was Dr. Robert Jervis, professor of applied chemistry at the University of Toronto, and the father of neutron activation analysis. After stating his background and qualifications, Jervis told the court that neutron activation analysis was currently the accepted scientific procedure in the examination of hair, when there was a large enough sample for testing. Fink asked the leading world expert on hair fiber analysis his opinion on the evidence in this case. Jervis weighed in. The hair from the like home does not have the same sources as the hair found in the underclothing of the victim. Without prompting, the researcher continued to assert, "I do not feel there is scientific support for the comparison of a mixture of hairs in this case. I feel many more samples should have been collected from the basement for analysis." Under cross-examination by Williams, Jervis admitted there is sometimes a variation of from 10 to 50% in elements found in hair from the same person's head. Dr. Jervis, would you agree Dr. Vincent Gwynn, witness for the prosecution on Wednesday, is among a small number of scientists who are knowledgeable about research projects involving hair analysis? Yes. On another matter, in a Canadian murder case, did you and several other University of Toronto scientists analyze hair samples for the Royal Canadian Mounted Police? Yes, we did. Is it not true that only 2 trace elements were found in hair analysis, as reported in your publication, about this case? No, about 7 elements were found in that study, Jervis responded. But you used only 2 elements, Williams quickly followed up. These 2 elements were the easiest to compare, the research scientist conceded. Under redirect by Fink, Dr. Jervis admitted he did not testify on the case cited, but 2 of his associates did. The case was in 1958, the 3rd year of attempts to analyze hair by neutron activation analysis. Under recross-examination by Williams, Jervis admitted he had not personally examined trace elements using NAA protocol since 1964, 6 years earlier. With that, Conlon adjourned the trial at noon, so he could meet with the attorneys in closed chambers to discuss arrangements for the Monday appearance of Dr. Samuel Golub of Boston, Massachusetts, an expert witness on hair analysis for the defense. Conlon also granted a prosecution request to have the jury tour the site where Beineman's body was discovered. The jury spent an hour examining the wooded gully just east of the Ann Arbor city limits in the sparsely inhabited area off Huron River Drive. A spokesperson for the defense team, who asked not to be identified, told the press that John Norman Collins might take the stand in his own defense next week if an arrangement with the prosecution to restrict the scope of the testimony could be agreed upon. Collins' attorneys were reluctant to let their client take the stand, because that would open him up to punishing cross-examination. Court observers speculated if the cross-examinations were not prolonged, the jury could be given the case and possibly return a verdict by the end of the following week. If a guilty verdict was returned in the Michigan case, the California case of murdered 17-year-old Roxy Ann Phillips might never reach the California courts. A guilty verdict in the Michigan case would bring an automatic life sentence. If Collins was found innocent, or if a mistrial was called, California authorities would petition to extradite Collins to Monterey County to face a grand jury indictment where it was believed they had a strong case against Collins. Delhi had serious concerns if Collins was released to California to face charges, since he could possibly be acquitted there. Then Collins would be released in California and never formally returned to Michigan. That was a risk Prosecutor Delhi was unwilling to take. Chris Bronson, a secretary in Delhi's office during the Collins case, remembers the California extradition issue this way. Prosecutor Delhi's long-term plan was to prosecute Collins with successive murders one after the other until Collins was imprisoned permanently in Michigan. William Delhi had enough evidence on each of the unsolved Michigan slayings to proffer charges against Collins in the event his lawyers were able to secure an acquittal or win an eventual appeal in the Beineman case. Monday, August 10th, the 4th week of the trial began. Dr. Samuel J. Golub, Assistant Director of the Fabric Research Laboratory in Dedham, Massachusetts, was the 8th defense witness called. Are there any inherent problems with the comparison of brown hair, Dr. Golub? Neil Fink began. There are not enough similar characteristics in brown human hair to say they came from the same source. The problem with brown hair is a great variety of hair coloring shades from light to dark, and all the characteristics used in comparison are so variable in one person's head, it is impossible to make a comparison. Drawing explanatory diagrams on a blackboard as he spoke, Dr. Golub lectured the jury about the underlying structure of hair fiber. He believed neither the diameter, the medullary area, the cortex, the cuticle, the color of the hair, nor the angle at which the hair was cut were conclusive points of comparison. Microscopic examination of only 200 hair samples is useless to me, the fiber expert said. There are more variations in one head of brown hair than there are between 2 different heads. Dr. Golub testified he also compared hair found in the underpants of the victim to brown hairs shaved from the legs of 2 female technicians who worked in his lab. The hair expert testified the hairs were the same general color and indistinguishable from the hair found on Miss Beineman's underpants and on the basement floor. Williams objected to the introduction of the women's leg hair into evidence, but was overruled. Mightn't the hairs found on Miss Bynum's panties come from shaving her legs? Or from washing her panties in a basin, where her brown-haired roommate clipped her bangs? Objection, Your Honor. The question is hypothetical and calls for a conclusion by the witness. Sustained. Can you draw any conclusion concerning the hair evidence? Fink asked. Only negative conclusions can be drawn from such comparisons. The comparison of hair samples can show only they came from different sources. The only conclusions I can draw are the hair was brown and Caucasian. Did you find any other trace evidence in the samples you examined? Yes, I found textile fibers and paint particles mixed with the hairs in the samples taken from the like basement floor. But this is most surprising. I didn't find any textile fibers or paint particles with the hairs found on Miss Bynum's underpants. I would expect textile fibers to adhere to the underpants just as readily as hair fibers. Dr. Golub testified for most of the day and was excused until Tuesday's session, when the prosecution would cross-examine him. As soon as the witness stepped down, the lawyers assembled in the judge's chambers to discuss the conditions of Collins' possible appearance on the stand. Louisel and Fink wanted Conlon to order the prosecution to exclude certain subjects from their cross-examination of Collins. Questions about the 2 Triumph motorcycles confiscated on July 31, 1969. Neither one was registered to Collins with the Michigan Secretary of State. The blanket and the Bold detergent box, said by witness Arnie Davis to contain women's apparel, removed from the trunk of Collins' car and disposed of shortly after Collins was questioned by police. Mention of a hunting knife given to Arnie Davis by Collins for safekeeping, after he removed it from under the hinged seat on one of his motorcycles. The knife was later surrendered to police by Davis. The contents of the Bold detergent box thought to contain trophies from some of the other murdered girls. Any reference to attempts Collins may have made to pick up other girls on the same day Bynum disappeared. If Conlon denied the defense motion, nothing would be lost. If he granted the motion, Collins could be placed on the stand with some level of immunity. There was no legal obligation for Collins to take the stand in his own defense. The decision rested with Collins and his lawyers. When court resumed on Tuesday, the cross-examination of the defense hair expert began when Booker Williams asked Dr. Golub, "Did you personally analyze any evidence for this case?" "Yes. I examined adhesive tape and panties rubbed on the basement floor of the Like House." "Did you personally gather the samples?" "No. William Menzies gathered the specimens for me at the behest of the defense. Then, a Michigan State Police detective brought the samples to my lab." "Do you know when these samples were collected?" "Yes, in June of this year." "Do you know the date when Karen Sue Bynum was allegedly murdered in the Like basement?" "No, not exactly." "July 23, 1969. Your evidence was gathered nearly 11 months after Miss Bynum was murdered. Was it not?" "I suppose it was." "Might that account for the differences you noted yesterday regarding paint specks and textile fibers between the 2 samples?" "I would expect to see similar fibers in a laundry room 11 months later." "You would expect?" Dr. Golub was shown slide evidence of the girl's underpants revealing fiber material he missed in his earlier examination and testimony. "You testified in this courtroom yesterday that you spent 3 days examining the evidence with a Michigan State Police Crime Lab expert, correct?" "Yes." "Were they full 8-hour days?" "Well, no." "How much total time would you estimate you spent with the state police expert, examining the evidence on those 3 days?" "It's tough to say. Estimated. About 12 hours? You also testified for the defense you found no textile fibers in the panty hair samples you examined. True?" "Yes. But upon closer examination today, you noticed textile fibers you overlooked the first time around. Did you not?" "Yes. There are more here than I previously testified to." "Can you explain the discrepancy of your observation?" Apparently, I didn't examine the lace-covered waistband. Dr. Golub, how long did you examine the panties? About 15 to 30 minutes. That's quite a range. Can you be more specific? Dr. Golub began to appear confused and indecisive under William's pointed questioning. As long as it took me to observe them under a microscope a quarter inch at a time, he relented. After most of the day on the stand, Dr. Golub remarked he was getting fatigued. He wrapped up his testimony by saying an assistant measured the angles of the cut hair segments and attached no significance and no practical use whatsoever in comparison. The angles ranged from 15 to 90 degrees, too great a range for comparison, he said. Dr. Golub, can you rule out that the two sets of hair came from the same source? All I'm saying is there is reasonable scientific certainty the hair did not come from the same source. I'll ask again. Can you rule out the possibility the two sets of hair clippings came from the same source? No. No further questions, Your Honor. The remainder of the day's session included the redirect examination of several prosecution witnesses. First to be recalled was Sandra Like. She was brought to the stand briefly to testify there was little or no change in the condition of the laundry room in the past year, except she had cut her father's hair in the basement during the winter months. Following Mrs. Like on the stand was Lieutenant Harold Morrison of the Michigan State Police. He was called to testify regarding the chain of custody of the gathered basement hair evidence. I saw former state police investigator William Menzies place adhesive tape on the floor in two places and scrub the floor using a new pair of women's panties taken from a plastic bag. Did you do anything after Menzies left the house? I duplicated his procedures on the floor and gave the items to the Michigan Department of Health. I thought it wouldn't hurt to have what the defense had. Last up to testify was John F. Youngblood, an associate of Joseph Louisel. Youngblood testified he took the materials gathered from the Like basement and flew them to Boston, where he gave them personally to Dr. Golub for analysis. Wednesday, August 12th began with the lawyers meeting in the judge's chambers to discuss the defense motions to limit Collins' testimony if they decided to place him on the stand. Conlon denied all the motions to exclude areas the defense did not want explored, except the one regarding the contents of the Bold detergent box, which the judge did grant. The items contained in the box would bring the other Washtenaw County murders into testimony, leading to a mistrial motion. During the last part of a 90-minute delay in the morning proceedings, Collins' immediate family was allowed to visit him in the judge's chambers with his attorneys present. Court observers wondered if Collins was about to take the stand in his defense. The atmosphere in the courtroom was bristling with anticipation as the press and gallery waited for the start of the day's session. With the principal parties assembled, Judge Conlon called the courtroom to order. Neil Fink addressed the judge directly. May it please, Your Honor, it is the sincere and professional opinion of the defense that the people have failed to show their case. Prosecutor Williams jumped up and said, I object on the grounds that, before the assistant prosecutor could finish his objection, Fink surprised the packed courtroom by saying, Then, Your Honor, the defense rests. So they were not caught off guard. Louisel and Fink decided against putting their client on the stand. The prosecution wanted to cross-examine Collins, but the defense could not predict how their client would hold up under their withering questioning. The prosecution had 3 rebuttal witnesses ready to testify. Eastern Michigan University Police Sergeant John E. Markwell testified he had driven motorcycles for 17 years. He ran time and distance comparisons for the police between 1307 Roosevelt Boulevard, the Like House, and J&J Cycle at 1196 Ecorse Road, the location of Collins' alibi. The tests were run between 12:40 p.m. and 2 p.m. to duplicate the traffic congestion and time frame of the Beineman killing. After taking several timed runs, Sergeant Markwell calculated it took between 7 and never more than 8.5 minutes to make the trip, depending on the traffic, rather than the 15 or 20-minute trip the defense contended. and Joe Patton testified to. The second rebuttal witness, State Trooper Terry Burnett, was called to refute the testimony of Joe Patton, alibi witness for Collins. Patton insisted, under staunch cross-examination, that he and his crew ate lunch generally between 1 p.m. and 1:30 p.m. every day. It would take something extraordinary to alter that, Patton had testified. Officer Burnett told the court he visited the motorcycle shop 7 days this June and 2 days in July. On one day, he said, he did not observe anyone eating lunch. But on the other days, lunch was eaten in the shop as early as 1:33 p.m. and as late as 2:25 p.m. The lunchtime discrepancy left a gaping hole in Collins' story and suggested the start time was moved up to accommodate his alibi. The third rebuttal witness was prosecution expert Dr. Holtz. His microscopic examination of the hair fiber evidence was roundly criticized by Fink and his defense team of science experts, particularly Dr. Golub and Dr. Jervis, for being inconclusive and obsolete. When Jervis examined mounted slides of the panty hairs, he claimed he found no evidence of textile fibers in them, as the like basement floor samples had. Prosecutor Delhey asked Dr. Holtz to show photographic slides to the jury of the underpants from the autopsy of Karen Sue Beineman. The head of the Michigan Public Health Criminalistics Division pointed out the presence of numerous textile fibers, refuting Dr. Golub's defense testimony. The people rest their case, Your Honor. Suddenly, it was over. Judge Conlin announced that closing arguments would begin at 12:30 p.m. on Thursday and would continue until complete. Jury deliberation would begin on Friday, August 14th. After Conlin gave his instructions to the jury, 2 names of the 14 jurors would be drawn from a revolving drum, and those individuals would be excused. 1 year and 22 days after the disappearance of Karen Sue Beineman, Michigan's most publicized and expensive murder case went to the jury. Courtroom observers speculated John Norman Collins did not take the stand because Conlin did not grant the defense motions to gag the prosecution. Outside the courtroom, Fink said the decision not to call Collins to the stand was a hard one, but he would not elaborate. Fink told the press gathered outside the courtroom, "The prosecution's case is riddled with inconsistencies. I feel at this point we have won." A reporter interjected a quick question on everyone's mind. Was it just too risky to place Collins on the stand? Listen, we did not want to jeopardize the case on testimony our client may have given under grueling cross-examination. Joseph Louisel and I are confident we made the right decision. A flurry of questions followed as Fink walked away. "No further comment," he said, heading out of the building to the parking lot. 29. The summations and jury instructions. In his 80-minute summation on Thursday afternoon, Prosecutor Delhey began by telling jurors John Norman Collins tortured, sexually violated, and murdered Karen Sue Beineman on July 23, 1969, in the basement of his aunt and uncle's home while they were away on a family vacation. Using common sense or applying reasonable doubt, is it possible to believe there were 2 men dressed the same way, riding a motorcycle in the same area at the same time, who had legal access to a house where barbering was performed and where traces of type A blood were found? It isn't. Because of the nature of the crime, the binding of the girl's wrists and her gagging, which show malice, willfulness, and premeditation, I respectfully submit to you that the people of the state of Michigan have proved beyond all reasonable doubt that John Norman Collins is guilty of murder in the first degree. William Delhey's summation had 5 categories. 1. Beineman's activities on July 23, 1969. 2. Collins' activities on the same day and time. 3. Evidence found at the alleged murder site, the Like home. 4. Expert scientific analysis of that evidence. 5. The discrepancies and holes in the defense case. Delhey and Williams made a number of strong points with the jury. Among them was testimony that 5 women saw Collins riding his motorcycle around the EMU campus between 11:30 a.m. and 12:30 p.m. Their testimony placed Collins in the area where Beineman was picked up by a motorcyclist wearing a green and yellow horizontal striped t-shirt riding a blue motorcycle. 3 other witnesses testified they saw Collins drive off with Karen Sue Beineman from Wiggs by Joan between 12:30 p.m. and 1 p.m. on the day she went missing. The wig shop ladies could identify John Collins as the man on the motorcycle, but they could not identify the motorcycle. A young woman who worked the counter next door at the chocolate shop testified she saw someone drive off with a girl on a blue Triumph with lots of gingerbread chrome and a square mirror. She could identify the motorcycle, but not its rider. Testimony from Sandra and David Like revealed they found black spray paint blotches on their basement floor and several cleaning items missing when they returned from vacation. Their nephew John Collins had a key to enter the house from the side door, but he fed the Like family dog in the garage. He had no reason to enter the house. Sandra Like testified she cut the hair of her 3 sons in front of the clothes dryer in her basement laundry room the night before leaving on vacation. Dr. Marjorie Barnes lived across Roosevelt Street from the Like house and testified she saw the person taking care of the Like dog leave their residence with a large, bold detergent box, one of the missing items from Sandra Like's basement laundry room. Dr. Barnes said this person rode north on Cornell Street with the box on either July 24th or July 25th. Dr. Robert Hendricks, Washtenaw County coroner, testified that Karen Sue Beineman was either dead or put in mortal fear of her life before 3 p.m. on the day she disappeared. There was also testimony about Collins's behavior and whereabouts from 2 of his roommates, and information from a former girlfriend of Collins at the time of Karen Sue Beineman's murder. Collins stood up Karen Naylor for a date the afternoon Beineman went missing. He had never done that before. Expert scientific hair and fiber testimony showed the hair clippings and fibers on the basement of the Like laundry room were similar in all respects to hair clippings and fibers discovered on Karen Sue Beineman's underpants found lodged inside her vagina. This was damning forensic evidence linking Beineman to the Like basement. "Isn't it amazing?" Delhi said. "Although John Collins had access to the house, and 3 people have testified he entered through the side door, none of his fingerprints were found in the house or the garage where he fed the dog? Strange indeed. Pay attention to the little facts." As Delhi wound down his closing remarks, he suggested Collins paid for his motorcycle bill at J&J on July 23rd with money taken from Beineman, the dying young woman. He noted Collins had no cash on July 22nd, but the following day, he paid a $20 3-cent bill at the motorcycle shop to establish an alibi. The workers at the motorcycle shop can only account for 1 hour of his time. What about the 2 hours before 4 p.m., when his roommates Arnie Davis and Andrew Manuel say he returned home? Delhi also pointed out discrepancies in statements by the 4 alibi witnesses and the 3 defense scientific witnesses leave gaping holes in the defense case. The defense has spent a great deal of time trying to throw sand in the jury's eyes, but I don't think you will be misled. While you must be guided by the doctrine of reasonable doubt, you should use common sense when reaching a verdict. Time is important in this case. Despite the apparent strength of the prosecution's case, even Judge Conlon admitted earlier in the week that the people's case was based primarily on circumstantial evidence. This, the defense felt, was their strongest point against conviction. After a short recess, Neil Fink led off for the defense, presenting a 25-minute summation discrediting the testimony of the witnesses who placed Collins with Beineman outside the wig shop. It is obvious their testimony is full of inherent incredibilities and obvious inconsistencies. I certainly can't prove John is innocent, and I can't produce the guilty party. But the prosecution simply has not linked our client to the girl's death beyond a reasonable doubt. Neil Fink warned the jury of the Perry Mason syndrome and lashed out at the prosecution. The pressure to find somebody bred confusion, and confusion bred a rush to judgment, and that rush to judgment led to the arrest of John Collins. Every right-thinking human being would say the murder of Miss Beineman was monstrous, and the work of a vicious dog that should be punished. However, it is just as monstrous to send somebody to prison that is innocent both in truth and fact. Joseph Louisel took over the summation. Collins' arrest and the charges against him are merely a rush to judgment, against a background in which a nervous community demanded a solution. It wasn't a search for truth and justice. It was a search to justify conclusions already reached by the police. Louisel attacked the conclusions and the credentials of the prosecution's expert scientific witnesses, implying they did not have the experience to analyze evidence with any degree of scientific certainty. After carefully avoiding the subject throughout the trial, Louisel mentioned the murders of 6 other young women in the area. That hung like a dark cloud over this case. Against a different background than the background that has prevailed here, Washtenaw County, we'd never be in this court trying this case, the famous defense attorney proclaimed. The community demanded a solution, and the police manufactured one. Booker T. Williams closed the summations with the prosecution's rebuttal. The defense has said we are contending that John Norman Collins is a sadist and murderer who borders on near genius. Well, I don't doubt that. But he is a near genius who panicked and did one stupid thing leading to his detection. If he had not sprayed the black paint on the basement floor, the chances are good the Like family would never have noticed anything missing in their basement when they returned. Williams chided the defense for bringing out the personal history of Diana Joan Goshi, one of the prosecution's key witnesses. The only person hurt was a 12-year-old boy, Williams said, referring to Goshi's son. It was John Norman Collins who rode off with Karen Sue Beineman that day. The 2 wig shop ladies made a positive identification of Mr. Collins, driving away with Miss Beineman, never to be seen alive again. There is nothing circumstantial about what the other women who saw Collins on the day Beineman disappeared testified to. There is nothing circumstantial about the conditions the Like family found in the basement of their home. Collins made the same mistake his uncle made. He mistook a substance on the basement floor as blood. When he couldn't remove the spots, he panicked. He did the one stupid thing which eventually led to his apprehension. Except for the black spray paint on the basement floor, Sergeant Like would probably have noticed nothing unusual. Then there is the scientific evidence. The defense discounted the use of the microscope in identifying hair segments, then later approved the use of it. Neutron activation analysis was used by both sides to compare hair clippings in this case. The killer of Karen Sue Beineman committed a cold-blooded murder. The prosecution believes we have proved beyond any reasonable doubt that John Norman Collins is guilty of the brutal sex slaying of Karen Sue Beineman. We ask the jury to return a guilty first-degree murder verdict. Thank you. The summations lasted over 3.5 hours. John Collins sat grim-faced, listening intently, while the jury sat impassively. At the end of the day, Collins appeared cheerful and managed a smile directed at his mother. To her credit, Loretta Collins attended every day of the trial and pretrial hearings for her son, and soon his case would go to the jury. The 4 lawyers faced each other across the bar of justice for the last 10 weeks. Each side wanted to make its final statements memorable to the jury. The 5-hour session was the last time the lawyers could address the jury, before they would decide the case. The prosecution called 48 witnesses over 13 days, while the defense called 8 witnesses over 4 days. As William Tremmel of the Ann Arbor News reported, they all seemed drained and jaded, the battle flame out, the shadows of self-doubt gathering. Friday marked the day the case went to the jury. Their morning was spent listening to Judge Conlin's opening remarks. It is not for the attorneys to tell you what the facts are, but for you, the jury, to decide what the facts are. what testimony is to be believed, and what weight is to be given. Judge Conlon defined reasonable doubt as a fair doubt growing out of the testimony, in this case, based on reason and common sense. He reminded the jury, "The law presumes the defendant innocent until you are convinced of his guilt, beyond reasonable doubt." After defining murder in the first degree as the willful, deliberate, or premeditated taking of a life, Judge Conlon narrowed down the range of verdicts. The evidence shows Miss Beineman was struck with a blunt instrument and strangled. Since that is the case, there is no room for a lesser offense such as second degree or manslaughter. It is either a verdict of guilty of murder in the first degree or not guilty. The judge also defined circumstantial evidence as a chain of well-authenticated circumstances. Judge Conlon advised the jury to give careful attention to the testimony of retained, paid, expert witnesses. Treat them in the same manner as any other witness. The mere fact that testimony was presented by experts does not give it more weight. Closely review the testimony from police officers who are witnesses under pay, and anyone who might lay claim to a reward. Because Mr. Collins did not take the stand, there is to be no prejudice against him. He has a right not to take the stand in his own defense. This is an important case, important to the people and to John Norman Collins. You will now weigh out and administer justice, and that justice should not be administered with sympathy or vengeance. After a brief 2-minute conference with the lawyers to give them an opportunity to enter any objections about his charge to the jury, Judge Conlon ordered the names of the 14 jurors to be placed into a revolving drum, and 2 chosen to be excused as alternates. A male juror in Chair 6 and a female juror in Chair 11 were excused from deliberations, their names withheld due to Judge Conlon's earlier court order protecting their identities. The excused jurors were instructed not to discuss this case with anyone until a verdict has been returned by the remaining 12 sitting jurors. At 11:35 a.m., the jury retired to the jury room. With that, the defense lawyers Joseph Louisel and Neil Fink went to lunch at the Town Club restaurant at 210 West Washington Street in downtown Ann Arbor. Sheriff Doug Harvey was seated nearby with several people when he overheard Louisel tell Fink he better win this case or look for another law firm. Louisel headed back to Detroit, leaving Fink to await the jury's verdict and wind down the case alone. The next 5 days would be nerve-wracking for Neil Fink. 30. The jury deliberates. At 11:35 a.m. on Friday morning, Judge Conlon gave the jury their charge: decide the fate of John Norman Collins. The jurors went to an undisclosed Ann Arbor restaurant for lunch and were back in the jury room at 1:10 p.m. to begin their deliberations. They continued until 9:30 p.m. From behind a locked door, the jury requested several exhibits, including the detailed composite drawing of Collins, as described by Goshi and Spaulding on July 24, 1969, the day after Karen Sue Beineman disappeared. They were the last known people to see her alive, except for her killer. At 3:15 p.m., Collins was brought from the nearby jail to the courtroom so the jurors could compare his face with the state police artist's composite sketch. That was an awkward moment for all concerned. After Collins' appearance in the courtroom, he and the deputies escorting him back to his maximum security cell noticed a note attached with a postage stamp to one of the stair risers in the county courthouse. Written on the back of an invoice statement from Ann's Flower Shop was a message that read, "John, we're still rooting for you." Apparently, it was from 2 teenaged girls seen earlier in the hallway outside the courtroom with a box of flowers. They gave the box of black-eyed Susans to the deputies guarding the courtroom door, but the flowers were never delivered to Collins. At 3:40 p.m., the jurors asked for a rehearing of the testimony of 6 witnesses. Jurors were not allowed to take notes during the trial, and they felt they needed to refresh their memories on the testimony of Goshi and Spaulding. The jury wanted to review the testimony of Karol Vieczeja, the clerk at the chocolate shop, and both of John Collins' former roommates, Arnie Davis and Andrew Manuel. The jury wanted to review the testimony of Karen Naylor, Collins' alleged girlfriend who dated him before he was arrested. At the very least, Collins and Naylor spent time together and went riding motorcycles in the backcountry where the bodies of 6 of the 7 unsolved murders were found. But the slaying of Karen Sue Beineman was this jury's singular concern. They listened for 1.5 hours, while court reporter Margaret R. Westfall read the testimony of Spaulding and Vieczeja. The jury deliberated for 30 minutes on what they heard before they left for dinner at 5 o'clock. When they returned, they changed their minds about hearing the testimony of the other witnesses. They deliberated until 9:30 p.m., when they were finally taken to their rooms at the campus inn. The jury was back deliberating Saturday morning at 8:25. It was reported the session was marked by conflict, as raised voices could be heard in the corridor by the press outside the jury room. The jurors asked again to rehear the testimony of Patricia Spaulding, Karen Naylor, and Arnie Davis. The sticking point was testimony about the square mirror on the blue motorcycle. As they listened to the testimony of the 3 witnesses being read to them, the jury heard Patricia Spaulding say she saw Collins driving off with Beineman and noticed a square rear-view mirror on the left handlebar of his blue motorcycle. Karen Naylor testified John had a detachable square rear-view mirror he used on whichever of his 4 bikes he was driving. But Arnie Davis, who rented a room across the landing from his best friend John, told the court Collins did not own a square rear-view mirror. Saturday morning, jurors left the jury room and spent 15 minutes in the courtroom, examining the 2 motorcycles still parked there. The green Triumph had a broken round mirror on the left handlebar, while the blue Triumph had no mirror at all. While the defense read in the Sunday newspapers about the jury's visit to view the motorcycles, Neil Fink immediately requested the judge have the cycles removed, because they were never officially entered into the court record as evidence. 15 minutes before the jury entered the courtroom on Monday, Collins and Neil Fink inspected the motorcycles for one last time. Looking thin and pale, Collins lightly rubbed the handlebars of one of his bikes. When he glanced up at the courtroom door windows, newsmen were peering inside. The motorcycles were removed before the jury entered the courtroom, per Neil Fink's request. Both bikes were taken to an undisclosed police storage facility. A point never pursued by the prosecution or the defense was the legal ownership of the 2 Triumph motorcycles. Neither was registered to Collins. Both bikes were stolen property. Delving into this area would open up testimony that the prosecution felt might lead to a mistrial charge. The defense did not want the jury to hear about John Collins' burglary crew, Collins, Davis, Manuel, and others, which would complicate the defense of their client. The opposing lawyers agreed on this point. After their Saturday lunch break, the jury listened for over 2 hours to reading from the court transcripts of Dr. Vincent P. Gwyn's scientific testimony about the hair clippings. After they returned from their dinner recess at 6:30, the jury heard the testimony of Dr. Parkons for 25 minutes, followed by 40 minutes of Dr. Jervis's testimony. The reading of Parkons and Jervis's testimony went faster than the previous readings, because the phonetically coded court transcripts were retyped by Westfall during the long periods of jury deliberation. These were easier to read and listen to. When the jurors finished their review of the scientific evidence at 7:50 p.m., Judge Conlon offered the jury the option of returning to their hotel rooms until Monday morning or pushing on until 9 p.m. One of the male jurors addressed the jury foreman, "Come on, we can do it." The jury attempted to reach a verdict within the hour, but were unsuccessful. Some jurors told Judge Conlon earlier in the day they wished to attend church services on Sunday. Although there was no legal reason they could not meet on Sunday, the judge granted the request. The judge was a practicing Catholic and had just that day attended a Holy Day service himself. Besides, the jury put in 2 long, stressful days and needed to rest up for Monday morning session. As it turned out, the two members of the jury who planned to go to Mass received religious dispensation from Monsignor Vincent Howard of St. Thomas Church in Ann Arbor, releasing them from their weekly obligation to attend Mass. During the final hour of Saturday's deliberation, Mrs. Collins was denied permission to visit her son in the courtroom lockup, despite the request being granted by the judge. The deputies charged with guarding Collins would not allow her to visit him for security reasons. Earlier in the day, Mrs. Collins, accompanied by her daughter Gail, went to St. Thomas Catholic Church to pray for her son. The Macomb Daily ran a photograph on the front page of them praying at the communion rail, with a quote from Loretta Collins. "We're just sitting with our fingers crossed. We're hoping. We're praying everything is going to work out all right," she said. Fink appeared depressed and worried as he paced outside the courtroom following the jury's evening meal recess, but he perked up when the jury failed to reach a verdict in their final hour of deliberation Saturday night. After 2 days and 21 hours of deliberations, this jury was about to become the longest-seated jury in Washtenaw County judicial history. A verdict was close, but just out of their reach. They would resume their civic responsibility on Monday morning at 8:30 a.m. The Collins jury entered its third day of deliberations. Judge Conlon, responding to growing concerns there might be a hung jury for this case, said he felt it was too early to speculate. "I am not ready to set any time limit on their deliberations. If the jury declares itself hung, a mistrial will be declared. If that happens, the long process of selecting another jury and taking 4 more weeks to hear the testimony will begin again. But not in Washtenaw County. Where would we get another jury?" he concluded. In sequestration, the jury reviewed and finished discussing the scientific evidence from Saturday's contentious deliberations. At 10:30 a.m., the jury notified the court they wanted to hear excerpts from the testimony of Arnie Davis concerning the whereabouts and activities of Collins on the day Beineman disappeared. The jury also requested a photograph of a child's T-shirt Sandra Like testified she had laundered before the family went on vacation. She found a dark spot not there before they left. The shirt had been hand-washed and hung up backward from the way it was before the Likes left on vacation. The judge granted the request. The jury also wanted to see the note Mrs. Like wrote listing changes she found in her basement after the family returned from vacation. The judge denied that request because the list was never formally entered into evidence. Court observers felt the jury was hung up on the validity of the circumstantial evidence key to the prosecution's case. The validity of the scientific hair evidence and the expert testimony from conflicting lab technicians was thought to be a major point of contention among jurors. Shortly before adjourning, the jury asked Judge Conlon to repeat his instructions on circumstantial evidence and reasonable doubt. Tired newsmen seeing the lights go on in the judge's courtroom thought the jury had come in with a verdict, but they were disappointed. After patiently reviewing his instructions and redefining terms for the jury, Judge Conlon adjourned deliberations at their request. They went through another long and exhausting day. The jury spent Tuesday struggling with the circumstantial evidence and whether the prosecution had proven beyond a reasonable doubt that Collins willfully committed first-degree murder upon Karen Sue Beineman. Much of the day was spent listening to Westfall reading Arnie Davis's testimony. The jury debated, point by point, everything Davis testified to. He was difficult for the jury to understand. On the one hand, some of the most devastating circumstantial evidence against John Collins came from him. But in cross-examination, Davis testified in favor of the defense, complaining about the police harassing him daily for months. The jury was not sure what to make of his testimony. Arnie Davis testified he saw Collins leave the boarding house with a used detergent box and a blanket removed from the trunk of his car. He could not remember the brand name of the detergent or the color of the blanket. This was shortly after Collins was questioned by police. Davis also testified he and Collins took the Green Triumph for a motorcycle driving lesson in the North Campus parking lot of Eastern Michigan University in the early afternoon, several hours earlier than they actually had gone. When Davis asked Collins why, Collins pressured him to agree without an explanation. The jury needed to make sense of it. A young man's life was at stake. Twice on Tuesday, Judge Conlon asked the jury if they were hopelessly deadlocked on reaching a verdict. Their deliberations began at 8:30 a.m., and after 3.5 hours, the judge called them into the courtroom. "Do you feel there is reasonable probability of jury agreement?" The jury foreman answered yes. After a short lunch break, the jury was not heard from again until 5 p.m., when they filed back into the courtroom. They were poker-faced and gave no clue of an imminent verdict. "You've been deliberating for 8.5 hours today, and are going to decide for yourselves about deliberating more tonight or tomorrow," Conlon told them. "Is there still a reasonable probability this jury can arrive at a verdict?" "Yes, there is a good probability," the foreman replied. They left the courtroom and sent a note back to the judge 10 minutes later. They preferred to return to their hotel rooms and resume their charge tomorrow. After 4 days of jury deliberations, speculation about a hung jury was over. At this stage of the proceedings, neither side wanted a hung jury. The costs to Washtenaw County for this trial were estimated to be $75,000. The costs of a new trial in another county would be even higher. Tension was running high outside the courtroom. A reporter from a Detroit radio station almost came to blows with a Detroit newspaper reporter over the use of a payphone. Michael J. Devine, press liaison for the Collins case, hastily arranged to have most of the phones in the county building made available to the media. However, some Detroit newspaper reporters and television people took that to mean they had exclusive use of those phones for the duration of the trial. They gave local reporters who needed to use these same phones a hard time. Then the out-of-town reporters got into the mix. This case was bigger than the Washtenaw County building was designed to handle, and tempers were wearing thin. When court adjourned for the day, it had been 101 hours and 30 minutes since the case went to the jury. They had deliberated for 27 hours, spent 5.5 hours hearing testimony read back to them, and listened to the judge repeat his instructions. On Wednesday morning, the jurors assembled in the jury room at 8:30 a.m. 15 minutes later, the jury foreman knocked from inside the deliberation room for the last time. The foreman told the bailiff they had arrived at a verdict. Calls went out to the county jail for Collins to be brought to the courtroom and for the lawyers, the press, and the Collins family to be notified. Throughout the trial, Mrs. Collins greeted her son every day with a smile and waved goodbye as bravely as she could when John was taken to the lockup. Whenever possible, she met with her son in the judge's chambers, always in the presence of his lawyers. On this day, she sat in the front row of the gallery, as she had for 8 weeks of jury selection and trial testimony, merely 20 feet away from her son. Collins entered the courtroom wearing a blue sports coat, dark slacks, a blue shirt, and a blue and white striped tie. His face revealed little emotion as he looked forward with a pale and drawn expression. The jurors entered the courtroom and filed into their respective seats in the jury box. At 9:33 a.m., Court Clerk Ruth Welch asked the jury, "Members of the jury, have you reached a verdict? Who speaks for you?" Jury Foreman William G. Billmeyer stood up and said, "I speak for the jury. We have reached a verdict." Collins stared steadily at the jury foreman while the verdict was read. "We find guilty. We find the defendant guilty as charged." An audible gasp swept through the courtroom. Collins sat impassively. His mother stared straight ahead, benumbed. Defense attorney Neil Fink asked that all the jurors be polled by the court clerk. All 12 were asked by Welch, "Was this, and is this, your verdict?" Each answered yes in turn. Judge Conlon, his voice tired and strained, noted for the court record that a pre-sentencing report was required. Fink rose and told Conlon, "The defendant is not going to talk to anyone except to give his name and address." "Of course. That's his privilege," Judge Conlon replied. After thanking the jurors for their diligent public service, the judge told them they were free to talk to newsmen if they wished, but he recommended they speak with no one. Conlon remanded Collins to the Washtenaw County Jail pending sentencing on August 28th. "I declare these proceedings closed," he said, as the gavel came down. As the press scrambled out of the courtroom to report the guilty verdict to their respective news organizations, a young woman who knew John sat with the Collins family and began to cry. Then Gail broke into uncontrollable sobbing while her mother tried to comfort her. Mrs. Collins called out to Fink and asked whether she could visit her son. The court officials granted her permission to sit with him at the defense table. Loretta placed her arms around him. One witness reported seeing John shrug her away when she tried to embrace him. She patted and rubbed his back as a mother would a frightened child. The bailiffs locked the courtroom doors and stood outside to keep spectators and the press from looking in the windows, while Mrs. Collins spent the final moments with her son, comforting him as best she could. Some court personnel said privately that Collins finally wept in his mother's arms. Loretta broke down as her son was led from the courtroom for the last time. Father Patrick Jackson of St. Thomas Parish, a Roman Catholic priest who served as Collins' spiritual advisor and accompanied the Collins family at many of the court sessions, did his best to console the inconsolable women. As Mrs. Collins and her family left the courthouse, they were rushed by court officials into a waiting car driven by Father Jackson. The family went to the church to regain what composure they could. The doors to St. Thomas were locked for 3 hours after the verdict was announced. The Collins family went into seclusion and refused commenting to the press. The jurors were sequestered for 4 weeks in one of Ann Arbor's nicest hotels, the Campus Inn, but there were only 2 occasions when they were allowed to see their families. All the newspapers reaching the jurors during the trial had no mention of John Collins or the Charles Manson trial in California. Those news stories were cut out. The jury was now officially disbanded and free to go about their personal lives. But despite a plea from the judge for the press not to reveal the names of the jurors, there was no legal obligation for them not to. The jurors' names appeared in most of the newspapers by their evening editions. For the record, they were: Chair 1, Alice Vining, the mother of 2 small children and wife of a criminal law professor at the University of Michigan. Chair 2, Rose Rasky, a university researcher whose husband was a zoology professor at the University of Michigan. Chair 3, Esther Travis, the mother of 3 small children and a clerk at a home for the aged. Chair 4, Clifford E. Fishback, a retired engineer for Detroit Edison and/or a retired high school principal, depending on which newspaper one consulted. Chair 5, Donald Burns, a systems analyst for the Ford Motor Company. Chair 6, Paul Huter, a Ford Motor Company engineer, alternate excused. Chair 7, Patra Terry, a mother of 1 and a housewife. Chair 8, James L. Burns, a father of 5, environmental expert and former military policeman. Chair 9, William G. Billmeyer, an engineer, jury foreman. Chair 10, Morton F. Newhouse, a grinder operator in a machine shop. Chair 11, Elizabeth Osborne, a housewife, alternate excused. Chair 12, Robert D. Hendricks, an auto worker. Chair 13, Doris M. Green, a school teacher. Chair 14, Trenna B. Edmondson, wife of a bioengineer at University of Michigan. Karen Sue Beineman's older sister, Barbara, was seated with the Like family in the first row across the aisle from the Collins entourage. Her mother and father declined to attend the trial. It was too painful. When the verdict was read, she wept with Sandra Like, who openly cried. Barbara Beineman left the courtroom to face a barrage of reporters and simply said she was relieved. When pressed further by reporters, she added, "That's the only comment I want to make." Prosecutors Delhi and Williams then accompanied Sergeant Like and his wife Sandra, along with Barbara Beineman, into Delhi's office. They remained there for almost 3 hours until the media frenzy died down. The only trial participant willing to comment openly after the trial was Washtenaw County Sheriff Douglas Harvey. He said, "I'm very pleased. The prosecutor's office did a fine job." Later that morning, Delhi and Williams held a short news conference. In essence, Delhi said Collins was the only suspect in the other 6 unsolved murders of young women in the area, which were still under investigation. There is a distinct possibility there will never be enough evidence to justify charging anyone in the killings. Moments after she heard the verdict on the radio, a neighbor in Grand Rapids rushed to the Beineman home. "My stomach is in knots," Mrs. Beineman said. "I'm convinced God was on that jury. He was the main member of the jury." A few seconds later, Mrs. Beineman received a call from her daughter, Barbara, who phoned after leaving the courthouse. Karen's father was contacted at his place of business, Seaway Time Company in Muskegon, but his immediate reaction to the news is unknown. What healing was possible could now begin. In Lansing, Governor William G. Milliken heard about the verdict at a daily news briefing. When asked about the extradition of Collins to California, as per the request of California Governor Ronald Reagan, all he could say was he had not made any decision about whether Collins would stand trial for the murder of Roxy Ann Phillips in Salinas, California. "That will require more study," the Michigan governor said. The 17-year-old high school senior was murdered 2,200 miles away and less than a month before Collins murdered Beineman in Ypsilanti. The California case hung like a dark cloud over the Collins case. Great pains were taken to keep any testimony about Collins' California trip with Andrew Manuel out of the record, for fear of a mistrial. But now, if Governor Milliken allowed California a writ of extradition, Collins would face another first-degree murder indictment, this time in a death penalty state. People close to Milliken felt his Catholic faith would make it difficult for him to comply with Governor Reagan's extradition request, a point the governor's handlers were quick to discount. Karen Beineman's high school friend in Muskegon, Becky Barlow, said when interviewed, "Karen knew the risks associated with going to Eastern Michigan University and said she took precautions. Karen joked about getting a football player for an escort, but said, then he might be the killer." Barlow continued, "Karen once wanted to be a social worker, but gave up the idea when she saw the places she would have to work. She was afraid because she was so little." Karen was a small girl, only 5 feet 1 inch tall and weighing only 96 pounds. Becky described Karen as a shrewd thinker and a sensible girl, but added she was gullible and trusted people. Arnie Davis heard about the conviction on the radio. Reached by phone, he responded to the guilty verdict his friend received, saying, "I'm neither glad nor sad. It wasn't a surprise. But as long as Collins had to be convicted, I'm glad he got life imprisonment in Michigan instead of the gas chamber in California." Arnie Davis continued, "The verdict takes a lot of weight off my mind. It's been an ordeal, and I'm glad it's finally over." Diana Joan Goshi had a different take on the verdict. "He was the man I saw, and I believe justice was done. Personally, I'm deeply relieved that he'll be behind bars, but my deepest emotion is a feeling of heartfelt sympathy to the girl's parents." A random sampling of people surveyed outside the courtroom felt Collins got a fair trial and a just verdict. Predictably, many people were disappointed he did not get the death penalty, which was not an option in Michigan. But not everyone agreed. Sharon Riley, 25, who lived in Ann Arbor, said she did not feel it was proven. He got a fair trial, but it was all circumstantial evidence. Riley said she met Collins at the Rubaiyat restaurant over a year ago and dated him from time to time. "He was very nice and treated me gently. He appeared very normal." When asked what her reaction to the jury verdict was, she answered, "I feel numb. I heard he showed no emotion when the verdict came in. I'd be concerned about dating him now. Mrs. John Miskovic walked by the courtroom with her 2 young children in tow. When asked to give her reaction, she said, "I feel it was a fair trial and he was guilty. With the death penalty, there would be less of this sort of thing. If a murderer knows he'll get out in time, then he is likely to do it again." Robert Harder, a county employee, also thought the death penalty should be instituted for murder. "We are having too many of these kinds of cases. We're losing too many policemen." Pearline Sullivan, a district court employee, said she felt Collins got a fair trial and was guilty. She added that the death penalty ought to be given to persons convicted of more than one murder. Vicky Smith, an employee in the county building's coffee shop, said, "It seems real sad that such a young man should be convicted like this. I feel sorry for him. It seems a shame he has to spend the rest of his life in prison. But he'll have to take his chances." Patsy Hubler said, "I wasn't surprised by the verdict because I thought he was guilty last summer. My sorority sisters and I pretty well figured it would have to be someone like Collins, handsome and strong. It wouldn't be so bad if it was someone who looked like a killer." One young man who asked to remain unidentified said, "The thing I don't understand is why Collins wasn't called to testify. He should have been called to the stand. I feel sorry for his family, but I think we should have the death penalty in Michigan." Some Centerline residents were reluctant to speak about the case, but others merely wished not to be identified. A student at St. Clement High School remembers going to Mass and the Monsignor instructing the assembled student body to pray for guidance and protection for one of their own who was in trouble. The common request of those few people in town who did talk was, "Please don't use my name. After all, this is a small town, and everyone knows everyone." Inquiring reporters looking for a story found the Collins family home on Helen Street with window shades drawn and doors locked. Neighbors on either side refused to comment about John or his family. Several youngsters playing in the street had the good sense not to talk to strangers about it. The principal at St. Clement High School, David Grassi, told a reporter from the Macomb Daily, "I have no comment to make about the Collins case." The local barber on Van Dyke and Helen Streets also had no comment. Wendell Steinhaus, director of Centerline's Recreation Department, said, "My wife was surprised by the first-degree guilty verdict. As for me, I really don't know what to say. I understand Collins took the jury's decision rather mildly. If it had been me, and I knew I was innocent, I would have shouted my innocence for all to hear." Then he added, "Maybe the long ordeal has broken his spirit. Those of us who knew him find it hard to believe he could have perpetrated such a crime." A middle-aged housewife interviewed at a local laundromat was one of the few people who would talk openly about the Collins family. "I'll bet his early childhood had something to do with it. If he is truly guilty of the crime. You know, his real name is Chapman. He got the Collins name from his stepfather." She continued, "I've lived around here for 40 years, and I know a lot, and so do others. I'd rather not make it a public matter." The woman paused while she loaded another basket of clothes into the washer. "My daughter's best friend used to date that boy. He never got fresh and respected her. He liked girls and respected girls who had good moral character." John's former St. Clement High School football coach, Al Baumgart, said he had heard Collins' parents had marital problems. "Maybe that is why he hit people so hard on the football field, to get his venom out." In California, when Monterey County District Attorney Edward Barnes learned of the jury decision, he reported he would begin extradition proceedings within 10 days for Collins to face a grand jury indictment for the first-degree murder of Roxy Ann Phillips. Judge Conlon called court to order for sentencing at 9 a.m. on Friday, August 28th. Conlon asked the defendant if he had anything to say on his behalf before the sentencing was imposed. Wearing a green plaid sports coat, a white shirt, and a striped tie, John Norman Collins spoke for the first time in this case in a squeaky voice that wavered from lack of use and the gravity of the prospect before him. He was clearly audible. "I have 2 things to say, Your Honor. 1, I feel this community tried to give me a fair trial. The jury did not take it too lightly. It did the best it could under the circumstances. Secondly, I never knew a girl named Karen Sue Beineman. I never engaged her in conversation, I never took her on a motorcycle ride, and I never took her to the wig shop. Also, I never took her to my uncle's basement. I did not take the life of Karen Sue Beineman. But in my view of the prevailing mood of the community, I feel that the events presented during the last 6 or 7 weeks have been blown out of proportion. I think my trial was a travesty of justice. I hope that someday this will be corrected. Mr. Collins, Judge Conlon began, if by chance they, the jurors, were wrong, I am sure it will be corrected. A jury of your peers has found you guilty, and under the law of the state of Michigan, I have no other recourse but to impose the mandatory sentence. I hereby sentence you to solitary confinement at hard labor for the rest of your life at Southern Michigan State Prison in Jackson. Your attorneys have a right to appeal within 60 days. If you do not have sufficient funds, you should apply to the court for an attorney. Although there has been no plea of insanity in the case, Judge Conlon continued, and although by your courtroom actions there is no evidence of your insanity, I am going to recommend that prison authorities give you a thorough psychiatric examination. Collins took the sentence stoically, while his mother's weeping was heard in the background. As Collins was led out of the courtroom, an unidentified young woman got as close as she could and said, smiling, "Don't worry, John. Everything will be all right." Collins smiled back at her. Afterward, Loretta Collins was permitted to spend 15 minutes with her son in the offices of the Washtenaw County Jail. By this time, he was dressed in bluish-green prison denims and white cotton slippers. Mother and son were alone. Before leaving, Mrs. Collins gave her son a long embrace. After Loretta Collins left, her son's hands were cuffed and shackled to his waist by a chain. John Collins was led to the prison lockup. At 10:40 on the same morning of his sentencing, Collins and 2 other prisoners were led into the jail garage and herded into a jail van. They were driven west on I-94 under heavy police escort to Jackson State Prison, 35 miles away. Part 3. 31. Prisoner number 126833. Collins' first full day in Jackson State Prison was Saturday, August 29, 1970. At 23 years old, he was the youngest lifer there. Despite the wording of the verdict, solitary confinement and hard labor, the Michigan Department of Corrections, MDOC, Director Gus Harrison told reporters these 2 penalties had not been enforced at Jackson State Prison for about 12 years. How can you have someone in solitary and also at hard labor? It's pretty difficult. Collins woke up at 6 a.m. and ate breakfast at 7. In addition to testing and interviews, he took a 1-hour recreation break in the prison yard, like the other 5,000 prisoners housed there. At the time, Jackson State Prison was the largest walled correctional facility in the world. Lights out was at 10 p.m. Before long, one day blended into the next. For his first 30 days, John Collins was in quarantine for testing and an adjustment period. "He'll be in and out of his cell all day long," said Harrison. "New prisoners undergo a complete battery of personality, aptitude, intelligence, and physical tests. They also give interviews to staff members and fill out questionnaires regarding family, possible visitors, and religious preference. Depending on the results, Collins may be allowed to take university classes. The Prison Classification Committee will decide what the best program for Mr. Collins will be." Judge Conlon recommended Collins be given a complete psychiatric examination. The results of any psychological testing are privileged information and unavailable to the public. Whenever testing is offered to Collins, he consistently remarks on his MDOC paperwork, "Not interested." While Collins was adjusting to his new reality, his lawyers were busy filing a mistrial motion in Washtenaw County Circuit Court. On September 16, 1970, Joseph Louisel cited 8 items of judicial error in the Collins case and requested a new trial with a different judge. The areas of defense concern were: 1. Judge Conlin failed to grant repeated motions for a change of venue. 5 unsuccessful attempts were made to move the trial to another county. 2. The court erred in admitting testimony of Diana Goshi and Patricia Spaulding. Their client, they claimed, was deprived of due process of law, which caused a miscarriage of justice. The women were shown a photograph of Collins prior to the police lineup. 3. The court erred in instructing the jury and was misleading. Judge Conlin did not define premeditation in his instructions to the jury. 4. Judge Conlin erred in admitting the testimony of 3 so-called experts in hair analysis. 5. Improper conduct on the part of the bailiff and improper communications to the jury during the trial, and improper reporting of the state of deliberations to the prosecutor and to certain representatives of the media who covered the trial. 6. Prejudicial misconduct on the part of key prosecution witnesses. Louisel claimed State Police Sergeant David Like and his wife Sandra did purposefully and willfully prejudice the jury by attending the proceedings with a man dressed as a priest and did situate themselves where certain members of the jury were sure to see them. Louisel failed to mention Loretta Collins sat through much of the trial accompanied by Father Patrick Jackson from St. Thomas Parish in Ann Arbor. 7. Judge Conlin was cited for his failure to grant a mistrial motion on the 4th day of deliberations. The defense motion was made on the belief that further deliberation amounted to coercion. The defense felt the last remaining jury members favorable to their client were bullied and worn down by the rest of the panel. 8. Louisel claimed the verdict was void because the jury returned a general verdict of guilty on an open charge. The foreman stumbled when he first gave the verdict. He said, "We find guilty," but he recovered and read the verdict in the proper legal format. "We find the defendant guilty as charged." Conlin scheduled a 2 p.m. hearing for October. It took about an hour. Neil Fink made his case about rumors involving improper communications with the jury. A television reporter, Fred Stowe of WWJ, Channel 2 in Detroit, and State Police Detective Sergeant Max Little were the only witnesses called. Neil Fink quizzed Stowe about some filming that took place in the lobby of the Washtenaw County building on the evening of August 15, 1970. "Didn't you make a news film on the ground floor of the county building in which you reported the status of the jury deliberations at the time stood at 9-3 for conviction?" "Yes, sir, but I would like to explain if I could," Stowe said, looking up at the judge. "It was done more or less as a joke. Some of my competitors thought I had an inside edge in Washtenaw County, and they followed me around. While I was waiting to film a story, one of my camera crew told me a competitor was standing in the stairwell eavesdropping. With that in mind, we made a dummy film to hand off some misinformation as a ruse. When my competitor left to file his story, we filmed our original story and sent it to Detroit for showing on the evening newscast." "And did you discuss this dummy film with Detroit news reporter John Peterson?" Fink inquired. "Yes, we work for the same firm, and we conferred frequently during the trial. When I told John about the film, he said, 'Good, I'll go up and tell him the vote in the jury room is 10-2, Stowe testified. "Did you read Peterson's article after the verdict, where he says an unidentified juror claimed the jury count was 9-3 for conviction for some time?" Fink asked. "No, sir, I have no direct knowledge of that story," the newsman said. In what can only be explained as a prank by bored newshounds waiting for a jury result to come in, Stowe's testimony stirred passing amusement among reporters covering the hearing. As the television newsman told of his plan to dupe his competitor, Fred Stowe left the stand chastened. making the news that day rather than reporting it. Fink informed the judge the defense was trying to subpoena John Peterson, but he was out of town on assignment and could not be located. Fink asked Conlon to take judicial notice of a copy of the newspaper story. The judge agreed to do so. Sergeant Max Little was called to the stand. He was a husky, dark-haired veteran of 24 years with the Michigan State Police. He told the court that while acting as a bailiff, he engaged in general conversation with several people, speculating how the jury deliberation was going. I made educated guesses. I had no direct knowledge of what was going on in the jury room. It was just discussion. Did you discuss deliberations with Diane from the sheriff's department? Fink probed. Diane Davis was a police matron and sheriff's investigator who, at the time of the trial, was stationed at the courtroom door to search the women spectators before they entered. Not that I remember. When Fink was finished, Prosecutor Delhy had no questions for either Stowe or Little. Judge Conlon said he was satisfied there were no leaks from the bailiff. It certainly is a serious question, and if you have proof of this, Mr. Fink, I certainly want to be the first to hear it. To everyone's surprise, Delhy rose and offered to testify his office received no information on the status of jury deliberations. I don't think that's necessary, Mr. Delhy. I myself heard all kinds of guesses during deliberations, Conlon said. I don't see how anyone would know that. I have all the confidence in the world in our bailiffs. On November 12, 1970, Collins made his first court appearance since his imprisonment. He was escorted into the courtroom by sheriff's detectives Roy Couch and Arthur Preston at 2:20 p.m. Collins was dressed in a blue prison jacket, a white shirt open at the collar, and light green dungaree work pants. His dark hair was trimmed shorter than at the trial, and his sideburns were cut to standard prison length. His face was still pale and wan, but he had gained some weight in prison. Collins was just in time to hear Fink review the 8 points of Louisel's petition for a new trial. True to form, Collins did not speak during the 35 minutes he was in the courtroom. Judge Conlon denied all 8 defense motions. The judge said there were no grounds for a change of venue, though there was substantial publicity about the Collins arrest. Collins ruled the jury selection was fair and impartial, and the jurors were not affected adversely by the publicity. The motion regarding the identification of Collins by Gaucher and Spaulding was not tainted. Their identification of Collins in a police lineup was not based on the photograph they were shown days earlier. Both women refused to base their identification on a photograph. The other motions were summarily swept aside. There would be no mistrial ruling or new trial for John Norman Collins that day. Fink vowed to take the case to the Michigan Court of Appeals in Lansing. At the conclusion of the hearing, there was no rush to the telephones by newsmen. The handful of reporters and spectators quietly filed out of the courtroom in marked contrast to the trial. The only commotion was when Detectives Couch and Preston hustled Collins from the courtroom through the prisoner tunnel leading to the parking lot on the north side of the building. Later, the sheriff's deputies said Collins told them he hoped to get a job as an X-ray technician in the prison hospital. The California extradition sword of Damocles hung over Collins' head. He still faced another murder trial, but this time in a capital punishment state. On August 31, 1970, Monterey County District Attorney Bert M. Young reported that California officials would petition the state of Michigan in a week to 10 days for the extradition of Collins in the wrongful death of Roxy Ann Phillips. In his press conference, District Attorney Young said the proceedings usually take 30 to 60 days. Then he outlined the process. First, the Monterey District Attorney originates an application to Governor Ronald Reagan. Governor Reagan will then sign a requisition form, including a warrant issued against Collins and other legal documents. The paperwork will be sent to Michigan Attorney General Frank Kelly to examine it for legality. At that point, Collins and his attorneys can request a governor's hearing and petition for clemency on the part of Governor William Milliken. The governor would then make his decision. On October 8, 1970, the Monterey County Prosecutor's Office airmailed a request by California Governor Ronald Reagan formally asking Michigan Governor William Milliken to extradite Collins to answer to a grand jury indictment for the first-degree murder of Roxy Ann Phillips. Certain conditions had to be met before Milliken would release Collins to California. The state of California would have to agree to pay all expenses for transporting Collins and returning him immediately to Jackson State Prison after the California trial, to serve out the remainder of his term in Michigan. Collins was ineligible for parole, but could be pardoned after 20 years. He had already served 2 years behind bars in Washtenaw County Jail that would be deducted from his sentence if a future Michigan governor should choose to pardon him. The extradition request, in the form of an executive agreement between two states, was handed over to Attorney General Frank Kelly on October 12, 1970. He checked it for legality before handing it off to the governor. In a letter to Milliken on October 19th, Attorney General Kelly asked Governor Milliken to make a formal agreement with Governor Reagan under the Uniform Extradition Act to ensure Collins' return to Michigan to serve out a sentence. Kelly explained there was case law in California that if a convict were extradited, it was considered an act of clemency by the sending state, and it precluded any further confinement or punishment. If this rule were to be followed by the California courts, there is a danger the state of Michigan might never see John Collins again, Kelly warned. If Collins was found not guilty in California, he would be a free man. Joseph H. Thibodeau, chief legal advisor to Governor Milliken, announced in a Lansing press conference on November 20, 1970, that the California extradition papers had some faulty provisions and were being returned to Governor Reagan's office for correction. The sticking point was worked out. It was now established on firm legal ground that extradition of Collins to California would not be considered an act of clemency on the part of Michigan. Thibodeau announced further that defense attorney Neil Fink was now Collins' sole attorney and would be notified when the revised documents arrived. On January 20, 1971, Neil Fink made an unusual request: that an extradition hearing be held in Jackson State Prison. Fink asked that the hearing be closed to the press and the public. On February 2nd, Governor Milliken announced he had scheduled a closed hearing at the Jackson Prison for Monday, February 8th at 1:30 p.m. His legal aide, Kenneth Franklin, would preside. Franklin said before assembled press reporters in Lansing that the decision to hold a closed hearing in the prison was made for security reasons. The cost of providing security for Collins in a Jackson County courtroom would be prohibitive. When Jackson Prison Warden Perry Johnson was reached for comment, he said, "In my 2 decades of penal work, I have never before heard of an extradition hearing being held in an institution. The hearing will take place in a conference room used to conduct parole hearings." Warden Johnson added he would hold a press conference afterward to inform the media of the outcome. A reporter asked the warden about rumors of Collins being beaten by other prisoners. "There is absolutely no foundation for these stories. There is no record of Collins being treated in the prison hospital and no report of assaults on him. He was brought to my office and asked about his mistreatment. Collins told me he hadn't been assaulted and he had no problems. Presently, he is working in the prison store as a stalker." When the day for the hearing came, it lasted only 10 minutes. At the press conference afterward, Kenneth Franklin said, "The hearing was called to give the defense a chance to present equitable facts which the governor might use in denying the extradition." Fink insisted he was entitled to subpoena witnesses, confront the governor personally, and obtain a verbatim record of the hearing. He complained Collins was being denied due process. Fink's demands were denied, and the hearing was brought to a close. On February 25, 1971, Fink vowed to file a federal suit in Detroit aimed at blocking Collins' extradition. On March 5, 1971, Federal District Court Judge Lawrence Gabow denied Fink's defense claim that the Collins extradition raised substantial constitutional questions. The federal judge disagreed Collins was denied due process of law at the hearing because Fink could not call any witnesses and he could not personally confront Governor Milliken. Undeterred, Fink said he now planned to appeal the decision to the Sixth Circuit Court of Appeals in Cincinnati. Meanwhile, the extradition process was at a standstill. Milliken announced he wanted to wait until all federal suits were decided before making his decision to extradite Collins. 4 months later, Governor Milliken's legal advisor and spokesperson, Kenneth P. Franklin, held an unscheduled news conference. "Today, we got word from the Monterey County District Attorney that he has a backlog of murder cases from a San Quentin prison riot, and he wants to hold up for a while on the Collins extradition until he gets the other cases out of the way." The Monterey County courts had 12 murder cases on their docket, and they were in no hurry to acquire another one. 2 days later, on June 10, 1971, Governor Milliken said in a Lansing, Michigan press conference that he received word from Governor Reagan that the extradition proceeding against John Norman Collins should be halted, pending disposition of 2 appeals now in the courts. New trial motions were filed by Neil Fink, one in the Michigan Court of Appeals in Lansing and the other in the United States District Court in Detroit. Governor Milliken said Governor Reagan felt it would be inappropriate to remove Collins from Michigan to California until all appeal procedures were exhausted. Finally, on January 4, 1972, Lansing state capitol sources said the California request to extradite Collins for the murder of Roxy Ann Phillips is closed and will not be reopened. The Monterey County District Attorney spokesman, Tom Kennan, responded, "This office has elected not to pursue extradition against Collins because this case does not deserve priority attention from local authorities." Other reasons stated by the Monterey County Prosecutor's Office were a huge backlog of murder cases and a lack of scientific evidence. After the trouble the Michigan jury had with conflicting hair evidence experts, their office was reluctant to base their case on similar evidence. Many observers believed the Phillips case was stronger than the Beineman case. 2 years before, 2 Michigan state policemen traveled to Salinas and helped with the California murder investigation. Washtenaw County Prosecutor William Delhey was clearly disappointed in the California decision. If this was a minor crime, a larceny or something like that, they, California, might be justified. But murder is an entirely different ballgame. If nothing else, I think their timing is poor. An irritated Sheriff Harvey told local reporters, "Apparently they're, Monterey County, balancing a human life against money, and the money wins out. This is the age-old battle of the bookkeeper and those who want justice done. Justice with a dollar sign is what it is." Harvey was responding to a California district attorney's statement that to try Collins for murder and then return him to Michigan to complete his life term would cost upward of $100,000. "They have a strong case against him out there," the sheriff noted. "But I guess that doesn't mean anything if it's going to cost a few dollars." An even more cynical view may have factored into California's decision not to extradite Collins. Neither Collins nor Phillips was a California resident. The Monterey County prosecutor made a cold-blooded decision that their budget was better spent adjudicating crimes committed by California residents. They decided to spare the expense and let justice take a holiday. The long-awaited appeal of the Collins verdict and sentence was taken to the Michigan State Appeals Court in Lansing on December 15, 1970. Filing a claim of appeal was the first step in getting the court to hear the case. The claim read, "Defendant Appellant John Norman Collins claims an appeal from the judgment of conviction and sentence of imprisonment pursuant thereto and from the opinion and order denying his motion for a new trial." Fink told a small group of reporters the substance of the appeal briefs was the same as the motions filed in their Washtenaw County court bid for a mistrial denied on November 12, 1970, by Judge Conlon. In addition, Fink moved that a new judge be assigned to the case, casting aspersions on Conlon. Fink informed the press that Washtenaw County court reporters must prepare transcripts with briefs and submit them to attorneys for the defendant and the state before a claim of appeal could be heard by a 3-judge panel. "I never anticipate failure," Fink said. "I think we have a very meritorious appeal." On July 9, 1971, Neil Fink announced he had received copies of the trial transcripts earlier in the week and had 90 days by law to file a formal appeal. Then, the attorneys for both sides of the case had 60 days to file briefs. The defense brief submitted to the appeals court contained the results of an informal, but not court-ordered, survey by a University of Michigan professor. He concluded before the trial began it was impossible for Collins to get an unbiased trial in Washtenaw County. The survey sampling was limited, and the results were never entered into evidence at the 2-month-long trial. Washtenaw County Assistant Prosecutor John J. Hensel filed papers in Lansing on December 1, 1971, to dismiss the appeal request and strike the part of the appendix that contained material from sources other than the trial transcripts of the court proceedings. On January 20, 1972, the Collins trial court record was returned to the Washtenaw County Courthouse. The Michigan Appeals Court 3-judge panel denied the defense suit and struck the public opinion survey from the court record. There was only one more place to go. On Wednesday, April 3, 1974, Fink filed papers to have the Collins case heard by the United States Supreme Court. But on Friday, April 19th, the High Court returned the trial transcripts to Washtenaw County and refused to hear the case. There was no evidence any federal constitutional provisions were at issue. Collins and Fink had exhausted every avenue for appeal and finally hit a brick wall. 32. The Canadian Gambit. After 7 years at Jackson State Prison, on September 19, 1977, MDOC Deputy Director Brown transferred Collins to Marquette Branch Prison in Michigan's remote Upper Peninsula. Marquette Branch Prison is Michigan's maximum security facility for the state's most difficult prisoners. Brown advised prison officials to place Collins under close supervision. The above resident, John Norman Collins, has been in the SPSM, Jackson Prison, population since 1970. At various times, he has been under investigation for a variety of illegal activities, including drug smuggling, loan sharking, etc. Of recent date, we had an escape attempt from inside the walls in which Mr. Collins, during early investigation, admitted being involved as a co-conspirator. Later, in denying his involvement, he admitted being involved with drugs and money. Based on this information, we believe that maximum supervision is indicated. Risk designation: very high risk. Sitting before the Security Classification Committee at Marquette Branch Prison, Collins admitted to drug trafficking and illicit green money transactions while at Jackson, but he denied aiding and abetting another prisoner in a successful escape attempt. Private investigator John Whalen, contracted by MDOC, discovered Collins was involved in the escape of inmate Robert Taylor at Jackson and was implicated in many nefarious institutional activities. At a security classification hearing held on September 9, 1977, Collins admitted to Deputy Grant and the Michigan State Police that he conspired with Resident Taylor in the escape attempt. During the interview, Collins said he promised several $1,000s to Taylor if he would assist him in escaping from Jackson. Incredible as it may sound, Taylor was to return to the prison by helicopter and land in the exercise area where Collins would be waiting to be airlifted out. Robert Taylor escaped from Jackson State Prison on June 5, 1977, and remained at large. During Collins' interview, he told prison officials he was fearful for his mother's safety and asked to contact her, warning of the possible danger. Collins asserted Taylor would kill his mother to get money from her. In his residence statement at Marquette Branch Prison, Collins denied making those statements about Taylor. He wrote he did not believe he was a threat to security and good order at Jackson State Prison, and he did not want the Marquette branch prison transfer. Collins feared a transfer would interfere with visits from friends and family. The committee was unmoved and recommended the transfer. Upon his arrival at Marquette Branch Prison on October 25, 1977, Collins was placed in protective custody. He wanted to enter the general population and stated that the threats upon his life were not real, and part of a ploy to cancel his transfer to Marquette. Collins was advised to inform staff of any adverse reactions toward him by other prison inmates, and he would be gradually assimilated into the general prison population as space became available. Collins told the classification committee, "They didn't want me down in Jackson. I didn't have nothing to do with the escape. Mr. Grant told me I was involved. Yes, I received a copy of the report. I didn't do anything to help him, Taylor, escape. If I did, I didn't know if I would say so. I've come to accept prisoners threatening me because of my crime. I don't know what the paper said in regard to my life being threatened at Marquette. I didn't say my life would be threatened any more or any less at Marquette than at Jackson. No, I didn't tell my attorney there are people at Marquette who had previously threatened me at Jackson. They said they would fuck me up. Maybe it's all talk. They do things for kicks, you know? I'd like an opportunity to prove myself. It's confusing to me, too." The committee responded. Resident Collins claims he has been threatened in Jackson by many residents, some presently at Marquette. He claims he does not know who they are since the threats happened at Jackson and were rather frequent because of the nature of his crime. After portraying himself as an oft-threatened prisoner, although in vague terms and without detail or names, he commences to question the validity of the threats, stating some prisoners do these things for kicks. It appears he would want us to believe he feels threatened, and also not threatened, as he weaves his story in an obvious manipulative fashion. The committee will approach this case with caution and feels protective custody is appropriate at this time. The classification committee determined Collins should be excluded from the general population and placed in 5 West with a 000 designation. Administrative segregation. With all his appeals exhausted, Collins found another promising avenue for an early release from his Michigan life sentence. On June 10, 1980, Governor Milliken signed an agreement with neighboring Canada to exchange prisoners to serve out the completion of their sentences in their home countries. H.R. 4308. The act joined the state of Michigan to the terms of a 1978 treaty between the United States and Canada. Collins was born in Windsor, Ontario, across the Detroit River, and became a naturalized American citizen at age 5. On June 18, 1980, the Canadian Consulate Vice Consul in Detroit, Douglas Frame, wrote a letter to Al Jandron, supervisor of records for the MDOC, asking for information. "Can you confirm that Mr. Collins is a Canadian citizen, and if so, could you let me know the particulars of his incarceration?" Consul Frame agreed to personally interview Collins on his next trip to Marquette Prison. A week later, Jandron responded, "We are unable to confirm Mr. Collins is a Canadian citizen, since our records only have Mr. Collins' statement that he was born in Windsor, Ontario on June 17, 1947. We do not even have a detainer filed by the Canadian Immigration Service. Proof of his Canadian citizenship would have to come from some other jurisdiction rather than ours." A copy of Jandron's letter was sent to the Marquette prison warden. 7 months later, without public notice, John Collins acted as his own attorney and quietly applied for a name change in the Macomb County Court on November 10, 1980. Probate Judge James F. Nowicki set January 5, 1981 for a hearing on the matter. On that day, Deputy Registrar of Probate Court for the County of Macomb, Maureen M. Fraser, certified a name change for John Norman Collins to John Norman Chapman. Since he was 3 years old, John had little or no contact with his Canadian birth father, whose last name was Chapman. After John went to prison, his father began to correspond with his son and reconnected John loosely with his Canadian relatives. This was the basis of his transfer claim. He had family in Canada. The change of his last name obscured who he was in the paperwork. Collins had plans for his new identity. Writing to Jandron on Monday, June 29, 1981, Collins/Chapman asked for paperwork and information about the Transfer Offenders Act. Chapman also wanted to know if Judge Conlin's letter, dated March 11, 1981, was forwarded to Jandron's office. He wanted credit for his time served in the Washtenaw County Jail, 1 year and 29 days. This credit was significant in John's mind as part of his overall transfer bid took shape. In a letter dated July 21, 1981, Chapman complained directly to Warden Kohler. "I am a Canadian citizen and wish to transfer to Canada under the Prisoner Exchange Treaty between the U.S. and Canada. The Canadian Consulate, Mr. Douglas Frame and Mr. George Stiffenbacher from the Federal Bureau of Prisons in Washington, D.C., told me I must write to you for the necessary forms. Every state prison has received a copy of the treaty and all the necessary applications and forms. Jackson State Prison and Ionia Reformatory have the papers, so Marquette should have them too. I have been trying to get information about the treaty, etc., here at Marquette for the last 18 months, and all I get is a big runaround. Please send the necessary papers to me right away." The warden sent the information to Al Jandron, and the next day he and Chapman processed the transfer paperwork and sent it off. The inquiry, signed by Chapman, read, "I hereby indicate an interest in being transferred to continue serving the sentence imposed by United States judicial authorities to the country of citizenship indicated above, Canada. I understand this is just an inquiry to obtain data before the actual request for transfer and is not binding upon either the government or me." On August 7, 1981, Marquette Prison Warden T.H. Kohler wrote Robert Brown, Jr., Deputy Director of the MDOC. Kohler had checked the qualifications for transfer to foreign countries and believed that this resident, John Norman Chapman, meets the necessary qualifications at this time. Certified copies of the record of sentence, parole eligibility report, and basic information were sent in the mailing. On a Marquette Prison Classification Committee recommendation dated December 27, 1981, Chapman was scheduled for transfer from Marquette Prison on December 29th, guarded by prison personnel, to the Kinross Correctional Facility. He would then be shuttled immediately into a Riverside Correctional Facility van and taken to Riverside on the same day. From there, he was to be taken to Jackson State Prison to await a hearing in Detroit on January 11, 1982. These arrangements were made by Mary Benjamin from the Marquette Branch Prison Central Office, assisted by Al Jandron on December 28th. When the day of the verification hearing for the transfer came, Ottawa, the Canadian government, had not completed its paperwork for the formal approval of the transfer. The hearing was knocked off the docket and postponed. On the list of possible transferees was John Chapman. He was one signature away from the scheduled transfer on Friday, January 29, 1982. The first news report of the Collins/Chapman transfer appeared in the Detroit Free Press on Friday evening, January 15th. Perry Johnson, State Corrections Director, responded to reporters saying, "The first I heard of it, the transfer, was the 19th of January. I asked Deputy Director Brown about the news. He told me he hadn't realized that by signing Collins' application, he had given the state's approval. He said he was aware who John Chapman was when he signed the application and was opposed to the transfer. I told him to immediately call the United States Justice Department to tell them we made a mistake on this." The next day, Wednesday, January 20th, 1982, Perry Johnson announced in Lansing that the state had officially denied the transfer request of John Chapman because it was preliminary. On the same day, Deputy Director of the MDOC, Robert Brown, shattered the hopes of John Collins/Chapman with this letter. "Dear Mr. Collins, as you know, this office has submitted an application to the United States Department of Justice for a possible transfer to your country of citizenship. However, I recently learned through diplomatic channels that you would have minimal family contact in Canada, since most of your family resides here in the States. Further, you spent the majority of your life here in the States. Since the main purpose of the treaty is to provide reintegration into society, and since this reintegration would not be possible in Canada, I am revoking our consideration of your transfer request. I am sorry I could not give you a more favorable reply. It was clear that Michigan prison officials responded to public outrage and pleas from the family of Karen Sue Beineman. On January 21st, Gail Light, Michigan State Corrections spokesperson, put the best spin on the embarrassing situation she could. State officials had no intention of transferring Collins. Deputy Director Robert Brown signed a form that showed Collins/Chapman met our criteria. Such a transfer between the United States and Canada would be subject to approval of both governments under the terms of the 1978 treaty. Robert Brown could not be reached for comment. On January 22, 1982, MDOC's Classification Committee ordered the return of John Norman Chapman to Marquette Branch Prison to serve out the remainder of his life term in Michigan. The next morning, Chapman was in a prison van heading up north, fuming, no doubt. He had been so close to repatriation and a better parole deal in Canada. When Collins returned to Marquette, no cell was available among the general prison population. Prison authorities did not expect him back, and Collins had not expected to be back. Before leaving Marquette, he sold his prison possessions, including an 11-inch black and white television. As Jim Newbacher wrote in a February 28, 1982 Detroit Free Press article, at the last moment, in a swirl of publicity, political pressure, and bureaucratic backpedaling, his, Collins, application to serve his time in his native Canada was denied by state officials. On February 22, 1982, the backstory of a Marquette inmate's prison leak that halted Collins' transfer was reported. It was revealed that a letter landed in the Free Press newsroom mail rack on the morning of January 14th. It was addressed to the assistant city desk editor, William Hart. He often wrote about Michigan prisons and corresponded with this inmate before. 4 paragraphs of a multi-page handwritten letter caught the editor's attention. 2 weeks ago, John Norman Collins was released to Canadian authorities. The letter claimed Collins planned to use a different name, Chapman, once in Canada, and he would be eligible for parole in about 2 years. This was possible, the informant wrote, with dollars being spread in the right areas. The letter continued, I would normally not pass information like this out, but if he's guilty of butchering young girls, then he's not the safest kind of dude to be put where he could repeat, and that could be the case in the not-too-distant future. Free Press editor Hart had heard nothing public or private about a transfer of John Collins. He was not convinced the information in the letter was true, and much of it turned out to be inaccurate. Hart assigned reporter Marianne Zhepka to investigate the story. She discovered that attorney Miriam Seifer, an undergraduate at University of Michigan when Collins was arrested in 1969, was appointed by the United States District Court in Detroit to represent Chapman at a Canadian transfer hearing. That evening, Zhepka's story, Transfer to Canada for a Killer, was the front-page headline. A Detroit Associated Press, AP, employee picked up early copies of the Free Press, as was his routine. Back at the office, when AP editors saw the headline, they immediately sent the article out on their wire service. Soon, Collins' Canadian transfer story was on its way to 33 newspapers and 85 radio and television stations across Michigan. Less than a week after Marian Zhepka's story appeared, Michigan revoked approval of Collins' Canadian transfer. When the Beineman family heard about the possible transfer of Collins to Canada, they contacted their local prosecutor in Kent County, whose father was a United States congressman. By the time the Beineman family contacted Washtenaw County Prosecutor William Delhy, he was already in touch with state and federal officials to prevent the transfer. Delhy told Mr. Beineman, "Information from Washington, D.C. seemed to indicate the transfer had the approval of state corrections officials here. The National Parole Board of Canada was to consider the transfer within the next 2 weeks, according to Canadian Consul Douglas Frame. The Beineman family was concerned a Canadian transfer might result in an early release from prison for Collins. Barbara Beineman, the now 40-year-old sister of Karen Sue Beineman, broke the family's 12-year silence and told a reporter, "Whether it's a few months from now or several years from now, he is somebody who should not be released." The details of the transfer came to light when editorial writer George Hutchinson of the London, Ontario Free Press wrote on January 27, 1982, if transferred to Canada, Chapman would be eligible for parole in 1985. He wrote that Canadian law allowed a transferred prisoner who was serving time for a first-degree crime to be considered for parole if he is within 3 years of having completed 15 years of his sentence from the date of his conviction. Bruce Mann, Director of Legal Affairs for the Canadian Corrections Ministry, told George Hutchinson that Chapman would be eligible for a day parole, known as work release in America, exactly 12 years after his conviction date, minus time already served. He could hold a job outside the prison, but would have to return to the prison after his shift. Without the protest from Michigan people, the transfer might have gone through with the signing of one document, the Canadian corrections official told Hutchinson. All that was required for Canadian authorities to officially close the file on John Norman Chapman was written notification from Michigan that their recommendation for his transfer was withdrawn. In a letter dated January 20, 1982, Deputy Director Robert Brown notified Collins his approval for transfer to Canada was revoked. MDOC Prison Director Perry Johnson rescinded the transfer recommendation and sent word to Ottawa. On October 20, 1981, John Norman Collins and his mother Loretta had reason to be optimistic about the international prison transfer. Michael Abel, Director of International Affairs for the United States Justice Department, sent a letter to Canadian authorities in Ottawa. This office and the state of Michigan have approved Chapman's transfer application. If it is approved in Canada, he could be included in a group to be exchanged on January 29, 1982. Canadian Consul Douglas Frame called Loretta Collins with the news, and she cried out with joy. "I was elated," she said. For over 2.5 months after that phone call, people involved in this maneuver had every reason to think John Norman Chapman's transfer was imminent. The Canadian National Parole Board needed to review the case and classify his crime according to Canadian law. Then the board would set a parole eligibility date and send the case to Canadian Solicitor General Robert Kaplan for final approval. When Mrs. Collins heard that her son's transfer had been rescinded, she was outraged. "You can't tell me officials could sign all the papers and move him down to Jackson and then tell him they made a mistake. It's politics, dirty politics. John's hopes were raised. He was moved. Then they slammed the door in his face. It's inhuman," she said. Chapman's mother and attorney were still hoping to find a way for John to be moved to Canada. They said they might push for a prison hearing or start a civil lawsuit. "I wouldn't think of helping John if I thought for 1 minute he was guilty. I will not give up," Loretta Collins said. "If Mrs. Beineman can go to the United States Congress, I can too. I can sit on doorsteps for a long time. It's all political." When Collins was returned to Marquette to serve out his life sentence, an unidentified prison source close to him said, "You can imagine how disappointed John was. He was shattered, absolutely shattered. He began to talk of suicide." Then, on February 28, 1982, Chapman granted the Detroit Free Press a 2.5-hour prison interview, the first in 5 years. He was friendly and open during the interview, but seemed nervous and declined to be photographed. His hair was longer and parted in the middle, and he had grown a mustache. At one point, he tapped his index finger on a paper, outlining MDOC's 16-step procedure on prison transfers. "If they'd denied me here, at step 5, like it says, I'd have been pissed, but I could have accepted it. I can't accept this. I won't accept this. The reason I want to go to Canada is to get away from the hostility I get here. When I first arrived at Jackson in 1970, 3,000 people knew I was coming. They had my articles up on the gym wall. People in there were jealous when they saw the amount of publicity I was getting. I hate it. If the governor told me I had to go over there, Canada, and start over from day one, I would go. Politics and publicity combined to rob me of my constitutional rights. I don't blame the Beineman family for lobbying against me. I can understand that. They have a right. The thing is, I never killed their daughter in the first place. But I can't accept the actions of state prison officials. I'm not going to give up. They're wrong. They're wrong as hell. I think my transfer was denied because of vindictiveness, and that's not what the treaty is all about. I hope to get out someday. If I didn't, I'd go off the gallery, commit suicide. I know that I can do good. I know that I can become a productive member of society. That's what fucks me up. John Collins/Chapman wrote MDOC Deputy Director Robert Brown to reconsider his disapproval of Collins' transfer request. Brown replied on MDOC stationery, "It is the intent of the state of Michigan that you serve your entire sentence under the jurisdiction of the state of Michigan." 5 years after Robert Brown withdrew his permission for Chapman's transfer, Chapman filed a civil lawsuit against the now director of MDOC. Chapman and his lawyer, William S. Dobreff of Warren, Michigan, contended Chapman was denied his right to due process and equal protection under the law. On January 12, 1987, United States District Court Magistrate Thomas Carlson, in Detroit, heard oral arguments on a motion by Michigan Assistant Attorney General Louis Porter for a summary judgment dismissal of the civil suit. Porter, appearing for the state of Michigan, argued the transfer treaty did not have strict guidelines, and therefore the reversal of the recommendation for the Canadian transfer was within the warden's discretion. Federal Magistrate Thomas Carlson had 60 days to respond to the oral arguments. 1 month later, on February 13, 1987, in a report to United States District Judge Avern Cohn, Carlson ruled that Chapman failed to establish any violation of his federally secured constitutional rights. Collins' request to return to Canada was summarily denied. This episode was officially closed on September 23, 1989, when Senior Border Patrol Agent Herbert H. Markle wrote to Cindy Greenleaf, the record supervisor at Marquette Branch Prison, to remove any holds this service, U.S. Immigration and Naturalization, has on Mr. Chapman. It has been confirmed he is a naturalized United States citizen. In addition to the inherent ambiguity over the Collins/Chapman name change, another prisoner by the name of John Chapman became a resident inmate of Marquette Prison. Their jail mail was getting mixed up. MDOC policy now requires that inmates be referred to, in prison documents, by the same name they were convicted under. 33. Doing time. In his almost 50 years in Michigan prisons, John Collins has had over 10 major misconduct hearings, according to MDOC documents obtained through the Freedom of Information Act. Misconduct can result in a number of consequences if the resident is found guilty. The penalties range from being classified to a higher level of security, forfeiting 5 days of disciplinary credits earned for the month in which the misconduct occurred, or losing accumulated good time or disciplinary credits if ordered by the warden. These documents show Collins within the prison environment interacting with other inmates and the prison system. Collins/Chapman, number 126833. Major misconduct hearings. 1. September 5, 1977. Disobedience of rules. A guard noticed a wire running from inside cell 87B to the underside of the first gallery 4 nights in a row. Collins was warned the first 3 times, and on the 4th, the wire was confiscated. Corporal Schultz wrote him up. Found guilty, 2 days of top lock and privileges suspended for 30 days. Top lock is a punishment where an inmate must be on his bunk unless at chow. 2. June 30th, 1980. Possession of gambling paraphernalia. In a statement taken after being caught, he said, "You busted me with tickets. What can I say?" Prison guard John C. Clark shook down Collins in the print shop. He had 104 gambling tickets made in the prison, with values marked on them from $0 to $2. Found guilty. 2 days of top lock. 3. February 19th, 1988. Possession of gambling paraphernalia. Now using the name Chapman. A resident by the name of Hedger submitted a statement saying the betting slips were his, but Officer Demers reported he noticed Chapman, a.k.a. Collins, place 2 legal-sized sheets of paper into his glove. During a shakedown, I removed the paper and noticed names of prisoners, money amounts, team names, and behind the names were numbers such as 4, 5, 6, and 6RR. Chapman stated to me, "That's my store list. I need that," referring to the 2 papers removed from his glove. Found guilty. Loss of privileges for 30 days. 4. February 21st, 1988. Possession of dangerous contraband. During a shakedown of Chapman's possessions in the property room, Officer Shane Place discovered a Rayovac flashlight, 2 pieces of nylon rope, 23 feet 8 inches, tied together, and a drawing of the attic area of Marquette Prison. Upon personal inspection of the nylon cord, it was noted it could support a great deal of weight. If the 23-foot section of cord were to be doubled over, it would be more than strong enough to climb with, and it would still be over the critical 8-foot definition of a critical tool. Found guilty. 30 days loss of privileges. 5. February 21st, 1989. Possession of money. 3 packs of chewing gum were found in a sealed footlocker belonging to John Chapman, with other items such as clothes, pens, pencils, photos, shaving gear, cosmetics, and candy. The gum did not appear on a packing list. When Officer Michael Wickstrom examined the packs of gum, he noticed the ends had been resealed. He took out the 5 sticks of gum and bent the first 2 sticks. The 3rd stick would not bend. He unwrapped the stick of gum and found 2 bills totaling $150 snugly fitted into the gum wrapper. He found the same result when he opened the other packs. Another had $200 and the 3rd had $100. The center stick in each pack was the best placement for concealing the money. Chapman stated someone must have tampered with his stuff or he was being set up by the prison guards. Found guilty. 7 days of top lock and 30 days loss of privileges. 6. March 10th, 1989. Creating a disturbance. Chapman was going to the mini-law library. Officer Dennis DeRocha's report read, "An inspection of some of the material he, Chapman, was going to bring into the library and found some material not allowed there, according to Housing Rule Number 17. When told by Officer Dennis DeRocha he could not bring it in, Chapman started screaming and hollering, 'You can't do that. You'll see.' Then other prisoners in the cell block started hollering and yelling the same thing. Chapman continued to yell for several more minutes. At the hearing, Chapman denied he created a disturbance. Guilty. 7 days loss of privileges. 7. November 13th, 1989. Insolence. Sergeant Frank Sulskis reported that after denying Chapman a pair of tennis shoes, he called from a distance and said, "Sulskis, you're a motherfucker." Chapman parsed words and claimed he said, "Sulskis, you are acting like a motherfucker." Chapman made the insolent statement to harass the officer and was guilty as charged. 4 days loss of privileges. 8. December 22nd, 1990. Possession of dangerous contraband in Riverside Correctional Facility. While conducting a shakedown of Chapman's cell, Officer J. McQuaid found 1 bottle of whiteout on Collins' desk, 6 metal paper clips, and a piece of carbon paper. The whiteout brand contained trichloroethylene, a prohibited substance per prison policy PD BCF 30.07. Resident found guilty of possession of dangerous contraband, 030. Penalty: time served, 6 days of detention for 6 credit days. 9. December 3, 2008. Possession of dangerous contraband, possession of money, and contraband. While doing a shakedown of Collins, Chapman's name reverts back to Collins, property, an officer whose name is illegible on the misconduct report found a number of suspect items. One was an incendiary device, a container of Vaseline with 3 wicks that at some point had been lit. Collins claimed he got the container from another prisoner and had not examined it. Also found were 2 pennies, 2 sharpened items fashioned as a screwdriver and a sticker, 3 needles approximately 3 inches long, 8 boxes of staples, 1 TV channel changer, 3 plastic pens with melted tips, 1 extension cord with one end cut off, 55 United States stamps totaling $12.09 hidden inside a typewriter, several screws, and 1 bag of pushpins. Collins was found guilty of all charges. 14 days loss of privileges. 10. December 23, 2008. Threatening behavior. An outgoing letter written by Collins was screened, which stated in part, "I may have to punch Alexander in the nose when I see him, though. It would get me out of Marquette." Alexander was the deputy warden. The prisoner's statement claimed he said may, which does not imply he would do it. Collins believed he could avoid consequences for his writing because of his constitutional freedom of expression, but prison officials were not persuaded. Resident Collins received 30 days detention and 30 days loss of privileges. August 11, 2011. Possession of dangerous contraband and possession of a dangerous weapon. While doing a shakedown of Collins' property, Officer B. Durano discovered matches and pieces of metal hidden in his cell that were capable of being made into weapons. One piece was sharpened to form a cutting or slashing edge. Also found out of compliance with prison policy were 1 photo album, 1 can of black shoe polish, altered wires, miscellaneous parts, 1 green army fatigue jacket, and 2 pairs of shower shoes. Only 1 pair is allowed. Collins received 30 days detention and 30 days loss of privileges. In addition to his serious misconduct hearings, Collins has had over 50 administrative hearings covering a wide range of issues. Notice of package rejection hearings were often held over disputed material Collins felt he should have received. On December 11, 1989, 2 handmade Christmas cards containing glitter and Elmer's glue made by Collins' twin grandnieces were deemed a safety and security issue by prison authorities. On January 12, 2004, a Hallmark calendar was withheld from Collins because it was not purchased in the prison store. These rejections may seem like petty tyranny, but the prison has rules that inmates must obey. Some package rejections were clearly infractions of MDOC policy. On August 3, 1995, the relative of another prison inmate sent Collins a money order for $40 from a fictitious address in Ypsilanti. At the hearing, Inspector Magadans stated, "A review of a taped telephone conversation indicates the funds were sent from another prisoner's family member. In that phone conversation, this prisoner had specifically spelled out John Chapman's name and listed his prison number, along with the amount sent, $40. Collins said, "I don't see the connection between this money order and what another inmate did on the phone. I can't control another prisoner. Other people send me money. What authority do you have to return it to the sender? You can't put it in the inmate benefit fund?" In the end, the $40 was placed in the inmate benefit fund. MDOC policy PD-04.02105 clearly states funds cannot be sent to a prisoner by unidentified sources or by other prisoners, parolees, or family of same. Hearing officer Robert J. Wood concluded, "It is clear this is, in fact, an attempt by one prisoner to send money to another prisoner. By falsifying the name of the sender, and because no such address exists in Ypsilanti or Ypsilanti Township, the source of the money order is now unidentifiable, and as such cannot be returned to sender." It is interesting to note how Collins disassociates himself from the money, or any attempt to have it sent to him, yet he asserts that prison officials do not have the authority to do that. He wants to control, by veto, where the money will go. On March 17, 2008, a death index record was withheld from Collins because it contained a Social Security number not belonging to him. "It is my grandmother's Social Security number, and I should be allowed to have it," he demanded. The other contents of the mailing were sent to Collins. The MDOC policy covering this infraction is PD 05.03.118, which states in part, "Mail shall be prohibited if it is a threat to the security, good order, or discipline of the facility, may facilitate or encourage criminal activity, or may interfere with the rehabilitation of the prisoner. Legal forms of identification may be used to acquire other identification that can be used in criminal activity." What plans, if any, Collins had for his grandmother's Social Security number can only be guessed. It is rumored his grandmother and mother set up a bank account contingency fund, if John ever made it to Canada, but no proof of that exists. Other administrative hearing reports deal with more serious matters. For instance, early on in his incarceration, February 1974, Collins got into a fight after being elbowed in the left eye by an inmate named Allen during a rough basketball game. A yard officer yelled at them to stop and blew his whistle before they broke it up the first time. Officer Mahi reported that the two men scuffled again before they stopped. Both men claimed they were just playing around. In a hearing dated March 1, 1974, resident Allen admitted to accidentally coming down with his elbow, striking Collins next to his left eye. They had a shoving match and broke it up after the whistle was blown. Then they started up again. Collins did not remember starting up again. Both men agreed no blows were struck, and they stated they were friends and locked next to each other. The hearing committee believed the dispute went beyond the bounds of a verbal exchange, and both inmates were advised of the seriousness of the situation. Each man received 5 days detention with suspended sentence and then were removed from the honor block. One of the more interesting asides to Collins' prison tenure happened when he was a kitchen worker at the Park Davis Clinic. Collins and another resident named Hayton were accused of stealing large amounts of sugar and making spud juice. On April 23, 1976, residents Wright and resident George got into a fight over gambling debts. Both men had been drinking this spud juice, and prison personnel soon found out where they got it. Despite writing a 2-page statement denying any culpability in this incident, Collins was removed from his honor assignment at Park Davis and was placed on restricted job status. Almost 10 years later, during a shakedown, Collins was discovered by prison guards to be running a store out of his cell. $45 of expendable store items were confiscated, placed in a duffel bag, and brought to the inspector's storage room. Collins' inventory was disposed of, per prison policy PD-DWA 53.01. Excess property and contraband were recurring issues with Collins. On March 1, 1988, a hearing was held regarding an extra footlocker Collins used to store his legal records and pending legal matters. At this hearing, the MDOC granted him the extra footlocker, but during screening, excess property was found. In addition to a TV and a Walkman with altered numbers, prison staff reported a sewing machine, a typewriter, 1 piece of pink plexiglass, 3 rolls of masking tape, 1 altered alarm clock, 20 pieces of torn-up clothing, 2 large white cloth bags, 1 large plastic bag, 1 metal antenna, 1 box of staples, 2 rolls of athletic tape, 2 rolls of electrical tape, 1 large bottle of an unknown liquid, 6 bottles of paint, 1 small bottle of an unknown substance, 1 large squeeze bottle of an unknown substance, 1 broken pair of scissors, 1 large metal ring, 1 blue metal box of T-bolts and wire, 1 large piece of fiberboard, and 2 metal clasps. Clearly, Collins was out of compliance. Other prohibited contraband also found were 5 magazines showing explicit sexual acts. At a hearing held a month later, Collins stated he wanted his magazines back and claimed they did not conflict with prison policy. But MDOC policy PD-BCF 63.03 states, "Prisoners shall not be allowed to receive the following items or publications as they are considered a threat to the order and the security of the institution or to the rehabilitation of prisoners. Material describing or showing acts of homosexuality, sadism, masochism, bestiality, sexual acts involving children, or any other unlawful sexual behavior." Over and over, Collins is found with contraband or excess property items. Here is a partial list of some of the more interesting finds. February 23, 1989. During a general shakedown of his cell, Collins had the following contraband: 1 paintbrush, 6 road maps, 2 light adapters, 2 can openers, 13 felt tip pens, 2 metal cans of shoe polish, 3 rings, and 1 roll of Scotch tape. The prisoner was allowed to keep 1 wedding band and 4 map books not showing any Michigan roads. Everything else was destroyed. June 13, 1989. Contraband found. Collins had 1 Greenfield jacket confiscated. His residence statement said, "I've had that jacket all this time, and all of a sudden they say it's contraband. It's not camouflage as PD-BCF-53.01 states. It's a solid color." Section 3, paragraph A states, "Clothing traditionally worn by persons in various professions, such as clergy shirts, doctors' and nurses' uniforms, or military camouflage clothing is prohibited." The coat was a United States Army fatigue jacket that could blend in with the forested countryside of Michigan's Upper Peninsula. The coat was disposed of. March 11, 1990. During a shakedown of Collins' cell, a Miami Dolphins jersey was found with another prisoner's number on it. Collins' cover story was he got the shirt from another prisoner who was leaving and getting rid of some of his clothes. Prisoner LaFrance was giving his stuff away and selling most of his stuff. He owed a lot out. Prisoner LaFrance reported the Dolphins jersey stolen prior to being transferred. It was returned to him at his new location. January 21, 1993. 100 United States postage stamps and $71 worth of store goods were in excess of prisoner property limits. 15 stamps were returned to Collins, and he was allowed to pick out $45 worth of store goods. The rest was confiscated as excess. January 4, 2001. Excess property. During a routine shakedown of Collins' cell, 22 magazines were found. Collins requested they be sent home. The property was held for 30 days and disposed of per prison policy. August 12, 2004. During a pack-up of Collins' cell, he was found to be seriously out of compliance with excess property and contraband. A partial list of items found in his possession were 1 altered extension cord, 1 pair of steel-toed boots, 1 crucifix necklace, 37 pornographic magazines containing explicit scenes and or stories on bondage and swinging, numerous pages torn out of adult magazines of a sexual nature, 1 coiled extension cord with large jacks, 1 large ace bandage, 2 jackets, a broken pair of glasses, 1 hard plastic brush, 1 sewing kit and sewing materials, 1 pair of weightlifting gloves, 1 homemade dream catcher, 1 pair of COS-altered headsets, 1 plastic bag with shoelaces and Velcro strips, 9 TV jacks, 1 piece of mirror, 1 AM/FM cassette player, 1 pair of knee braces, 51 assorted magazines, and assorted hobbycraft art materials. Collins' prisoner's statement said, "Most of the stuff I have collected over time. I can't seem to throw anything away. I have a medical detail for the boots and the knee braces. The cassette player is mine. The other piece of sound equipment is just a radio. I will send some of the items out to a friend with the rejected tapes I got a few weeks ago." The hearing officer's findings indicated that one of the jackets belonged to another inmate named Cubits and was returned to him. The 51 assorted magazines were donated by Collins and sent to the Q Unit book rack. The rest of the items were either destroyed or sent out of the facility at the prisoner's expense. Several items of a legal nature were returned to the prisoner. 4 file folders, each thick with materials. One folder contained information on Canadian treaty and transfer issues. Another folder contained information on class actions, consent decrees, and more Canadian material. The third file contained information on his case and correspondence with people working on various issues in his criminal case, and the fourth folder file held miscellaneous items. December 3, 2008. Collins was found to have 2 duffel bags packed with his property while he was in administrative segregation. Prison Policy PD-04.07.112 states, "Prisoners in Level 5 shall not have property which exceeds that which can be contained in one state-issue duffel bag or similarly sized container." In addition to an incredible amount of excess property, the duffel bags contained the following contraband: 27 nude books with penetration, 22 pairs of shoelaces, 2 Brother altered typewriter ribbons, 2 bottles of black liquid shoe polish, 6 toothbrushes, a pair of altered earbuds, 1 packet of string, 1 large mirror, and 1 homemade filter. A partial list of excess items indicated his prison store business was thriving. 9 packages of Bugler tobacco, 1 beef stick, 1 box of Little Debbie cookies, 1 box of Nutty Bars, 11 bags of candy, 2 bags of chips, 1 bag of protein drink, 2 jars of honey, 2 tubs of cheese, 2 packs of Mike and Ike candy, 2 jars of peanut butter, 2 jars of refried beans, 1 jar of peppers, 2 instant lunches, 3 Monster buns, 1 jar of cocoa, 1 large candy bar, 5 Chicka Sticks, 1 leather purse, 1 calendar, 1 cross, 1 bite wing, 1 Michigan Murders novel, 4 Alka-Seltzer packets, 6 flour tortillas, 3 bags of Carr's nuts, 9 boxes of cookies, 3 jars of breakfast drink, 1 large bag of M&Ms, 39 books of matches, 2 bottles of aspirin, 8 AAA batteries, 9 nail clippers, 6 packs of cigarette rolling papers, 12 D batteries, 4 decks of cards, 9 skin creams, 3 jars of Vaseline, 11 combs, 8 razors, 1 musk powder, 93 pens, 17 pencils, 13 chili packets, 4 garlic pickles, and 6 packets of Country Time lemonade. The disposition was as usual. Collins could have the items sent out at his expense. They could be retained and stored by the facility up to 30 calendar days to be picked up by a person Collins designated, or the contraband would be destroyed. As evident from his misconduct and administrative hearing reports, Collins often antagonized prison officials, making matters worse rather than better. When found with contraband and stolen property, he rationalized it away and absolved himself of responsibility. Consistently, Collins played the victim card, but prison officials were unimpressed. 34. Now I lay me down to sleep. On October 13, 1976, William Martin, Hollywood movie producer, director, and writer, reported to the Ypsilanti Press he had completed a script dealing with the Washtenaw County murders. He insisted his script was an original work, not based on The Michigan Murders, a novelization of the Washtenaw County murders released a year earlier. The movie was slated to be called Now I Lay Me Down to Sleep, after the children's bedtime prayer. Its words offered a grim irony, juxtaposed against the details of these murders. "The filming should start sometime after New Year's," Martin said. Early in 1977, William Martin began shooting. He made a movie previously in southern Michigan called Jacktown, which was coincidentally about an inmate at Jackson State Prison, where Collins was imprisoned at the time of the filming of this new project. Jacktown was an uneasy mixture of grainy documentary footage from the Jackson State Prison riot of April 1952, location shooting in Royal Oak, Michigan, and an uninspired script punctuated with wooden amateur acting. As with Jacktown, Martin hired seasoned actors in the lead roles for Now I Lay Me Down to Sleep, and used local talent to play the girls. Kathy Pierce, an actress from Chelsea, Michigan, was chosen to play the role of one of the victims. Malibu surf legend and television character actor Robert Purvey, with screen credits for popular 1970s television shows like Police Story and Kojak, was cast in the role of John Norman Collins. The Collins character would be renamed Brian Caldwell. Rory Calhoun, best known for his role on the hit TV western The Texan, 1958 to 1960, and host of Death Valley Days, would play a state police post commander and spokesperson. Because of the complicated police involvement of 5 different agencies in these cases, a composite role was created to simplify the storyline. For the role of Sandra Like, Katherine Grayson was chosen. She is best remembered for singing performances in Hollywood musicals like Anchors Away and Kiss Me, Kate. Psychic Peter Hurkos would play himself in the film. Hurkos was not an actor in the strict sense of the word, but he needed the work and the exposure, so he signed on to the project. Rounding out the cast was local WXYZ anchorman Bill Bonds, who interviewed Hurkos at the time of the Beineman murder. He would reprise himself. Bonds had previously appeared in 2 of the Planet of the Apes movies and 5 Easy Pieces when he was working as a newscaster in Los Angeles. Appearing in front of a camera was second nature to the popular Detroit television news anchor. Martin claimed he began writing his script in 1972, when he first learned of the case, and insisted his movie was not connected with the Michigan murders, published in 1976. Martin's movie was to be a mood piece about a community in crisis, rather than a laundry list of factual details. "It's not a police story," Martin told reporters. "The whole county was in terror for 2 years. I'm only doing it from the standpoint of what was running through the minds of the girls, what was happening to the community, and what was happening with the killer at large." Martin stated he was going to portray the crime through the eyes of the defendant. Early in 1977, a film crew of 35 people from New York City descended upon Ypsilanti and Ann Arbor. The budget for the film ranged from early estimates of $1 million to a soaring $2.5 million in production costs. Martin announced the film was scheduled by Paramount Pictures for an Ypsilanti premiere around Christmas time in 1978. Collins was not pleased when he heard the news of the proposed film. In an Ann Arbor News article dated January 14, 1977, Collins complained to reporter William Tremmel that the Michigan murders and the proposed movie Now I Lay Me Down to Sleep were both efforts to exploit his situation for profit. Collins' lawyer tried to get a court injunction to stop production of the movie because it was prejudicial to the appeal process of his client. It was denied. Martin publicly offered to pay for a polygraph test and close down production if Collins could exonerate himself. Neither Collins nor his lawyer took Martin up on the offer. More serious was an Ann Arbor News report from July 30, 1977, about William Martin being approached by a large man with a beard at about 10 a.m. while he was preparing for the day's shoot. The burly man poked his finger in Martin's chest and told him, "You're dead. We'll kill you." After the incident, Martin told of other unspecified threats to him and some of the film's stars. The Ann Arbor News article went on to say, "A truckload of roadblocks led some to believe that this film would never be made." Lead actor Robert Purvey remembers, "There were problems with the screenplay from the beginning. Martin and I spent every night rewriting the script. He had only half a script and asked me to help write the story as we went along. Our days were spent on location, and our evenings were spent in his hotel room feverishly preparing for the next day's shoot. Once the film crew returned to New York, additional studio scenes were supposed to be shot, but post-production costs soared. We were told the studio shut down the project, and the film was shelved. The director of photography, DP, for the Collins movie, who wished to remain anonymous, recalled that William Martin, known simply as Marty by the crew, hired him to assemble a New York film crew for a 4 or 5 week shoot in Ann Arbor, Michigan. The DP says he and his crew drove 2 film trucks to Ann Arbor, only to find Marty had no script, just a sketchy outline and nothing else. He had no cast, no locations, and only partial funding for the project. Martin was confident publicity would attract investors and additional funding, the lifeblood of the movie industry. Martin named local attorney Jay Kaufman as producer. It was his job to raise the money. Somehow, Martin was able to land 2 Hollywood actors in a package deal, Rory Calhoun and Katherine Grayson. Their celebrity would attract investors. The actor's booking agent was thought to owe Marty a favor. They shot footage for almost 5 weeks. On a typical day, there would be no casting and no preset location. Marty rode around in a Cadillac convertible and literally acquired a cast and locations along the way. We were shooting cinema verite style. For example, we went to the Michigan State Police Post in Ypsilanti, and suddenly real state policemen were playing troopers in the movie, and we were shooting scenes in and around the police post. Toward the end of the location shooting, William Martin, a.k.a. Martin Bacow, in response to a federal subpoena, testified in Detroit that he had no knowledge of the murder of Teamster President Jimmy Hoffa, nor did he know where his body might be found. Because of the controversy, word came down that the studio had halted the project. That left the crew high and dry, the DP said. This was the weirdest film shoot any of us had ever been on. We speculated that the film was a scheme to raise money and defraud investors. When the archivist from Paramount Pictures in Hollywood was contacted about Now I Lay Me Down to Sleep, he checked their records and studio film vault. He found no evidence of any film footage rotting in the can or any publicity stills in their files. The studio had no record of any involvement with the film. If William Martin's earlier film Jacktown is any indication, it is better that Now I Lay Me Down to Sleep never saw the light of day. The story of the murders of these young women who never had the opportunity for a full life deserves to be told accurately, not cobbled together like some television mystery movie of the week. A sample viewing of Jacktown will convince anyone William Martin was no filmmaker. Further information on William Marty Martin, a.k.a. Martin Bacow, can now be found in the book The Last Mogul by Dennis McDougal, which states, Martin Bacow, a Hollywood jack of all trades, began his career in Southern California in 1948 as a boxing announcer. He then branched out over the next 4 decades to become an actor, screenwriter, labor negotiator, and a B-movie producer. The Last Mogul also notes that Marty Bacow was a close associate of Teamster President Jackie Presser. Bacow was known as the Teamsters' fix-it man in Hollywood. It was rumored he could start and settle labor disputes in Tinseltown. While Marty Bacow was filming in Ann Arbor and Ypsilanti, the DP remembers Marty was always in the presence of 2 Teamster consultants, William Candy Davidson and Marvin the Steel Broker Mulligan. They acted as Marty's private security force. The movie crew disappeared from the area even faster than it had appeared. People who predicted this film would never be made were correct. Not a single can of footage is known to exist. 35. Manipulating the media. John Norman Collins was 29 years old when he broke 7 years of public silence to give the Ann Arbor news reporter William Bill Tremmel a prison interview. The Ann Arbor News sought a telephone interview to get Collins' comments about a published book on his case and a proposed movie to be filmed in the spring in Ann Arbor and Ypsilanti. Collins requested an in-person prison interview. and said he would permit a photographer to take photos for the exclusive story. The 3-hour interview took place in Jackson State Prison on Thursday, January 13, 1977, and covered a wide range of issues, everything from high school football to capital punishment. Bill Tremmel asked Collins why he waited so long to give an interview. "No one really asked," he replied. Later in the interview, Collins admitted he wanted to meet Tremmel. Bill had covered the Collins case since the Beineman murder, and he wrote the most comprehensive articles of any reporter. Dressed in institutional blue trousers, heavy work shoes, and a long-sleeved gray sweatshirt, Collins was led to a vacant prison office where he met Tremmel and his photographer. The prison officials left the small conference room and shut the door, leaving the men free to talk. During the interview, Tremmel noted Collins was articulate, thoughtful, and pondering. Questions about his conviction brought out a number of Collins' key points. He proclaimed he was innocent of the murder of Karen Sue Beineman with his mantra, "I never knew her, I never saw her, I never gave her a ride." The prosecutors withheld evidence that would have proven him innocent, referring to the Running Man defense theory at the Mannequin stakeout. The jury foreman pressured a guilty verdict from the jury through the rationalization "better safe than sorry," and then hammered on the undecided jurors. Diana Joan Goshi made a false courtroom identification under police pressure and greed for the reward money. The jury was bored with the scientific testimony, which he pronounced scientifically invalid and technically unacceptable. The Michigan Murders, a novelization of his case, is a crass commercial venture that exploits him and jeopardizes his appeal possibilities. Author Edward Keyes analyzed him in a totally incorrect and highly fabricated theory, although Keyes never spoke with him. Collins said the proposed movie, Now I Lay Me Down to Sleep, was even more flagrant than the Keyes novel, because it purported to see through the eyes of the defendant, but no one from the production company came to speak to him about his case. Regarding the key evidence, Collins broadsided the prosecution. "They withheld information. I don't know what it is, but they do. It was a political game. They had to get someone. Mr. Delhey did his job, but he was overzealous. And look at Booker T. Williams. That's the kind of official that was trying me." Collins accused the police of threatening J&J cycle owner Joe Patton with shutting his business down. They pressured him to say I was there at the time, which would fit in with the prosecution's case. Here, Collins failed to cite the 4 different timeframes given by 4 different motorcycle shop employees, not to mention other serious discrepancies in their testimony. Collins showed bitterness when he spoke about Diana Joan Goshi. She was after the reward. She applied for it after the trial. 2 other witnesses saw Beineman ride away with Collins also, but he did not mention either of them. In this interview, Bill Tremmel allowed Collins to speak freely about anything on his mind. The public had waited a long time to hear Collins speak. "I never killed anyone. I had no reason to. I was a senior in college. I was going to get my degree in June. I was engaged to be married. I never even slapped a woman in my life. I look down on anyone who does. I never hold a grudge. I like girls. I dated often. Of course I've got a temper. But it's nothing I can't handle. I'm competitive in sports. I play football and basketball here. I play hard. But when it's over, I don't carry it with me." Regarding the Michigan murders and the proposed movie Now I Lay Me Down to Sleep, Collins said, "These people never talk to me. How do they know how I feel? What is in my mind? How can they analyze me? Edward Keyes told millions of readers that I hate my mother, and that's why I killed. I didn't kill, and I love my mother. She's been strong. She's been with me. How can this movie bunch say they're going to film something through my eyes? They don't know what I see or how I see things. It all comes down to money. To make money off people like myself who are helpless, who have no legal remedy and no way to protect themselves. It's not right, but they are doing it. I was tried and convicted of the Beineman murder. I'm appealing that. But why do the media insist on naming me with other murders? I don't know who did any of them. They say the murders stopped after I was arrested, so that must prove something. I don't think it proves anything. Maybe the person who did the murders died. Maybe he moved away. Maybe he got right. Whoever did something like this has to be sick. There has to be something wrong with him. I believe there is a God. There's some being who got the whole ball rolling. But I don't think you have to go through a priest or minister to have him hear you. I think you can go directly to him. On the 20th anniversary of Karen Sue Beineman's disappearance, 42-year-old Collins was reluctant to be interviewed but consented. By this time, he had exhausted all of his appeals, so there was nothing to lose. But there would be no information drop for Jim Mencarelli of the Ann Arbor News. Rather than take the opportunity to make a full confession of his crimes and show remorse, Collins waved those questions aside and used the platform to complain about his prison life. What good does it do me to talk about it? There is nothing to be gained, said Collins, still professing his innocence. He steadfastly maintained he did not receive a fair trial. I'm still pursuing avenues to reopen my case, although I no longer have an attorney. Collins told Mencarelli he spends his days in front of a small black and white television in a 7 by 12-foot cell. He leaves the cell for 1 hour a day, 5 days a week, for exercise on prison grounds, and 3 times a week for a 5-minute shower. I sit on my narrow metal frame bed in F block and watch TV, read old newspapers, write letters, and daydream. The mind is a beautiful thing. You can be anywhere you want, anytime you want. The fact that you're away from society, that you're locked up, that you're dictated what you can do, when you can do it, and how much you can do, is a punishment in itself. But telling us we can't talk, can't read books, can't speak to our families and kids is slipping beyond belief. Here they want to destroy everything a person has. They won't give you any incentive to do anything. The prison system picks on me because of my name. I'm being punished for who I am. Anytime my name is mentioned, it draws heat. I'm doing hard time because of the sensationalism surrounding my case. Reporter Mencarelli took the opportunity while at Marquette to interview George Pennell, administrative assistant to the warden. Referring to Collins, Pennell said, "He's an average prisoner in that he's not a lot of trouble to us. But overall, he's not an average prisoner because we've never had a prisoner here who's received as much attention or had a book written about him." Collins has a quick temper, but he is not classified as an assaultive prisoner. The problems he has in prison were running a gambling operation, loan sharking, and possessing material considered escape contraband. In 1977, while still at Jackson, Collins was accused of plotting a helicopter escape. He admitted it to the warden and then denied he conspired with another inmate, Robert Taylor of Port Huron, to escape. Collins injured himself in the exercise yard and was in the prison first aid office when Taylor, dressed as a maintenance man, walked out of Jackson and was never heard from again. In 1979, while here at Marquette, Collins was accused of taking part in an attempt to tunnel out of the prison, though the accusation was later dropped. Collins was implicated with 6 other inmates in the escape attempt. There are no prison reports, other than the initial newspaper articles. It is thought Collins' lawyer successfully challenged the allegation, and the charges were dropped. No documentation of the incident exists, nor will Marquette Branch prison officials discuss the issue. But the 5 other prisoners accused of being co-conspirators in the tunneling attempt were all sent to different Michigan prisons. Everyone except Collins. And in the mid-'80s, George Pennell continued, Collins was caught with 2 hacksaw blades and a drill bit hidden in his cell. Only 17 months ago, he was found with a length of parachute cord in his cell and was again returned to administrative segregation, a 22-man cell block reserved for our highest-risk inmates. Collins dismissed each prison escape accusation as the prison system's way of warehousing him in administrative segregation, commonly known as solitary confinement, or the hole. You're locked in your cell 23 hours a day. Thursday and Friday, you don't get out at all. Everything is metal, a metal frame bed, a metal sink and toilet, and a little metal desk for writing letters. You get fed in your cell. They push the food in, you eat it, and you lie down. Mencarelli asked Collins who he wrote to. Collins replied, I exchanged letters with several people through a prison pen pal program, and others who have written me over the years. Collins says he receives regular visits from several women. One woman who visited Collins several times a year in Marquette Prison was Marlene Thompson. She ran a small chapel in Warren, near Collins' hometown of Centerline. Reverend Thompson was ordained in a spiritualist church, Sister Dora's National and International Church of Love. She maintained a prison ministry. Washtenaw County Prosecutor William Delhey was asked to comment for the Ann Arbor News on Collins' 20th year behind bars. Delhey said, When I think back over those times, it brings back a lot of feelings and memories. The case was tried, and it's over with as far as I'm concerned. It's in the past. I believe Collins would kill again if he were freed. I think he is a very dangerous individual, and I would oppose any effort to get him released. As Collins was nearing his third decade in prison, he granted an Oakland Press newspaper reporter an interview on September 28, 1988. The media from the beginning of his case was unsympathetic to Collins and gave him no quarter from the start. The defense team harped on Judge Conlin about the amount of sensationalistic and unfavorable press their client was attracting. They believed their client could not get a fair trial in Washtenaw County. But now, Collins needed the press. They were his only link to the public, so he would take his case to them. All of his appeals for a retrial or a commutation of his sentence were exhausted. Since February 1987, Collins' attempt to transfer to Canada was rescinded. As he was nearing his third decade in prison, he granted an Oakland Press staff reporter an interview on September 28, 1988. John Collins emerged from his isolation cell at Marquette Prison and gave the reporter the same statement he made in his closing remarks at the trial. I never met Karen Sue Beineman, nor did I strangle her. Collins said he never murdered any of the 6 other female students in Ypsilanti and Ann Arbor. The dark cloud of the other murders and the indictment of Collins in California for the murder of Roxy Ann Phillips hung heavily over the Beineman trial. Great pains were taken by the prosecution to prevent any testimony regarding the other alleged victims from being entered into the trial testimony. Neil Fink was quoted in the article as saying, Unspoken evidence linked Collins with the other 6 murders in the area because the Beineman slaying was the last of its kind in the area for many years. Collins disagreed with his former attorney. The public was led to believe that the murders had stopped after the Beineman killing. I don't think there was anything similar about a lot of the murders. Some were shot, some were strangled, some weren't. It's so easy to say, oh, he did it all. Collins complained his 1970 trial was marred by circumstantial evidence, police pressure on witnesses, and massive prejudicial publicity. On the advice of his lawyers, he never testified in his defense, but was making up for it now. The most notable part of the interview was when Collins accused police of scapegoating him into prison. Collins essentially repeated what he told Bill Tremmel years before. I honestly believe the police know who did it, and they squashed it one way or another. Or they got rid of the person. Or they know where he is. Collins said he hoped to get a new trial, to test the hair evidence again, using updated analytical techniques. If they would run them through today, I'd be exonerated. I would have to get a new trial to get the new analysis. Collins did not mention that prison officials asked inmates to volunteer DNA samples for tests that were in use by 1988 and widely accepted as reliable forensic evidence in American courts. Despite other prison inmates being proven innocent by DNA analysis after they were imprisoned, Collins refused testing. In 2002, all Michigan prison inmates were compelled to give a DNA sample. 3 weeks after the Oakland Press interview, John Collins signed a media release to appear on a popular Detroit morning talk show, Kelly and Company. John Kelly and his wife Marilyn Turner interviewed celebrities and local newsmakers in front of a live studio audience in Southfield, Michigan, where WXYZ-TV, Channel 7, was located. The original plan called for a live prison interview, with interactive segments between Collins and a panel of key people associated with his case. It was unprecedented. 41-year-old John Collins was scheduled to appear live via satellite from Marquette Branch Prison on Monday morning, October 3, 1988 at 9 a.m. Kelly and Company producer Chris Sloat said, "Collins agreed to talk with the media because he never has had a chance to give his side of the story." Of course, Collins could have taken the stand in his own defense against the wishes of his then attorneys. Glossing over that point, the producers and the station manager felt they might have an award-winning show on their hands. The original concept for the popular audience participation show was a courtroom-type debate. Collins would appear live with Marilyn Turner from Marquette Branch Prison, while her husband, John Kelly, would be in the Channel 7 studios, with an audience of about 200 people. The master plan was to have Collins tell his story, question the panelists live on the air, and between those segments, have audience members ask questions of the panel. This was a ready-made public relations forum Collins could not afford to pass up. Persons scheduled for the panel were Neil Fink for the defense. His partner Joseph Louisel had died in 1974. William Delhi, the lead prosecutor. Douglas Harvey, former Washtenaw County Sheriff. Eric Smith, WXYZ reporter. Jackie Callan, a reporter who covered the case for the Oakland Press, and Reverend Marlene Thompson, Collins' prison advocate. Plans began to fall apart the Thursday prior to the show, when prosecutor Delhi balked at appearing. He declined to be a part of a second Collins trial for television entertainment. He tried the case once, and that was enough for him. Then the producer of the show got more bad news. "The prison authorities reneged on their cooperation," said an associate producer. "They decided not to let Collins appear live with Marilyn. We managed to convince the warden to let us do a taped interview from prison. Not exactly what we had in mind." A last-minute thought by Channel 7 producers was to have prosecutor Delhi videotape a statement, but he declined. Quoted in an Ann Arbor News article, Delhi said, "In any statement, I would have said exactly what happened and what's been on record for 18 years. The trial was held, the conviction was affirmed by 3 courts, and the case is over. I was not going to be a part of a staged courtroom scene with Collins being given a chance to plead his case and a dozen people off the street shouting out inane questions. I'm a prosecutor, not a question and answer man for show business." Marilyn Turner did the videotaped interview with Collins inside Marquette Prison on the Friday before the Monday broadcast. The first segment gave a news summary of the Collins-Beineman case that was essentially accurate, until the taped footage showed a shot of the wrong house as the murder site, not the home of David and Sandra Like on Roosevelt Street in Ypsilanti, but the house where Collins' alleged second victim, Joan Schell, lived. After a synopsis of the 18-year-old case using vintage video footage, Marilyn Turner did a masterful job of interviewing Collins and making him feel comfortable. If Marilyn's husband, John Kelly, had gone to the prison instead, asking Collins the same questions, the answers would have been the same because they were well rehearsed, but the tone of the interview would have been different. It seemed Collins had a crush on Marilyn Turner. He played on her sympathies, and she let him. Marilyn showed herself to be a real professional. The videotaped interview was interspersed throughout the live show on Monday morning. Kelly and Company's second segment had John Kelly questioning the trial participants, Neil Fink and Sheriff Harvey. Fink contended it was the unspoken evidence of the other area murders that convicted his client, and not the circumstantial evidence presented in court. The former sheriff said he believed Collins was guilty of all 7 murders, and 1 in California. Nothing had changed in their positions after 18 years. The men discussed the mannequin stakeout, which Fink described as the Keystone Cops. That rankled Sheriff Harvey. Harvey recalled the incident and revealed the mannequin was dusted for prints, and none were found. It was reported by a local newspaper that a midnight runner came upon the site and may have stopped and even touched the mannequin. Police on the scene reported this person was a jogger who swept past them so fast they did not have enough time to respond. In another previously recorded clip from Marquette Prison, Marilyn Turner asked Collins about the mannequin incident. The Collins defense team tried their best to use this as proof their client had an alibi for that weekend. Collins said he was in Ortonville 60 miles away, with two former fraternity brothers and their wives. One of the wives testified in court to that. The alibi was based on the notion the midnight jogger was the murderer, and the police botched the stakeout. If police had found the runner, they would have captured the murderer, or so the defense theory went. But that reasoning relied on facts, not in evidence. With no jogger to question, and no reason to suspect he had any interest in the gully where the body was found, there was no basis for a credible alibi. Collins was doing his best to manipulate the audience of the morning show to make his case. After John Kelly explained to the audience that prosecutor William Delhey declined to appear on the program because he wanted to put the case behind him, Part 3 of the show ran along the same lines as Part 2. A question, a brief discussion, and a clip of Collins responding to the same question. This segment was about the county sheriff's alleged offer to buy Collins a steak dinner in exchange for a full confession. In response, the sheriff denied ever making such an offer to Collins while he was detained in the county jail. Somehow, the absurdity of the situation spoke for itself when Collins told Marilyn he almost took the sheriff up on his steak dinner offer. After another segment of the Collins-Turner taped interview was run, Part 4 of Kelly and Company was reserved for the supporters of John Norman Collins on the panel, who gave their assessments of his innocence. Reverend Marlene Thompson ran a small chapel in Warren, Michigan, near Collins' hometown of Centerline. She was given Collins' name by a prison ministry group in Marquette. Thompson said she visited with Collins several times a year for the past 3.5 years. John shows great concern for women. He is a caring and intellectual person who couldn't kill anything. If you really take a good look at the evidence, all of it is circumstantial, Thompson said, ignoring the scientific hair evidence. I firmly believe they, the police, needed a scapegoat so everyone in Michigan could feel more relaxed. There isn't anything in this person that could ever kill anything, she said with conviction. Reverend Thompson spent the rest of her time criticizing the Michigan prison system. Also included on the panel was Jackie Callan, an Oakland Press newswoman who did not cover the case at the time, but who had written Collins while he was in prison over the years. She too thought John may be innocent and railroaded into prison. Callan stated her opinion. If he did it, he doesn't know he did it. He is open and tells the truth as he perceives it. No mention was made of the word delusional or why Collins refused every attempt by prison officials to undergo a psychiatric evaluation and treatment. The most remarkable and probing part of the show was when Marilyn Turner gently asked John Collins in a calm and soothing voice, "Do you love your mother, John?" With that one well-placed personal question, Marilyn penetrated Collins' self-protective wall and caught him in an unguarded moment. Until then, he maintained control of the interview. Then, he lost his composure, and his emotions welled up. Collins was disoriented from that point on. Marilyn Turner did a great job interviewing a difficult subject. Part 5 of the show was a question-and-answer segment with the audience. A question was asked about Collins/Chapman's Canadian transfer attempt and why current Michigan Governor Blanchard would not sign it. There was also a question about the California murder case against Collins that was dropped years before. The Kelly and Company morning show ended with John and Marilyn asking individuals in the audience if they thought Collins was innocent or guilty. Several of Collins' supporters were sprinkled among the audience. Stephanie Smiley, an Eastern Michigan University friend of Collins, was convinced of his innocence. Collins' Theta Chi fraternity brother, James Zellen, also came to his friend's defense. But still, the votes of the audience ran 2-1 against Collins. not the result he hoped for. 36. Room for doubt. After John Collins was found guilty of Karen Sue Beineman's murder, the 6 other unsolved murder cases were relegated to cold case status. But from the start, something was different about Jane Mixer's murder. In 2001, Michigan State Police Detective Sergeant Eric Schrader was placed in charge of cataloging evidence from the other Washtenaw County unsolved murder cases. Schrader never believed Jane Mixer's murder was related to the others. He sent some evidence from her case to the State Police Crime Lab for DNA testing. Because of the backlog in processing DNA samples, Schrader waited a year for results. On November 25, 2004, over 35 years after Jane was murdered, a 62-year-old retired male nurse named Gary Earl Leiterman was charged with her murder. Leiterman left 3 droplets of his perspiration, enough for DNA analysis, on the nylon stocking knotted around Jane Mixer's neck. He was registered in the FBI's National DNA Index System, NDIS, a supercomputer that networks and cross-references databases nationwide using the Combined DNA Index System, CODIS. Letterman's DNA was in the CODIS system from an earlier minor drug conviction in 2001 for forging and passing prescriptions for painkillers like Vicodin and Lorcet. The system came up with a solid hit on Leiterman. Gary Leiterman told authorities he became addicted to painkillers after a painful bout with kidney stones. After a thorough search of his car, investigators found a stack of prescription blanks he had stolen from the Kalamazoo hospital where he worked. Leiterman pleaded guilty and was given probation after agreeing to enter a drug rehab program. As a felon, he was required to give a sample of his DNA under the provisions of a new Michigan state law that went into effect only 3 days before his drug conviction. A disturbing wildcard in the Leiterman case was someone else's DNA found on Jane's body. A single drop of blood on Jane's hand from John Ruelas, a 4-year-old child at the time. How did this cross-contamination get there, and what impact would it have on the trial? Leiterman's defense attorney, Gary Gabry, wanted to exploit this issue as much as he could. This was proof of cross-contamination at the DNA lab. Gabry wanted the judge to remove the DNA evidence from consideration by the jury, thereby expecting a full acquittal of his client. Closing arguments were made on the morning of July 22nd. The jury came back with a guilty verdict by 4:15 p.m., after only 3 hours of deliberation. They found Gary Earl Leiterman guilty of the murder of Jane Mixer. On August 30, 2005, Judge Donald Shelton handed down the mandatory life sentence. Leiterman's family was shocked. The case was appealed, but the verdict stood firm. Immediately, they established a foundation to fight for his release. To date, they have been unsuccessful. What makes this case relevant to the other cases is that Collins was proven innocent by default of a murder the general public believed he committed. The shadow of doubt suddenly loomed larger for Collins. After the 2005 Leiterman conviction, some people were willing to consider the possibility that John Norman Collins may not be responsible for the other murders he was thought by the court of public opinion to have committed. 37. Final thoughts. Since his conviction, John Norman Collins has taken every media opportunity to tell the public the story of his false arrest and unjust imprisonment. Collins alleges he was framed by corrupt law enforcement and railroaded by an overzealous prosecutor. During his murder trial, Collins' attorneys were unable to establish a convincing alibi for their client, nor did they produce any viable evidence to exonerate him. When Collins was given the chance to take the stand in his own defense, his lawyers advised against it, fearing he would lose his composure on the stand. Now, he tells anyone who will listen how he was convicted solely on circumstantial evidence, at the same time ignoring eyewitness testimony placing him with the victim and scientific evidence linking the deceased to the murder site, his aunt and uncle's home. Evidence from the unsolved Washtenaw County murder cases was carefully avoided during courtroom testimony to prevent a mistrial that neither side wanted. But evidence exists linking Collins with the other murdered girls. For instance, when Collins' room was thoroughly searched after his arrest, investigators found a Canadian Expo 67 medallion necklace on top of his dresser that was like the one found missing from Mary Fletcher's belongings 2 years before. When questioned about it, Collins claimed he never saw the necklace and maintained it was planted by the police to frame him. Acting on a tip 2 weeks after Joan Schell's body was found, police investigators interviewed 2 Eastern Michigan University students alleged to have seen John Collins and Joan Schell together the night she disappeared. The couple was on a double date with a Marine Corps friend to pick up his date, who was waitressing at Casa Nova on Michigan Avenue. She called at 11:30 p.m., ready to be picked up. This was the Marine's last evening before leaving for Camp Pendleton in California and shipping out to Vietnam. Eastern Michigan University student Edward Lee Knickerbocker told investigators he did not come forward with information earlier because he did not want to get his former Theta Chi fraternity brother in trouble, especially since he claimed he was not positive it was John Collins with the girl he saw crossing the intersection of Emmett and College Place. Knickerbocker falsely estimated the time to be 9:30 p.m. His girlfriend, Doreen Gagnon, was interviewed separately. She put the time at just after 11:30 p.m., when her waitress friend called to be picked up from work. But who was correct? The police were left with conflicting reports, but discounted the young man's error as a simple mistake. Knickerbocker said he asked Collins about seeing him with the missing co-ed, but Collins denied he knew the girl. The Marine Corps witness was on active duty by that time and not available for a police interview. The same couple was interviewed again a year later, after Collins was arrested for the Beineman murder. By this time, Collins was believed to have murdered no fewer than 7 young women in Washtenaw County. Doreen Gagnon, who was more truthful than her ex-boyfriend the previous year, said she talked with Knickerbocker 2 days after Joan Schell's body was found. Knickerbocker told her he did not want to get his fraternity brother in trouble because he knew Collins was stealing motorcycles. On the night in question, Doreen said she recognized Joan Schell and waved to her as she and John Collins crossed the street. She was positive about this. Knickerbocker had since graduated from Eastern and was now a commissioned Army officer at Fort Knox, Kentucky. He was re-interviewed by a different investigator after Collins' arrest. This time, Knickerbocker made a positive identification of Collins and placed him and Schell together at the intersection of Emmett and College Place shortly after 11:30 p.m. Knickerbocker added when he asked Collins about that evening, John claimed to be at his mother's home in Centerline that weekend. Then Collins gave his former fraternity brother a cold, withering glare, enough to whip Knickerbocker into line. After the couple was re-interviewed, the Marine was questioned for the first time on November 10, 1969. He had not seen or spoken with the couple since the night Schell went missing. His story matched the couple's, including the time frame. The Marine remembered driving his car and stopping to allow 2 people to cross the street. As they crossed in front of his headlights, the couple inside the car waved at them, and they waved back. The Marine remembered the woman had long brown hair, but did not notice anything in particular about the guy who was with her. A female student who worked with Collins in the Alumni Relations Office during the Joan Schell incident remembers John Collins talking incessantly about how mutilated Schell's body was. Collins went into graphic detail describing the corpse, and he enjoyed tormenting her until she complained to her supervisor, who called the Eastern Michigan campus police. When Collins was questioned, he claimed he got his inside information from his uncle, a well-known Michigan State Police trooper, who worked at the Ypsilanti post on Michigan Avenue. When John's uncle, Corporal Daniel Like, was asked to corroborate his nephew's statement, Like said he had not discussed the case with him, and that the state police were not a part of the Schell murder investigation. The detectives could not help but notice Collins' bogus attempt to establish a reason for his detailed knowledge of Joan Schell's injuries. Perhaps out of professional courtesy for a fellow cop, this thread was never followed up. John was caught in an obvious falsehood. Corporal Like asked his wife Sandra to call her nephew and ask if he knew the murdered girl. John flatly denied he knew anything about her. One lie compounded another. For the first time, John found himself on the slippery slope of willful deceit. But nothing came of it. Collins' caution might explain why it was 8 months before the next slaying. On August 31, 1970, 13 months after Collins was jailed, Isabel Wilson took her children for a Sunday outing along the north side of the Huron River. They were fishing west of the dam and bridge crossing at Superior Road. It was late afternoon when she looked into the water and saw a wallet lying in the mud. She reached in and picked it up. The wallet was still snapped shut. Wilson checked the interior and found a card which read, "In case of emergency, call Mike Millage," with his phone number written down. When Wilson and her children returned home, she called the number. The person on the other end of the line became very excited. Mike Millage took down the woman's contact information and immediately called Sergeant Canada of the Ann Arbor Police. Canada hurried to the Wilson apartment on Huron River Drive. Wilson gave the detective a full account of where she discovered the wallet. He looked inside and found Marilyn Skelton's Social Security card and numerous photographs. Wilson went on to explain that she and her husband had arrived in this country in February 1970 from Glasgow, Scotland, so neither of them had knowledge of the local murders. A search was made along the shoreline of the Huron River where the wallet was found. Because the water was shallow and visibility was poor, divers were not called in. Police put on waders and checked the water carefully. Sergeant Janishevsky of the State Police located the purse in about 3 feet of water, 20 feet from shore. When the officer tried to pick the purse up, it broke apart from being in the water under 5 feet of mud for almost 18 months. The murderer had weighed it down with rocks before throwing it into the water. Michael Millage was contacted to confirm this was indeed Marilyn's purse. It contained one change purse, a ballpoint pen, a comb, a nail clipper, one chapstick, one pink hairbrush, a pair of sunglasses, hand cream, 2 lipsticks, 2 keys, and 2 erasers. The wallet contained numerous photos and Marilyn's identification. Microscopic examination for latent fingerprints was conducted, but nothing of evidentiary value was found, except that Marilyn's murderer passed by the Huron River after he killed her. Karen Naylor was a part-time Washtenaw Community College student and a full-time employee at the old St. Joseph's Hospital in Ann Arbor. One day, she was riding her Yamaha motorcycle when a handsome college guy pulled up alongside her on a flashy Triumph. The rider asked if she would go riding with him, rather than asking if he could go riding with her. His bold self-confidence attracted her, as did his muscular physique, so she agreed. She dated Collins from March through July of 1969, except for a few weeks in June when he was in California. In a recent interview, Naylor revealed previously unknown information to the public. On the night of Dawn Basim's disappearance, Naylor said Collins showed up at her doorstep with blood on his t-shirt. Collins told her he accidentally ran over a dog with his car and got blood on himself when moving the carcass. Naylor said he appeared quite upset. When she heard about the murder of the girl who lived across the street from her apartment complex, she began to suspect Collins. But like almost everyone, she found it difficult to imagine he could do such a thing. After all, he did not fit the police profile. When asked if she contacted the police with her suspicions, Naylor said, "Yes, but not until Beineman went missing. You see, I was a tall, lanky blonde in a college town. Guys were always trying to pick me up. It sounds immodest to say, but it's true. I thought it was unusual that John never tried to have sex with me. That seemed odd, but I didn't trust my suspicions. We always had fun riding together in the backcountry." When police questioned her, she told them she had suspected Collins since April and gave them the details. Investigators took down the information and said they would get back with her. Police were true to their word. Karen Naylor was called to testify for the prosecution against Collins in the Beineman trial, but the Basom evidence was not part of that case. Naylor revealed in a recent interview that defense attorneys Louisel and Fink were so worried by what she might say on the stand that they sent their legal aide, Margot Doble, to carry a marriage proposal from Collins in an attempt to prevent her from testifying. Another link ties Collins to Dawn Basom. One of Dawn Basom's cousins, Sherry Hall Zismont Benoit, claims her grandmother told her Collins was at her Aunt Cleo's house for the funeral buffet after Dawn's burial. Dawn's grandmother did not recognize the person, so she asked him if he was one of Dawn's friends. He said yes. It was not until Collins' photograph ran in the local papers 3 months later that she was able to identify him. Normally, my grandmother took photos of everything, Benoit said, but my Aunt Cleo, Dawn's mother, would not allow any picture taking at the buffet. It seems probable that law enforcement would have positioned investigators outside the Basom house taking photographs of anyone coming or going. When the Michigan State Police were asked if they had any such photographic evidence, the officer in charge of the case would not comment, because this cold case was officially open. There is no statute of limitations for murder. Lieutenant Bunchett explained, "When the evidence chain of custody is broken, it becomes inadmissible in court. Evidence must be preserved in the event these cases are ever brought to trial. It is certain the Michigan State Police have details about these cases locked up in their evidence vault that may never be revealed to the public." In the final analysis, John Norman Collins was indicted by a California grand jury for the murder of Roxy Ann Phillips, and his Michigan conviction for the murder of Karen Sue Beineman brings a tremendous amount of coincidence to bear upon one individual. The fact that mutilated bodies stopped turning up after Collins' arrest added to the widespread belief that the state of Michigan convicted the right man. The secret why Collins derailed is locked in his mind. The combination of factors necessary to unleash Collins' rampages may never be known in the absence of psychiatric documentation or a verifiable family history. Since his arrest, and through all the decades he has been behind bars, John Norman Collins has never willingly submitted to a single psychological evaluation. It is clear from reading the newspaper clippings of her son's murder trial that until the time of her death, Loretta Marjorie Collins was John's fiercest defender. Loretta was guilty in the first degree of a mother's blind love for her son. In her last will and testament, written in 1979, Loretta left her Marine City clothing store and her Cadillac to her daughter. She left her Buick Skylark to her grandson, Dwayne. Loretta's oldest son, Jerry, was placed in charge of dispensing his mother's jewelry among the women in the family. The rest of Loretta Collins' estate was divided between Jerry and Gail. As for her youngest son, Loretta wrote, "I am not unmindful of my son John Norman Chapman, formerly known as John Norman Collins, but I have intentionally omitted him from my last will and testament for my own personal reasons." Collins exhausted every legal remedy to obtain an early release from his life sentence. Only a pardon from a sitting Michigan governor can release him. Rather than acknowledge his crimes and show remorse, like most imprisoned serial killers do, Collins denies knowledge of the victims and shows no empathy for the suffering of their families. He lives out his remaining days in Marquette Prison, awaiting death's cold embrace and his final reward. This concludes Terror in Ypsilanti by Gregory A. Fournier. Narrated by Chris Andrew Shula. Copyright 2016 by Gregory A. Fournier. This unabridged audiobook is published by arrangement with Gregory A. Fournier and was produced in the year 2017 by Tantor Media Incorporated, a division of Recorded Books, which holds the copyright thereto. Please visit Tantor.com for more information on our growing library of unabridged audiobooks and to take advantage of special offers.
Audible hopes you have enjoyed this program.